Natalia Loukacheva. Legal and political autonomy of Greenland and Nunavut. Contents. 3. 1. The Inuit of Greenland and Nunavut, from subjugation to self-government. 17. 2. The constitutional dimensions of the governance of Nunavut and Greenland. 33. 3. Territorial government versus home rule, the structure of Nunavut's and Greenland's institutions. 53. 4. The jurisdiction of Greenland and Nunavut. 73. 5. Greenland and Nunavut in international affairs. 103. Conclusion. 145. Nunavut, which was carved out of the Northwest Territories of Canada in 1999, and Greenland, which obtained home rule status within Denmark in 1979, are in the process of attaining more autonomy. Nunavut within the framework of the territorial governance system in Canada's Eastern Arctic, and Greenland by anticipated extension of self-government within the Danish realm. This process of increasing autonomy is a result of a combination of factors. These include not only the development of Inuit political consciousness in both jurisdictions and consequent demands for self-determination, but also political compromises surrounding the accommodation of the Nunavut Inuit within a multi-ethnic Canadian polity, nation-building developments in Greenland, and the gradual devolution of powers from both Denmark and Canada. I argue that, with the evolution of Greenlandic and Nunavut governance systems, these Arctic jurisdictions are displaying a new form of autonomy that is not addressed adequately by international or comparative constitutional law. Further, there is no legal definition for this form of autonomy, and it can best be understood if we look at de facto developments that gradually shape the juridical scope and content of this autonomy. Much scholarly writing on the issue of autonomy and indigenous self-governance demonstrates confusion with regard to legal concepts of autonomy. These concepts can be rendered clearer by a comparative constitutional analysis of measures that secure autonomy in Arctic areas where indigenous Inuit peoples are the majority. In Canada's Eastern Arctic and Greenland, the Inuit have been the majority population for centuries. As a result of gradual constitutional developments, there received promises from both the Canadian and Danish governments that encouraged them to assume more responsibility for their lands in order to regain control of their lives. This book evaluates how the Inuit vision of self-governance relates to the public governance systems of Greenland and Nunavut, which are based on non-indigenous institutions and norms, and how much autonomy there can be for territories that remain subordinate units of larger states. In this study, I present a comparative empirical and normative survey of territorial governance in Nunavut and the home rule system in Greenland. I explore different legal arrangements for Nunavut and Greenland that secure a measure of legal and political autonomy for their indigenous peoples, and analyze the rapidly evolving governance systems of these Arctic jurisdictions. By addressing the question of whether there is an emerging right to indigenous autonomy, I hope to reveal the ambiguity surrounding the right to autonomy under international law. I argue that, although this right is housed in the concept of self-determination, its content and scope may vary from jurisdiction to jurisdiction and should be understood in the context of each particular situation. An empirical analysis of Greenland's and Nunavut's governance systems shows that autonomy is not a static phenomenon. It is a dynamic concept, constantly developing and evolving towards greater recognition at the de jure level. The ways in which the right to autonomy is exercised in the two jurisdictions have been heavily influenced by the interaction between Inuit forms of social organization and the opposing legal and political regimes introduced by colonial and contemporary authorities. The dramatic differences in outlook and way of life between Inuit and non-Inuit populations require approaches to the development of autonomy in the Arctic that take into account indigenous values and knowledge. By means of a bottom-up approach including contextual, jurisprudential, textualist, and historical legal comparisons of Greenland and Nunavut, this book will examine the forms and evolution of the right to autonomy among the Inuit. Governmental authorities should pay due respect to indigenous peoples' expectations for expanding their legal capability to exercise jurisdiction in areas traditionally non-transferable to subnational regions. Accordingly, the right to autonomy should encompass or protect Inuit jurisdiction in legal systems and the administration of justice. It should allow the Inuit direct participation in international affairs where their homelands are concerned and in security issues relevant to the development of their lands. 5. The subject of this study, the governance concepts of Greenland and Nunavut, was inspired by the unique legal position of the Inuit in these regions and by the remarkable changes that have taken place in recent decades in these northern lands. This study examines the extent to which, within the framework of territorial public governance and home rule structures, the Inuit have been able to secure their interests and needs without de jure indigenous self-governance. At the same time, these subnational Arctic regions are constitutional hybrids with some jurisdiction comparable to provinces in Canada. Regardless of the profound differences between Canada as a federal state and Denmark as a unitary state, the two countries have strikingly similar policies towards, and relationships with, the Inuit peoples. In both jurisdictions the Inuit peoples, notwithstanding their geographical remoteness, are one people, one with similar roots, needs, and aspirations for greater political autonomy. There have been considerable efforts in recent years to promote different autonomous arrangements for indigenous peoples of the North. However, it is not clear within legal and political science scholarship whether the right to indigenous autonomy exists in international or domestic law, and, if so, how it can help indigenous peoples to preserve their livelihood, traditional culture, and values. By illuminating the legal position of the indigenous Inuit of Greenland and Nunavut, I will consider to what extent constitutional arrangements can be infused with indigenous values and perspectives, allowing these arrangements to attain greater legitimacy among those governed by their terms. The scope of this book is dictated by the geographical dispersion of the Inuit people and by their stage of development towards self-governance. I have chosen to examine the Inuit in Greenland and the Canadian Eastern Arctic because of the former's advanced state with respect to self-governance and the achievements of the latter in that direction. Despite the focus on these two regions, there are lessons to be learned from the experience of the Inuit of Chukotka, Alaska, and of other Canadian regions outside of Nunavut, as well as from other indigenous peoples of the Arctic. It should be noted, too, that the legal status of the Inuit of Labrador, northern Quebec, and the western Arctic remains a subject for further research. A few qualifications are in order. In this book the term Nunavummiut includes all citizens of Nunavut, Inuit and non-Inuit. Those Inuit who are the beneficiaries of the Nunavut Land Claims Agreement have their rights and obligations protected, and currently there. 6. Is little confusion over who to consider a beneficiary. In the National Registry in Greenland, the population is divided for statistical purposes into those born in Greenland and those born outside Greenland. Children who were born in Greenland but whose parents are not Greenlandic born fit into the category born in Greenland, whereas offspring of Greenlanders who, for example, had their children while studying in Denmark would be registered as born outside Greenland when the parents move back to Greenland too. Although the term Greenlanders can be applied to all residents of Greenland, including all linguistic groups among the Inuit population, Danes, and representatives of other nationalities who were born and live in Greenland. In this study, the term Greenlanders often refers to indigenous residents who identify themselves as Greenlanders and represent Greenland as a nation of Greenlanders. Autonomy is a vague concept subject to multiple interpretations by different scholars and different groups, both Inuit and non-Inuit. For the purposes of this study, I define autonomy as being equivalent to self-government in the context of an internal right to self-determination. I do not explore the right to external self-determination, including secession, as an attribute of autonomy. Further, this study uses the concept of autonomy in constitutional legal terms, rather than in the context of local self-administration or municipal levels of government. 3. This narrows the scope of this book to autonomous entities in the Arctic with constitutional powers transferred from unitary or federal state authorities to the institutions of territorial or regional public governance. The book does not explore in detail issues of economic sustainability, political economy, fiscal autonomy, intergovernmental relations, language, or social policies in Greenland or Nunavut. Rather, it looks at the legal scope of political autonomy in the Arctic, with the main emphasis being on the areas of non-transferable jurisdiction of Greenlandic and Nunavut authorities, namely, the administration of justice, international affairs, defense, and security. In light of probable changes in the status of Greenlandic home rule, these non-transferable areas arguably raise the most challenging theoretical and practical questions surrounding frameworks of political autonomy and governance in the Arctic. In 1999, the Home Rule Government of Greenland set up a Commission on Self-Governance. The Commission delivered its report in 2003 with recommendations for a draft partnership agreement between Greenland and Denmark with regard to Greenland's right to self-governance. 4. The Commission's recommendations call for expansion of 7. Greenland's autonomy in a number of areas. Following negotiations between Danish and Greenlandic authorities, in 2004 a Danish Greenlandic Parliamentary Self-Governance Commission was appointed with equal representation from Denmark and Greenland. The Commission's mandate is with reference to Greenland's constitutional position and in conformity with the Greenlandic people's right of self-determination in accordance to international law, consider and suggest ways by which the Greenlandic authorities can assume further control where this is constitutionally possible. 5. The Commission aims to develop a plan for increased Greenlandic self-government within Denmark. Greenlanders hope that a partnership agreement will establish Greenland and Denmark as equal partners within the kingdom. 6. However, the mandate of the Commission also notes that, according to the agreement between the Danish and Greenlandic governments, the people of Greenland shall decide whether they want independence. 7. Ongoing Danish-Greenlandic negotiations and anticipated changes in the constitutional status of Greenland by 2008, along with the possible introduction by the Danish and Greenland parliaments of the Partnership Agreement on Self-Governance and Greenland's probable focus on independence, have limited the present research to legislation and materials available up to February 2007. Despite existing limitations, I consider the Home Rule Act of 1978 as an important legal basis for understanding Greenland's present constitutional place within the Kingdom of Denmark. This book covers areas of international law, comparative constitutional law, Aboriginal law, legal anthropology, history, political science, and international relations, and contributes to the literature on legal theory by deepening the understanding of the right to autonomy. It aims to fill the gap in current scholarship on the concepts of governance and autonomy in the Arctic. In terms of methodology, this study represents one of the first efforts to compare Inuit people's quest for self-governance in two jurisdictions. With regard to institutions, this study offers consideration of the concept of governance in the Arctic and information on current problems, prospects, mechanisms of dispute resolution, and structures of governance. Thus, it may be useful for indigenous groups of the North who are bringing forward self-government arrangements. In Chapter 1, The Inuit of Greenland and Nunavut, From Subjugation to Self-Government, I compare Greenland and Nunavut in terms of the historical, political, social, economic, and legal conditions that have affected these Arctic jurisdictions in their transition to modern. 8. Governance structures. I argue that the Inuit quest for political autonomy in these two jurisdictions has similar origins. I will show that there are also striking similarities in the political, legal, cultural, economic, and social development of Inuit governance and in the policies of Denmark and Canada towards the Inuit. In Chapter 2, The Constitutional Dimensions of the Governance of Nunavut and Greenland, I examine the constitutional significance of Greenland's and Nunavut's governance arrangements. This analysis shows that, although the Greenland Home Rule Act, the Nunavut Act, and the NLCA do not explicitly envisage Inuit self-government, and some features of colonial legacy are retained in these documents, self-government is not a legal fiction in either jurisdiction. Home rule in Greenland has evolved to meet the Inuits' needs at a functional rather than juridical level. In Nunavut, the combination of decision-making powers and institutions created under the system of public governance provides valuable instruments for Inuit self-governance. Chapter 3, Territorial Government versus Home Rule, The Structure of Nunavut's and Greenland's Institutions, provides an overview on the effectiveness of Inuit self-governance through the lens of Inuit participation in Greenland and Nunavut politics, political systems, and institutions of governance. It shows how the Inuit in both jurisdictions are being challenged by the transition and adjustment to the non-Inuit values of other societies and how they risk being overwhelmed by Western concepts of governance. The study then turns to an examination of legal autonomy in the Arctic and explores the jurisdiction of Greenland and Nunavut in non-transferable areas as an important indicator of the evolution of the concept of autonomy for northern lands. Chapters 4 and 5, which examine the jurisdictional authorities of Greenland and Nunavut, draw on the aspirations of Inuit authorities to take over responsibilities in the non-transferable areas of judicial/legal systems and international relations, including defense/security, as a means of promoting their autonomy. Potential sources of legal authority for these areas are examined. Chapter 4, The Jurisdiction of Greenland and Nunavut, explores the possibility of Inuit legal institutions and judicial powers within the scope of the Home Rule and public governance arrangements. I argue that there is no formal legal obstacle to the creation of a more or less independent justice system in Greenland and an Inuit judiciary within Nunavut. However, social, political, economic, and technical difficulties do not favor these developments. Chapter 5, Greenland and Nunavut in International Affairs, first assesses the legity. 9. Macy, Perspectives and Outcomes of International Affairs involving Greenland and Nunavut. It also examines Inuit forms of international cooperation. This chapter further considers the transferability of security jurisdiction to Greenland and Nunavut in the framework of the both regions' legitimate interests. It addresses the question of whether citizens of subnational entities like Greenland and Nunavut should have some legal capacity on questions of defense or homeland security policies that concern or affect their lands. Although this book examines the general framework of constitutional and political autonomy in Arctic regions where indigenous peoples are the majority, I do not mean to suggest that internal self-government is a panacea or the ideal solution for realizing their right to self-determination. Instead, I argue that existing forms of public governance may be effective in meeting indigenous peoples' needs without the enactment of special forms of indigenous autonomy. The Arctic Promise means that there might be room for a unique vision of governance in the North inclusive of Southern modes of governance, indigenous knowledge and values, and flexible legal imagination on the scope of autonomy. This book leaves open the question of whether autonomy is a temporary stage on the road to independence or an artificial construct that can coexist in the framework of financial dependence and neocolonial paternalism of national states. Despite the political significance of existing constitutional arrangements to the Inuit of Greenland and Nunavut, I do not suggest that their models of governance are applicable to all Arctic areas where indigenous peoples are the majority. I argue that forms of autonomy in the North vary and should be understood in the context of each particular situation. Finally, it should be noted that I do not speak for the Inuit of Greenland or Nunavut. The views presented in this study solely reflect my understanding of the issues of governance in the Arctic from an outsider's perspective. Why the Inuit of Greenland and Nunavut? Resemblances are the shadows of differences. Different people see different similarities and similar differences. Vladimir Nabokov. Although there are differences in the legal status of Greenland and Nunavut, geographical, demographic, cultural, political, economic, and 10. Historical similarities predominate and make these jurisdictions good candidates for comparison. An analysis of these commonalities is required for our understanding of the roots of Nunavut's and Greenland's governance arrangements. Greenland is the largest island in the world, encompassing an area of 2,166,086 million square kilometers, of which 410,449 square kilometers are ice-free. 8 Nunavut, covering more than 2.1 million square kilometers, is the largest territorial unit in the Canadian Federation. Both entities belong geographically to the North American continent. Both Greenland and a major part of Nunavut are isolated from the mainland, have a similar Arctic climate, and lie above the treeline, with the exception of Greenland's southwest forest, where the ice cap is absent. In terms of demographics, both entities are sparsely populated. Nunavut has 1 city and 24 hamlets, while Greenland, until an expected merger in 2009, has 18 municipalities. 9 Inuit are a clear majority of the population in both. Of Greenland's 56,969 inhabitants, about 88% are natives. Similarly, approximately 85% of Nunavut's 2006 population of 30,245 is Inuit. 10 Culturally, the Inuit of Nunavut and Greenland have shared a nomadic lifestyle, a common mode of hunting, fishing, and gathering, and similar methods of making snow houses, clothing, and drums. They share similar traditional values and belong to the same language group, though speak different dialects. Historically, the Inuit in both countries were confronted with some similar methods of colonization, from relocation to assimilation, although neither group was subject to a reservation system. With regard to politics, many Inuit of both entities consider themselves as one people. They have gone through similar experiences of political awakening and self-identification in their struggle for self-determination and self-governance. They share the same political goals and promote international collaboration with Inuit of the Russian Federation, the United States, and other regions of Canada. Both Greenland and Nunavut face transition from traditional to modern sustainable societies, resulting in the same type of social, health, and education problems that challenge the stability of their governments. Economically speaking, both entities aspire to sustainability, self-reliance, and self-accountability, but in the meantime they accept substantial financial support from Denmark and Canada. 11 In legal terms, public governance based on the territorial principle functions in both territories and applies to both native and non-native. 11. Residence. Finally, the strategic location of Greenland and Nunavut in the Arctic requires special legal guarantees for their demilitarization and encourages Arctic cooperation. 12 Although there are striking similarities between Greenland and Nunavut, there are some notable differences. The Nunavut Act ensured the creation of the new territory of Nunavut in 1999 as a result of the division of the Northwest Territories of Canada. In 1993 the Inuit also negotiated the Nunavut Land Claims Agreement. Nunavut's present boundaries do not cover all of the traditional territory of the Inuit-used lands in the Canadian North, and the Inuit of Nunatsiavut and Nunavik as well as the Iñuvialuit of the Western Arctic live beyond its borders. Greenland was a part of Denmark, which at the time of introduction of Greenland's home rule placed little emphasis on the interests of the Inuit as an indigenous people. 13 In contrast, Nunavut is an example of distinctiveness in the multicultural and multinational Canadian Federation. There also exists a difference between Canadian and Danish approaches to the concepts of indigenous rights, which have affected the establishment of Greenland Home Rule and the territory of Nunavut. The creation of Nunavut was negotiated as an integral part of the Nunavut Land Claims Settlement, whereas the Home Rule system is not rooted in indigenous use or occupation of the land. Generally, Danish policies of colonization regarding the Inuit of Greenland were somewhat less intrusive than those imposed on the Canadian Inuit. The former underwent more gradual stages of colonization and did not experience residential schools or the controversial practice of the numbered identification disc system, a tracking system used by the NWT authorities from 1941 until the early 1970s to facilitate the maintenance of government and administrative records on the Inuit. The preservation of the Greenlandic language, the establishment in the 1850s of a printing house, and the development of Greenlandic literature played key roles in the development of Greenlandic national identity. 14 Finally, while Greenlanders created a unified nation with a political system based on a number of political parties, Nunavut's system of governance is nonpartisan. Political goals are achieved by the active role of Inuit organizations. These distinctions may partially explain the differences in the Inuit people's relationships with the Danish and Canadian states. They also help to elucidate the divergence in the stages of colonization, dakolony. 12. Zashin, and modern approaches to governance in Greenland and Nunavut. Approach of this study. The notion of autonomy in legal and political science theory is subject to much confusion. At the same time, there is an evolving understanding of the right to autonomy in law. Depending on the methodological grounds, there are several ways to approach the legal concept of autonomy. 15. To date, the right to autonomy has a stronger basis for its legal justification in the sphere of the right of indigenous peoples to autonomy. I hope to reduce the ambiguity surrounding the right to autonomy in areas where indigenous peoples are the majority by exploring empirically and through some elements of normative analysis how the right to autonomy is emerging and how its legal scope is evolving in Greenland and Nunavut. In so doing, I follow a non-traditional way of studying the concept of autonomy. I focus on a bottom-up approach, revealing how empirical or de facto comprehension of the right to autonomy is evolving towards greater recognition on a de jure level and thereby advancing our legal understanding of autonomy. This method is blended into the methodology of interdisciplinary research and employs a variety of investigatory approaches for analyzing a number of theoretical and practical questions. Each chapter addresses a distinct topic, but my methods of research remain consistent. These include cultural immersion and comparative legal and historical analyses with the main emphasis on contextual, textualist, and jurisprudential interpretation. Despite profound differences between the historical, political, and legal backgrounds of Canada and Denmark, the policies pursued by these states towards the Inuit people, and their consequences for the Inuits' present legal status and political development, have been similar. Both countries applied comparable methods of colonization, including the banning of traditional Inuit practices like shamanism and dances, the imposition of the colonizers' religions, the use of similar policies of assimilation, relocation, and integration of the Inuit with the larger, dominant societies, the devaluation of unique Inuit culture and needs, and the stalling of the Inuit people's quest for self-determination and greater political autonomy. How could the experiences of Inuit people in such different countries and legal contexts have been so similar? What is the basis for a legal comparison within these different legal systems? Denmark is a member. 13. Of the continental legal family. Nordic law, to which Denmark subscribes, is considered to constitute its own legal family, though it is also often seen as a part of the continental Roman-German legal family. 16. However, some Nordic scholars view the Danish legal system as being closer to common law, since the judges do not view themselves so strongly, only as mere executors of codified legal rules. 17. The Canadian system of law strives to find a balance between a common law and civil law tradition. One must also factor in the influence of European, international, and common law practices in both countries, and the increasing importance of supranational law presenting challenges to the comparison of different legal systems. Alongside all of these influences, Inuit customary law and perceptions have to be considered. This process raises many questions. How does indigenous peoples' law fit into the process of legal transformation? Legal transformations in other countries involved a significant level of institutional emulation and adaptation. 18. This was not the case with respect to indigenous peoples' ideas or legal systems, which the colonizers did not consider valuable and which have had little impact on mainstream legal developments in Canada or Denmark. 19. Against this history, how do we define the line between the legal paradigms of the modern Canadian or Danish state and non-legal traditional Inuit customary practices? To what extent does the traditional culture of the Inuit possess normative significance? Governance in the Arctic is regulated by many factors, including law. What is the law's role in the management of northern governments, and are there any efforts to recognize elements of Inuit legal systems in contemporary constitutional arrangements? These are difficult questions that cannot be adequately addressed only through existing approaches to Aboriginal law and politics. Full answers require a comparative approach, but such a methodology brings with it a unique set of challenges. A basic difficulty lies in the vagueness of the comparative method generally and its application to this particular type of legal scholarship. Unfortunately, an analysis of the literature on comparative law methodology does not yield a clear method of legal comparison. Many scholars argue about how and why comparison should be done but do not provide a clear definition of a proper method of legal comparison. 20. In conducting this research and recognizing the multiplicity of approaches to comparative law, I have incorporated Vivian G. Curran's suggestions on cultural immersion comparison. 21. Thus, in order to COL. 14. Collect information firsthand and generate original research, I conducted field studies in Iqaluit and Nuuk in the fall of 2002. Interviews in the form of open conversation were conducted with selected Inuit leaders, activists, governmental officials, lawyers, and northern residents who were willing to express their views on governance and political issues regarding their communities and to explain their expectations and concerns about the process of autonomy building. All participants in the study were asked a similar set of open-ended questions formulated in accordance with their competence or expertise, which allowed them to freely express their own views on the issues. Anonymity and confidentiality of the information were guaranteed, as requested. The comparative method applied in this book consists of three related approaches: contextualist, textualist, and jurisprudential. A contextualist approach, which focuses on law in action, 22 situates the analysis of the Inuits' legal status in the two countries within the context of social changes. It regards the legal situation of the Inuit in both countries as strongly affected by the surrounding society. Moreover, specific geographic, economic, political, and cultural factors related to the Inuits' way of life in the Arctic influence legislation in a number of ways. In many cases, existing conditions require special regulations, applicable only to northern or cultural Inuit settings. A textualist approach, which targets law in books, 23 focuses on the interpretation of texts and statutes. In this instance it examines the concept of autonomy and its relevance to the Inuit people's rights in the juridical literature and legislation of the two countries as well as in international documents. A jurisprudential approach, focusing on law in minds, or a style of conscious thought, 24 includes an understanding and comparison of ideas of legislators and indigenous activists about the essence of autonomy for the Inuit people. I adapt several comparative approaches not just to find reasons for differences and similarities among the Inuit of the two countries, but to attempt to provide a comprehensive assessment of the quest for autonomy by the Inuit. This macro-comparative study is possible because of the striking similarities between national policies towards the Inuit in the two countries. Despite the value in the approaches I have outlined above, the application of non-native methods of study to the interpretation of Inuit views on self-governance has its limits. It is difficult to realize indigenous government within the existing institutional and legal structures of the 15 Canadian and Danish states. Because they are alien to the Inuit culture, it is also difficult to apply common methods of legal study to the legal systems in question, which are imposed upon the Inuit by the dominant states. Using the experiences of the Inuit in Greenland and Nunavut, I will show that certain legal definitions and concepts, for example, human rights and mainstream domestic law, are unknown and confusing to some Inuit. How does one incorporate existing methods or principles of the dominant society to Inuit governance? The challenge is how to apply non-native approaches to research on Inuit perceptions on governance when, on the one hand, despite the evolution of the modern Inuit language, it still has no precise definition of the notion of autonomy and there is no unanimity among the Inuit regarding what this notion means. There is also no authentic translation for this notion in legal terms. On the other hand, there is no precise definition or understanding of the concept of autonomy or self-governance in the legal doctrines of Canada or Denmark. Another limitation for this study results from the lack of complex comparative legal studies on issues of Inuit governance. There are some notable comparative studies on Aboriginal self-government in general and on the rights of Arctic indigenous peoples, 25, but they are not specific enough to enhance our understanding of the legal situation of the Inuit of Greenland and Nunavut. The scope of existing legal research on Inuit issues is limited, as it usually consists of a single country or case study of Inuit communities. Also, with some exceptions, this project is mostly restricted to the analysis of English language literature on the autonomy of Greenland and Nunavut, with the inclusion of many publications by Danish and Greenlandic scholars. From what angle does one examine the issue of autonomy in Greenland and Nunavut if, on the one hand, Canadian and Danish legal systems were imposed on the Inuit, and, on the other, the Inuit had their own methods for resolving social problems and exercised what is called in the dominant societies a system of customary law. Some elements of customary law practices were partially incorporated in the Greenland Criminal Code of 1954, and the process of further consideration and inclusion of Inuit legal practices in the modern justice system is currently taking place in Nunavut. For the purposes of this study, should the Inuit people in the two countries be regarded from the point of view of the legal systems of the dominant societies? Or should there be some recognition that they possess their own legal system and structures of governance? 16. Kelly Gallagher Mackay suggests that a legal study of the Inuit of Nunavut should be conducted in a way that considers their cultural system and partially deconstructs the key political and legal institutional context in which the cultural elements are working. 26. Greg Poelzer argues that such an analysis should be focused on Aboriginal collectivities, which should be treated as separate political communities, distinct from the societies that dominate them. 27. His argument raises the question of whether the Inuit people of Canada and Denmark consider themselves part of Canadian and Danish societies and should therefore be treated as such, or whether they should be treated separately. I employ a blended approach, examining the Inuit people in Nunavut and Greenland as both separate communities and as part of the broader, dominant societies. Recent developments in Nunavut have shown that its political trajectory of development is different from that of Greenland. The Inuit of Nunavut see themselves as a part of Canada and are interested in further devolution of powers and in stronger cooperation and partnership with the wide spectrum of Canadian federal structures. The fact that Greenland is functioning within the institutional, legal, and political settings of a unitary state does not make a significant difference to its citizens' political choices regarding their country's future and expansion of autonomy in partnership with Denmark. The nation of Greenlanders is looking for greater autonomy within the Danish kingdom based on a new partnership agreement on self-governance, with the ultimate goal of economic and possibly political independence in the future. The Greenlanders' desire for increased self-government is linked to the necessity of economic sustainability and the realization of their right to self-determination. In the meantime, this dynamic process of obtaining increased autonomy is based on mutual respect, equal partnership, and consideration of existing close ties with the Danish state. The case of Greenland is of great learning importance for Nunavut, and vice versa. At the same time, the Inuit of both Nunavut and Greenland have historical, cultural, economic, and geopolitical relationships with the broader societies in which they are located. Finding the points of convergence and divergence among views held by Southerners and Northerners is crucial to this study. 1. The Inuit of Greenland and Nunavut. Before European contact. According to some scholars, the Inuit of Greenland and Nunavut were self-governing people prior to colonization. 1. In both Greenland and Nunavut the extended family provided the social structure of Inuit society. 2. The extended family coordinated its members and made decisions about where to set up camp and about hunting and gathering activities. Overall leadership of each group rested with the oldest male. 3. The Inuit lived in numerous, dispersed clusters of small hunting camps. Individual camps within each group tended to be made up of interrelated extended families, living together by common agreement. 4. The Inuit had a flexible system of governance based on consensus and making decisions through discussion. 5. Accordingly, the pre-colonial Inuit had no permanent administration or centralized political organization in the form of territorial government. The modern state system necessitated modifications to traditional Inuit social organization. However, the extended family structure and informal self-regulation that existed prior to European contact influenced both the administrative forms established by the Danish and Canadian colonizers as well as the eventual form of home rule and Nunavut public governance. Despite their informal, traditional social organization, the Inuit were able to adjust rapidly to formal, non-indigenous institutions and practices. How did they adapt so quickly to the new governmental systems? The impact of colonization on the Inuit of Greenland and Nunavut. The Inuit of Greenland and Nunavut share a common history of colony. 18. Zashan, albeit with an approximately 150-year time difference between them. 6. Both Canada and Denmark legitimate their sovereignty over Inuit territories using similar methods, missions and religious proselytizing, trade activity, and establishment of administrative systems. Although there were many similarities in the colonial experience of the two regions, there were differences as well. In contrast to Greenland, the Northwest Territories did not face the frontier phase of conquest, which according to Jet E. Ashley, dated from 1721 to 1776, and was marked by competition between Denmark and other European countries for control over the island. 7. There was no conquest of the Inuit of Nunavut, and British imperial rule over the area was established long before the Arctic was adequately charted. 8. British sovereignty over the territory occupied by the Inuit was partially established by Martin Frobisher in 1576 but was not formally asserted until May 2, 1670, when King Charles II of England granted what was then called Rupert's Land, an enormous tract comprising the lands in the entire watershed of Hudson Bay, to the Governor and Company of Adventurers of England trading into Hudson's Bay. The validity of the Royal Charter and the extent of the granted territories were questioned until 1870. The British North America Act, 1867 provided for and stipulated conditions for admission of these territories to the Dominion of Canada. 1 year later the British Parliament passed an act for enabling Her Majesty to accept a surrender upon terms of the lands, privileges and rights of the Governor and Company of Adventurers of England trading into Hudson's Bay, and for admitting the same into the Dominion of Canada. Such a surrender took place in 1869. Sovereignty of what was known as Rupert's Land and the Northwestern Territory was transferred peacefully to the Dominion of Canada in 1870. Upon the admission of these regions to the Dominion, the province of Manitoba was established out of a portion of their territory. The remaining territory was united and named the Northwest Territories. 10 years later Canada's northern boundaries were changed with the transfer from Britain of jurisdiction over all Arctic islands. 9. With recolonization of West Greenland on a permanent basis in 1721 after the arrival of Pastor Hans Egede and the Bergen Trading Company, the conversion of the Inuit population to Christianity gradually led to the demise of their traditional beliefs, social organization, and political system. The Inuit were becoming wards of the Norwegian-Danish crown and were administered by traders and missionaries. 10. Danish sovereignty over Greenland was vested through the creation of 19. The Royal Greenland Trading Company. In 1776 Denmark declared paramount control over trade in Greenland and promulgated a royal declaration entitled A Revised Royal Ordinance and Prohibition Against Unjustified Trade with Greenland, which provided an exclusive Danish monopoly of trade and travel to Greenland. 11. Europeans colonized the Inuit of Greenland and Nunavut by trade and settlement, which was largely in the form of missions and trading posts. 12. Gradually, the Inuit were put under alien authority by the activity of the KGH in Denmark and the Hudson's Bay Company in Canada. These companies, however, played different roles. Ashley writes that the KGH was an agent of state, as a result it constituted a full-body politic in Greenland, whereas the HBC was chiefly concerned with trade. 13. It is revealing that, in seeking to establish their sovereignty over these areas, neither Denmark, Great Britain, nor, later, Canada saw the necessity of concluding treaties with the Inuit themselves. Some argue that this lack of treaties shows that the colonizers did not recognize the Inuit as sovereign people. 14. Canada and Denmark each had difficulties in justifying their sovereignty over their Arctic possessions. Denmark's claim of sovereignty over Greenland in 1776 was based on the right of discovery. Thus, the Danish title to Greenland was recognized by other sovereign European countries. Yet Denmark had to compete with some rivals, particularly Norway, which considered the uncolonized part of the east coast of Greenland as a terra nullius and claimed the right to it. 15. Consequently, Denmark faced challenges to its assertion of sovereignty over the island. 16. The Dominion of Canada, which had obtained Hudson's Bay Company territories through transfer of title from Great Britain, had to seek international recognition of its sovereignty by effective occupation. 17. The Dominion's title was not recognized in international law, which asserted at the end of the 19th century that mere discovery, which was the basis of British sovereignty and Canadian title to the Inuit homelands, was insufficient to maintain territorial rights over an area in perpetuity. 18. Neither Denmark nor Canada fully recognized the Inuit as legal persons or saw much need for legislation to recognize or regulate their legal status. The Danish instructions of 1782, the Instructs, contain some form of recognition and has even been described by some as a genuine Magna Carta or Bill of Rights for the island's Eskimos. 19. However, this document was mostly concerned with trade and wage regulations. Furthermore, there was no mention of Greenland Inuit in the 20. Constitution of the Kingdom of Denmark of 1849 and consequent constitutional amendments simply because they did not exist in the eyes of legislators. Similarly to the Instructs, the British Royal Proclamation of 1763 has been called by some the Indian Bill of Rights. 20. Yet while the Crown recognized Indian nations or tribes, and acknowledged that they continue to possess traditional territories until they are ceded to or purchased by the Crown, it did not specifically refer to the existence or rights of the Inuit. It is debatable whether the proclamation applied to Rupert's Land. Indeed, the second paragraph of the part relating to Indians, which reserved certain lands for their use, expressly excluded the territory granted to the Hudson's Bay Company. 21. However, it is argued by some scholars that other paragraphs of the proclamation that deal with Indian lands apply to Rupert's Land. 22. Furthermore, notwithstanding that some legal documents dealing with the admission of Rupert's Land and the Northwestern Territory to the Dominion of Canada refer to Indians and compensation for their lands required for purposes of settlement, thus recognizing some legal rights for natives, the Inuit were not specifically mentioned in these documents and were not explicitly referred to in the Indian Act of 1876. 23. Importantly, the Inuit were eventually treated as subjects of law with the implementation of a British-based criminal justice system in Canada in the 1920s. However, it was only in 1939 that the Supreme Court of Canada decided that the term Indians included Inuit. 24. It is an open question whether Canada would have prevented challenges by foreign states to its sovereignty in the North had it recognized the Inuit as citizens. That such a step was not taken reveals the depth of the colonial mentality that governed Ottawa's relationship with the North and its indigenous peoples. This mentality, however, was not unique to Canada but was common among colonizers. Thus, to Denmark Greenland was just a colony with an inferior vassal population. If the broad perspectives of both Canada and Denmark vis-a-vis the Inuit were similar, their colonial policy differed. Part of the difference was dictated by geography. Anthropologist Jens Dahl notes that the Danish administration of Greenland had an external character, whereas the Inuit of Nunavut were the subject of internal colonialism. The geographical separation of Greenland from Denmark by several thousand kilometers and the lack of permanent Danish settlers meant that Greenlanders were not as influenced by outsiders. Consequently, their demands for decolonization have been much more radical than those 21. Put forth by Inuit in Canada or Alaska. The lands of Canadian Inuit, while remote, were directly connected to the rest of the country, and their indigenous occupants were more directly influenced by non-Aboriginal migrants. Consequently, it was more difficult for the Inuit of Nunavut to develop either a political elite or political unity. 25. The Danish assertion of sovereignty over Greenland was more active than Canada's over Nunavut. A political system based on Western concepts of law, religion, and property ownership was intended to replace the existing Inuit social order and was backed by Danish absolute authority. The Instructs of 1782 established rules for wages and codes of behavior for Inuit and Danish merchants, divided Greenland's population into social categories, set forth heavy penalties for corrupting the Inuit with alcohol and other things that might jeopardize their livelihood and health, prohibited marriages between Europeans and pure Greenlanders, and closed Greenland to outsiders by permitting only the king's officials to have contact with Greenlanders. 26. This document gave expression To the Danish principle of keeping the Inuit away from the corrupting influences of the Europeans. The Danish government assumed that protecting Greenland from outsiders and exploiting the resources of the island themselves would result in profits that would defray business and administrative expenses. Thus, every trader was supposed to become a mentor and protector of the Inuit involved in trade, and the Inuits' welfare had to receive the highest possible consideration, even override when necessary the interests of trade itself. 27. This policy of making an Arctic colony a Garden of Eden where happiness would come through isolation and paternal rule. 28. Both protected Greenlanders from outside influences and made them dependent on Danish tutelage. The idea was to civilize Greenlanders and to keep them as junior Danish partners without pushing for any development of the Inuit population or putting extra money into improving their living conditions. In contrast to Denmark, which protected its trade interests by economic paternalism towards the Inuit population and used the profits to modify the Inuit social system with mercantile principles, Canada pursued a passive approach to colonization. It adopted a laissez-faire policy towards the Inuit, who were to be left as little disturbed as possible, provided that peace prevailed. 29. Several researchers have emphasized that Canada was a reluctant guardian of the Inuit. 30. In comparison to Denmark, Canada did not take notice of the Lords of the North or acknowledge any responsibility for their fate until circumstances forced 22. It to do so. It was motivated to take action partially by the challenges to Canadian sovereignty in the Arctic by foreign states, which prompted the establishment of permanent posts of the Northwest Mounted Police in the region in the early 1900s. 31. Several factors account for this reluctance. First, Canada obtained its title to the North via a peaceful transfer rather than by any rivalry for the new territories. Second, as a recent British colony, the Dominion of Canada acquired responsibility for territories that were at the time of little importance to the national policy. Third, organized as a federal state, Canada had a different pattern of nation building than unitary Denmark, which tried to civilize Greenlanders by promoting a centralized, collective cultural identity. Finally, partially because of geographical remoteness, the Inuit were legally unknown, and they had little contact with Europeans until the 19th century. 32. Because of their isolation, the Inuit in both regions were less affected by European colonizers than were other Aboriginal peoples, and colonial practices were relatively benign because of the lack of oppression by force. 33. According to Robert Peterson, the Danish colonization had a peaceful character because the Greenlandic community had no organization above the household level, and thus lacked anyone who might be interested in defending his power. 34. This observation can also be applied to the Canadian Eastern Arctic. There were similar, though slightly different, reasons why both territories were not subject to forcible oppression. Greenland was isolated by Danish protectionism and its geographical location, whereas the Canadian North had little communication with Dominion powers because of its remoteness and Ottawa's indifference. The spread of liberal ideas in Denmark in the 19th century resulted in a reorganization of Greenland's social life. In 1871, Greenlandic language was standardized, and the gap between a literate Inuit minority and uneducated hunters increased social stratification. 35. The administration of Greenland was rationalized by the creation in the second part of the 19th century of local administrative bodies, the Boards of Guardians, which served the function of a municipal council. In response to criticism that they were undemocratic and too heavily composed of Danish officials, the boards were replaced by new municipal councils in 1908. Danish legislation was frequently updated to accommodate the island's social conditions. 36. An important change was undertaken by the separation of trade and administration, and by the creation for the first time in 1911 of two provincial councils. 23. Of northern and southern Greenland, with Greenlanders' exclusive participation. 37. In the opinion of Dahl, these were key steps towards political unity and the formation of a true Greenlandic nation, which was in sharp contrast to the fragmentation that characterized the Inuit of Canada and Alaska. These developments were also important for shaping a political infrastructure that included Greenlanders' participation in the political process and for the emergence of a class of indigenous leaders. 38 In 1910 Greenland's elite founded a nationalist movement with the motto "Forward and Upward" and was talking about Greenland as a nation. 39 Further realization by the educated Greenlandic elite that Greenlanders were second-class citizens because of their lower social status and education, and of the necessity to be able to compete with Danes for jobs, led to a political philosophy shaped by the need for making the society as Danish as possible and as Greenlandic as necessary. 40 It also encouraged Greenlanders to learn Danish, which became more widespread in Greenland after the Second World War. 41 Paternalistic policies, based on the assumption of Inuit inferiority and centralized control and domination of the Inuit political and social systems, caused economic dependency on Denmark and escalated the conflict between the Greenlandic elite and the Danes. At the same time, the colonial administration was based on an indirect form of government with Greenlandic and Danish participation. According to Dahl, in order to achieve better results, the Danish administration looked to Greenland's pre-colonial form of societal organization. 42 This outlook affected the structure and scope of the Greenlandic home rule system and stands in sharp contrast to the Nunavut case. Canadian administration in the north was ad hoc, shaped by the separate activities of missionaries, traders, and police, and was based on the government structures in Ottawa, with minimal interest or intervention by the Dominion. 43 There was no active coordination of these activities. The Inuit of Canada's Eastern Arctic did not have an opportunity to participate in the administration of their area, as did Greenlanders. Except for some experiments, Canada ignored the Inuits' existence and abandoned any responsibility for their welfare. 44 British/Canadian legislation was not updated for Northerners' social needs. In the early 1920s, criminal law was extended to Canada's Eastern Arctic because of a cry in the South demanding that the Inuit be subject to white men's justice. This cry was precipitated by a series of murders of non-Inuit in the North. 45 Although Canadian and Danish policies and perspectives with re. 24. Regard to treatment of the Inuit differed in some ways, in many respects the outcomes were much the same. The result was a path that brought enormous changes to the Inuits' lives, including the spread of diseases, dependency on European technologies such as firearms, loss of indigenous belief systems to Christianity, the change of subsistence patterns of livelihood, and replacement of indigenous leaders by outsiders. 46 The longer period of colonization in Greenland, cultural factors, the distinct Danish policy towards Greenlanders, and the beginning of the formation of the Greenlandic nation caused faster social stratification in Greenlandic society and led to the emergence of a new elite characterized by growing dissatisfaction with the privileged Danes. This phenomenon did not occur in Nunavut because of the different relationship between the Inuit and the Canadian government. Decolonization and the road to self-governance. The current governance arrangements in Greenland and Nunavut were influenced by factors preceding the creation of the Nunavut Territory and Greenlandic Home Rule. These factors, which dated from the end of the Second World War to the early 1980s, included the end of colonization and the legal recognition of the Inuit by their respective states, the increased exploitation and extraction of natural resources, military activity and challenges to Arctic sovereignty, social and economic changes brought about by the modernization of Inuit societies, and the Inuits' political mobilization and move towards self-determination and autonomy. The Second World War and the post-war years brought enormous changes to the lives of the Inuit in Greenland and Canada. In both countries, isolation was broken by increased military activity, which raised the issue of Greenland's status within the Danish kingdom and brought new challenges to Canada's sovereignty in the north. Germany's invasion of Denmark in 1940 brought Allied forces to Greenlandic shores to protect the Danes' overseas territory, which they were unable to do themselves. This situation heightened Greenlanders' awareness of the need for radical change. Moreover, after 1941 U.S. military bases were established in Greenland. When the war ended, Denmark wanted to demolish them, but the United States prolonged the negotiations until the bases came under the authority of the North Atlantic Treaty Organization in 1949. 47 Meanwhile, in 1942 to 3:25. And between 1952 and 1957, a U.S. Air Force base was built at Frobisher Bay in Canada's eastern Arctic, and the U.S. Canadian Distant Early Warning Line was established from Alaska to the east coast of Baffin Island in response to the threat of Soviet missiles. 48 The strategic importance of the Canadian Arctic and quasi-permanent American presence in the region threatened Canadian sovereignty and forced the Canadian government to look more closely at its northern territories. One result was the creation in 1953 of the Department of Northern Affairs and National Resources. 49 Moreover, the increased scrutiny brought about by the war had shown that there was a huge disparity in the living conditions of the Inuit and the rest of the population. In the words of Peter Juhl, the country had been forced to discover Inuit and other northern peoples through war and Cold War. 50 In 1945 the Greenlandic provincial councils expressed their wish to seek an equal footing with the Danes. 51 In 1948 the Danish Prime Minister, Hans Hedtoft, appointed a royal commission on Greenland to look into the situation on the island. The commission's report, which was published in 1950, formed the basis for a new order plan oriented on the modernization and transformation of Greenland from a Danish colony to an industrial society within the Danish kingdom. 52 In contrast to Denmark, Canada had no clear plan for dealing with its Inuit population. Since the early post-war years, the Arctic had been flooded with white administrators, school teachers, doctors, nurses and welfare officers, all committed to raise the Eskimos' cultural level and improve their standard of living, but progress disturbingly slow because there was no clear policy for organizing the endeavors of all these well-meaning individuals or any effort to coordinate the numerous programs. 53 In the post-war period Canada and Denmark took different approaches to the well-being of the Inuit. They also took different directions on other issues regarding further development of their Arctic territories. One such issue was resource extraction and the dimensions of industrial policy. Under the new order of 1950, Greenland proceeded with modernization and industrialization simultaneously. This was followed by the G60 plan in the 1960s, which led to further increases in investment in Greenland but failed to facilitate the training and education of Greenlanders to take on jobs that were carried out mostly by skilled Danes. 54 There were no resources in the Canadian North that could provide an effective economic base for the modernization of Inuit economies. However, the thinking of policymakers and administrators 26 was that the Inuit of the NWT would become a modern workforce for a resource economy through education and acculturation. 55 With Ottawa's desire to extend the standards of the Canadian welfare state to the Inuit, and with its need to indicate to the international community its commitment to the provisions of the UN Charter, quasi-modernization programs were introduced long before an adequate wage economy was founded for the area. 56 The changed international climate, including Canada's and Denmark's adherence to the principles of the UN Charter, led to the realization in both countries that changes had to be made in the legal and social status of Greenlanders and the Canadian Inuit. From 1946 to 1954 Denmark in its report to the UN listed Greenland as a non-self-governing territory under Chapter 11 of the UN Charter, thus confirming the colonial nature of its administration on the island. 57 However, in the general atmosphere of criticism of colonialism and the Greenlanders' expressed desire for decentralization, Danish authorities, who were eager to eliminate the supervision by the United Nations and other international scrutiny of the conditions in their possession, seized the initiative and transformed the requests of the natives into integration. 58 Consequently, the Constitution of 1953 ended Greenland's colonial status by integrating the island into the Kingdom of Denmark. 59 However, it is not clear to what extent the colonial mentality towards Greenlanders and the ability of the latter to exercise direct influence and control of their own affairs remained unchanged between this move and the introduction of Home Rule on May 1, 1979. 60 While Greenland was placed on an equal footing with the rest of the Danish kingdom and obtained the right to send 2 representatives to the Danish parliament, there was no real equality between Greenlanders and their Danish counterparts. Living standards in Greenland were much lower than in Denmark. Furthermore, a colonial relationship actually intensified, with the immigration to Greenland of a significant number of Danes and the continuation of a neocolonial economic policy. 61 Moreover, as Gudmundur Alfredsson notes, Greenland was not given a choice other than to opt for integration with Denmark. Greenlanders had not participated in the enactment of the new constitution, either through elections or a referendum. However, Danish lawyers have argued that Greenlanders raised no objections to integration with Denmark. 62 Indeed, the new arrangements raised high hopes among Greenlanders for increased management of their own affairs and for greater economic prosperity, but in some ways the practices of the former Colorado 27 Nile relationship remained unchanged. As in Greenland, the quality of life for the Inuit in the Canadian Arctic remained far behind that of the majority population. Furthermore, equality was interpreted as uniformity, as the Inuit children read books full of pictures and stories about trees and pet dogs and cats. The scattered Inuit camps were gathered into central villages near trading posts, nursing clinics, schools, and mission churches. Inuit elders were replaced by white administrators who were to supervise an acculturation. 63 Contact with the rest of the country was infrequent, and the only Inuit to experience life outside their communities were tuberculosis patients sent to recuperate in the south. 64 The Canadian Citizenship Act 1947 designated the Inuit as Canadian citizens. Citizenship might imply a vague equality among Canadians, but it did not result in sudden improvements in living conditions, economic status, or in the poor level of formal education among the Inuit. Nor did citizenship confer automatic realization of voting rights by the Inuit and other residents of the NWT, who were unable to vote in federal elections until 1962. 65 This delay was mainly logistical, as holding elections in the Canadian Arctic was nearly impossible. By comparison, Greenlanders, who had a higher level of literacy and formal education than the Canadian Inuit, were familiar with forms of electoral democracy at an earlier time than their Canadian counterparts and were able to raise their voice through their representatives in the national legislature. 66 Canada and Denmark employed similar welfare state methods in their northern lands. Attempts to improve the standard of living for the Inuit by means of employment, income assistance, health, housing, and education programs met with limited success. In Greenland, industrialization and the extension of social welfare required the movement of the population to urban districts. In the words of Mark Nuttall, people were encouraged to migrate from outlying areas to west coast towns by the closing down of what the Danish authorities regarded unprofitable settlements. 67 This policy transformed Greenlanders into wage-earning urban workers and widened the income gap between the Danish and Greenlandic labor force, as Greenlanders received lower salaries than their Danish colleagues. 68 Furthermore, as Nuttall states, movement to the towns led to the fragmentation of kin-based groups, and individuals now experienced alienation, social and economic marginality and discrimination, accentuated by ethnic divisions between Inuit and Danes. One unintended result of this policy was an emerging Inuit political awareness. 69. 28. In Canada's Arctic, the Inuit were concentrated in their communities, as government schemes of relocation to major industrial urban centres in the south were not considered a priority. In the 1950s, Ottawa introduced a highly controversial relocation plan in the high Arctic, affecting the Inuit of Inukjuak and Pond Inlet. Although the federal government argued otherwise, the Inuit claimed that they were being used as pawns to bolster Canada's sovereignty in the area. In some ways, this experience is similar to the relocation of the Inuit of Greenland in 1925, which was done to establish Danish sovereignty over northeast Greenland, and the relocation of the Inuit of Greenland in 1953, which occurred to make way for a U.S. military base in the Thule area. 70 Despite some changes, Canada's Arctic remained a northern frontier characterized by isolation and infrequent contact with the rest of Canada. The political mobilization of Greenlanders, which had begun in the early 1900s, reached its peak in the 1970s. It produced a new generation of young Greenlandic politicians as well as the formation of Inuit parties. The impetus for self-determination and political autonomy came from the activities of these groups. Greenlandic politicians, frustrated by increasing Danish dominance and the failure to achieve equal status with Danes, advocated a more Greenlandic Greenland, i.e. a society as Greenlandic as possible and as Danish as necessary. 71 Influenced by growing talk of decolonization for the Fourth World, they demanded to have a greater say in their own country. 72 Formed in the 1970s, Greenlandic parties put forward a wide spectrum of political platforms, from separation from Denmark to further integration with the kingdom. As will be discussed in Chapter 3, they made a valuable contribution to the radical shifts in the Greenlandic-Danish relationship. In Canada, the formation of Inuit political associations in the 1970s was stimulated by several factors, including the failure of the 1969 White Paper on Native Policy, the discovery of oil fields in Alaska, the impact of the Supreme Court of Canada's Calder decision, which revived the recognition of a common law native title, and the signing of the James Bay and Northern Quebec Agreement. 73 In 1976 the Inuit Tapiriset of Canada proposed to the federal government to create Nunavut as a part of a comprehensive settlement of Inuit land claims in the Northwest Territories. 74 Unlike in Greenland, where the Inuit were the island's sole Aboriginal group, the NWT contains several native groups with distinct interests and claims. Thus, the Inuvialut of the 29 Western Arctic, who were originally covered by the ITC's Nunavut proposal, negotiated a separate land claims agreement in 1984. 75 Unlike in Greenland, where the process towards self-government was a process of nation-building, the regionalism of Canadian Inuit politics was further nourished by the division of the process of negotiating self-government. 76 That was part of the reason why it took so many years for the Inuit of Canada's Eastern Arctic to make their dream of the creation of Nunavut come true. 77 The process of establishing Nunavut had many stages, culminating in the combination of a 1993 land claims agreement and the creation of the new territory and government on April 1, 1999. 78 The Nunavut success story is testimony to the decades of persistent work and patient strategy of Inuit organizations and their leaders. In contrast to the situation in Greenland, an Inuit elite did not exist in Canada when Inuit organizations were first created. In Greenland by the 1970s the internal political course was driven by a bilingual Greenlandic elite disappointed with continuing oppression and broken promises of equality with the Danes. 79 Thus, a so-called Greenlandic intelligentsia with well-formed political goals led the 1970s movement for home rule. But in Canada in the 1970s a Western-educated Inuit intelligentsia was still emerging. In both regions, the quest for self-determination and autonomy was a product of nationalism and a unique Inuit identity. Ilana Wilson argues that in Nunavut much of the call for self-government was rooted in the idea that the Inuit identity was challenged and subverted by their participation in essentially foreign governance structures. The Inuit autonomy movement adopted and internalized the rhetoric of nationalism, particularly in the discourses of land, tradition, and institution building. 80 The creation of Nunavut can be seen as the result of an indigenous nationalist movement. In Greenland, the struggle for autonomy was validated by the image of a Greenlandic nation and a Greenlandic elite that, when demanding self-government, spoke on behalf of all Greenlanders. 81 Therefore the process of negotiating and establishing self-government was a process of nation-building, a gradual process transforming an ethnic identity to national cultural and political identities. 82 By contrast, in Canada, the claims process was a process towards strengthening ethnic identity, a process in which new identities were asserted. 83 Nonetheless, the seizing of the political momentum played a crucial role in negotiating the Greenland Home Rule and Nunavut governance arrangements. As Jose Kosugak has noted, outside events, like 30. Upcoming federal election in 1993, the tragic events at Oka, Quebec, and the breakdown in a single comprehensive land claims agreement in the Mackenzie Valley prompted the final negotiations of the Nunavut Agreement and helped to realize the creation of Nunavut. 84 Greenland's membership in the European Economic Community was a decisive impetus towards autonomy. Although the majority of Greenlanders voted against entry during the 1972 referendum on Danish membership in the EEC, Greenland became a member of the EEC along with Denmark. 85 This event led the Provincial Council to submit a proposal to the Danish government in 1972 requesting that local authorities be granted wider jurisdiction over Greenlandic matters. 86 This proposal resulted in the establishment of the Home Rule Committee, whose partial report led to the creation in 1975 of the Danish Greenlandic Home Rule Commission. 87 The Commission's report developed the basis for the Greenland Home Rule Act of 1978, which came into force on May 1, 1979. 88 Greenland's Home Rule and the creation of Nunavut became possible partly because of the idealism within the dominant societies regarding the Inuit. In the process of its creation, Nunavut experienced the enormous advantages that follow from finding support in non-Aboriginal society. 89 As Joel states, Canadian idealism and romance about Inuit and the Arctic has included readiness to accept high costs. Thus, for Inuit, Nunavut is an astonishing achievement; for other Canadians, it is a monument to national idealism and goodwill. 90 Idealism also existed in Danish society with regard to Greenlanders. In both regions, the Inuit succeeded in overcoming their subjugation by using the methods and the language of their colonizers. 91 In Dahl's opinion, the fact that Greenlanders fought the colonial power holders with their own weapons, was the major organizational reason behind the successful process that resulted in Home Rule. 92 Similarly, the Inuits' use of language and tactics acceptable to the federal and NWT governments may explain their success during negotiations. At the same time, the creation of Nunavut paralleled the reform of Canada's constitution and was influenced by existing political culture. The Inuit were negotiating their cultural and political autonomy and their water and land rights in the framework of de facto citizenship and constitutional processes. 93 As Joel stresses, the Nunavut self-government and claims teams maintained high moral and intellectual ground in constitutional, cross-cultural, and environmental matters, example parading the quest for a Nunavut territory as Canada's first made in Canada. 31. Constitutional reform process since white settlement. 94 Thus, the Inuit won over enough Canadians and white elites to establish themselves as full Canadians, but a new kind of Canadian, with Nunavut a new kind of Canada. 95 Despite differences in their organization, Home Rule in Greenland and public governance in Nunavut were shaped by similar experiences that propelled these regions towards self-determination and autonomy. As the Inuit both in Canada and Greenland had their traditional way of life supplanted by social, economic, political, and legal structures imposed on them by the Canadian and Danish governments, they became dependent on their colonizers for financial support and other forms of social welfare. This situation seriously eroded Inuit economic and ecological sustainability and established solid grounds for continuing voluntary colonialism, which put the future of Inuit self-governance and self-determination in question. As the Inuit became dependent on state welfare, their capacity for traditional independent subsistence was largely extinguished. Hugh Brody describes the experience of Pond Inlet. White men had come with many powers and purposes. Under their supervision, the old days changed. A mix began to take shape, with life on the land yielding to various forms of modern poverty. Inuit women became servants in the white officials' homes, men had opportunities for occasional wage labor. This was work that yielded small amounts of money or credit at the store. It also meant a shift towards store-bought food and clothes, and some degree of dependence on newcomers who were anything but generous. 96 The road to self-governance did not end with the introduction of Home Rule in 1979 or the creation of the territory of Nunavut in 1999 and the signing by the Inuit of the NLCA in 1993. Because of the continuous evolution of Greenland's system of governance and fulfillment of all legal and political possibilities embedded in the Greenland Home Rule Act of 1978, the reform of Greenland's legal status within the Danish realm was necessary. This led to the creation in 1999 by the Greenland government of the Commission on Self-Governance, which in 2003 released its report offering recommendations for expansion of Greenland's autonomy in a number of areas. In 2004 a Danish Greenlandic Self-Governance Commission was created to develop a plan for increasing Greenland's autonomy within Denmark. It is expected that ongoing Danish-Greenlandic negotiations on Greenland's constitutional status will lead to the signing by 2008 of a new partnership agree. 32. Meant on self-governance that will provide Greenlandic authorities with possibilities of greater autonomy. In Nunavut we also witness political and legal evolution of governance. Even though the Nunavut system of public governance was created with active Inuit participation, it is not clear yet whether it is going to develop towards any form of self-governance for all residents of Nunavut or towards Inuit autonomy, or if Nunavut will eventually become a province of Canada. In the near future Nunavut is expected to reach a devolution agreement with the federal government, which may transfer more province-like powers from Ottawa to the territory. Thus, both Greenland and Nunavut are looking forward to a greater measure of autonomy in regaining control over their affairs. 2. The constitutional dimensions of the governance of Nunavut and Greenland. Inuit perspectives on self-governance and the governance systems of Greenland and Nunavut. Are Greenland and Nunavut examples of real autonomy for the Inuit, or are they legal fictions, indulgences granted by Denmark and Canada? The legal understanding of the constitutional arrangements in Greenland and Nunavut cannot be explored without consideration of Inuit perspectives on autonomy. Canadian and Danish political, social, economic, and legal institutions were imposed on the Inuit. Colonial and modern state practices eroded traditional Inuit systems of self-regulation. Thus, the Inuit had to live under the alien structures of colonizers, who were not always inclined to accept indigenous institutions. Published materials and interviews with the Inuit show that they consider themselves to have been a self-governing people. 1. The Inuit perceptions of governance are closely connected with their perceptions of their rights. However, discussing the concept of rights among the Inuit is complicated. As Inuit representatives state, there is no concept of rights in Inuit tradition, but they were always there, part of our mentality even though they were never written. 2. Thus, from their own perspective, the Inuit were self-governing prior to European contact, notwithstanding the fact that there were no formal concepts of governance and its constituent elements in Inuit tradition and practice. 3. This discussion highlights the problem of the compatibility of Western notions of governance with Inuit values. If formal doctrines of autonomy and rights are not inherent to the Inuit tradition, how could the Inuit have been expected to comprehend and apply these concepts when state institutions, including law, were imposed on them? 4. For many years, the dominant society told the Inuit what to do without SPE. 34. Child accommodation for their traditional values, and the Inuit have adapted accordingly. But with the rise of Inuit political consciousness, it became necessary for the Inuit not only to understand such rules but to be able to use them to justify their own political aspirations. This becomes evident in remarks by the late Inuit leader Mark R. Gordon, who stated that the concepts of land claims and Aboriginal rights were introduced by non-Inuit lawyers and were a tool not of our invention but were used by Inuit with the intention to run our own lives. 5. The Inuit Tapiriset of Canada agrees with Gordon, but indicates how difficult this process could be. 6. At the political level, the uneven power relationship between Aboriginal peoples and non-Aboriginal decision-makers has provided little opportunity for Aboriginal peoples to shift discussion from conceptual frameworks rooted in Western legal traditions towards some more neutral ground. The decision to work within a common law framework, a human rights framework or some other conceptual framework to articulate Inuit self-government rights is a strategic decision influenced by a range of complex political, legal, and other factors. Needless to say, Inuit are placed at some disadvantage in attempting to express Inuit perspectives of Inuit rights through an alien legal system. 7. Currently, there is no common view on self-governance among Aboriginal peoples, among the Inuit of the different regions of the Canadian Arctic, and particularly between the Inuit of Nunavut and Greenland. 8. During interviews, many of the Inuit respondents emphasized the importance of developing economic opportunities, self-sufficiency, and partnership with the criminal justice system as the best means for dealing with social issues and promoting human development. As expressed by a senior official of the Inuit Circumpolar Conference, self-government begins when people have the ability to be a part of the governance structures. Self-government has to reflect the Inuit culture, values, and principles. It has to be completely in a way where we have been part of that process from the bottom up. And so, the self-government, self-governance, must reflect the actual empowerment of the individual, the family, the community, and the nations as a whole to be real. 9. Genuine self-government starts with people's ability to realize themselves and to promote their values and beliefs within governmental structures. The success of current governance systems in Nunavut and Greenland depends not just on the development of the institutionalized structures but also on people's active participation in processes, initia. 35. Tives, and contributions in making different levels of their governance machinery efficient and responsive to its citizens' needs and expectations. Furthermore, in both Greenland and Nunavut, Inuit values should form the basis for self-government or at least be reflected in the administration of governance institutions. 10. The Home Rule process is evolving towards greater autonomy for the Greenlandic nation, whereas in Nunavut the focus is on nation building. In contrast to Nunavut, Greenland is a unified nation. The Inuit of Greenland act as national representatives of the country of Greenlanders. Thus, the existing Home Rule system and anticipated legislation on Greenland's expanded self-governance do not put special emphasis on promotion of ethnic rights of the Inuit. Furthermore, after more than 2 decades of Home Rule, the system in Greenland has evolved to a more advanced level of governance and nation building compared to that in Nunavut, where the process is still rooted in Inuit nationalism and regionalism. Along with settlement of the Nunavut Land Claims Agreement, which guaranteed the Inuit a variety of rights and benefits, the Inuit of Nunavut chose the form of public government for their territory. However, despite the fact that this created system of public governance applies to all Nunavummiut, that is, citizens of Nunavut, it gives special priority to the accommodation of the Inuit interests and protection of their rights. Thus, a dual political culture and a hybrid system of governance policies have developed in Nunavut. On the one hand, there is a legal regime and policies intended for the beneficiaries of the NLCA, who represent the majority of Nunavut's population. On the other hand, there is public government for all Nunavummiut, which gives special consideration to Inuit values and concerns. In the political discourse within Greenland, many rights are claimed for the Inuit. However, for several reasons, every demand for rights put in ethnic terms has been transformed and interpreted into rights for the territorially defined population of the island. Consequently, de jure rights are not conferred on anyone for being an indigenous person. 11. Thus, in Canada and Denmark there are different approaches to the ethnic rights of the Inuit citizens of Nunavut and Greenland. This is partially because of the history of colonization, differences in Canadian and Danish legal and political perceptions of indigenous rights, and uncertainty regarding availability of mineral resources in Greenland. 12. Thus, the concept of an inherent Aboriginal right of self-government or negotiations of a land claim agreement with Greenlanders has never been at issue in Denmark. Unlike their Canadian counterparts, the Inuit of Greenland are the only indigenous group of the Danish realm occupy 36. A distinct territory, and they did not face rivalry with other Aboriginal peoples in asserting their political aspirations. Finally, because of fluid ethnic boundaries in Greenland and because of the reluctance of Danish authorities to apply ethnic criteria, the legal definition of who is a Greenlander includes every Danish citizen living on the island. 13. In sharp contrast to Nunavut, ethnicity was not the basis for Greenlandic identity, and there was no need to decide whom to consider Inuk or non-Inuk in terms of rights and access to benefits. 14 Despite the prevalence of intermarriage between Inuit and non-Inuit in the Canadian North, the special protection of Inuit residents, and especially those who qualify as beneficiaries of the NLCA, has been a matter of vital importance in Nunavut. 15 The question of the Canadian Inuits' right to self-government requires some further attention because of its theoretical complexity arising from political and constitutional practices that affect the relationship between the Inuit and the State of Canada. The Inuit of Canada view their right to self-government as part of the right to internal self-determination and as an inherent, fundamental human and aboriginal right. Thus, if the ancestors of the Inuit of modern Nunavut were self-governing prior to colonization, then an Inuit right to autonomy, being inherent, continues to exist notwithstanding any governance structures created by Canada. Consequently, the Inuit could choose to establish a system of indigenous autonomy with all the necessary components based on their traditional beliefs. In the Inuit view, Aboriginal self-government is not an abstract concept which needs definition, it is the means by which Inuit can regain control over their lives. 16 Thus, the Inuit Tapiriset of Canada emphasizes that Inuit believe that the Canadian Constitution and Canadian Aboriginal rights doctrine should be interpreted and developed in a manner that recognizes individual and collective rights as integral parts of a comprehensive human rights regime. For example, the inherent right of self-government is an aspect of our right to self-determination and therefore has the character of a fundamental human right. 17 As summarized by Rosemary Kuptana, the Inuit Tapiriset of Canada has elaborated several elements of the right to self-government. It is a pre-existing and fundamental human right and therefore not subject to extinguishment. The inherent right of self-government exists independent of any self-government agreement, govern. 37. Ments established by Aboriginal peoples in exercise of the inherent right constitute an order of government with constitutional status. The consent of Aboriginal peoples is necessary in defining the relationship between Aboriginal peoples' governments and federal and provincial governments. The inherent right of self-government does not prescribe any particular form of government and therefore encompasses ethnic and non-ethnic forms of government. 18. A 1987 position paper by the Inuit Committee on National Issues mapped the general terms of what Canadian Inuit are seeking from self-government. Canadian Inuit favor a territorial base for their institutions of self-government but do not claim absolute sovereignty in the areas in which they live. Further, Inuit seek legislative authority and other powers necessary for raising their own revenues. They stress that self-government means full authority over most local and regional matters, and concurrent jurisdiction with federal or provincial governments over matters of common concern. The Inuit also have emphasized an importance of having a constitutional protection for self-government. 19 In Canada, the Inuit maintain that the federal crown has a specific relationship with Inuit as a people and a fiduciary duty to Inuit. This fiduciary duty includes the obligation of the federal government to respect the fundamental human rights of Inuit, including the right of self-determination, which encompasses self-government. 20 As noted by Joel, self-determination refers to the right of a culture, society or region to decide for itself whether its future will be as an independent sovereign entity in the world, or whether, like Nunavut, its people accept association with or an integration in an existing national constitutional order. 21 The Inuit perception of self-government needs to be viewed through the Inuits' special relationship with the Canadian and Danish states. How is this relationship reflected in the governance arrangements for Greenland and Nunavut? Legal and political nature of Greenland's and Nunavut's governance arrangements. The key to sustained and effective Inuit participation in politics does not lie in 38. Further elaboration and consolidation of existing structures, nor in tinkering with existing mechanisms for decision-making. It lies in the formal constitutional recognition of the Inuits' right to determine their own future and to develop the institutions and procedures most appropriate to the expression of their deepest concerns. Peter Ittenauer, Inuit leader. The legal and political foundations of the Greenland Home Rule Act, the Nunavut Land Claims Agreement, and the Nunavut Act constitute the basis of the governance systems of these two jurisdictions. Consequently, the following questions have to be considered. What are the main legal features and principles of these documents? Are they results of the Inuit right to self-government/self-determination or the outcomes of political necessity? Do they actually provide the Inuit with effective self-government? It is important to note that both jurisdictions are based on the territorial principle, with some differences in the intent of the legislators in the elaboration of the Home Rule Act, the NLCA, and the Nunavut Act. 22 Some authorities maintain that the Inuit of Greenland became the first population of Inuit to achieve a degree of self-government over a large region of the high Arctic. 23 They also state that under the structure that established the system of Greenland Home Rule, an emphasis was placed on the definition of indigenous peoples as collective entities, being the first inhabitants of part or all of the country. 24 Although these statements are technically correct, in reality, Home Rule status was given to all residents of Greenland, including non-Inuit. As a former Premier of Greenland, Lars Emil Johansson, noted, the Home Rule Agreement is not an agreement honoring or even referring to the collective rights of the Inuit population, but rather a law concerning everyone living permanently within the geographical entity of 840,000 square miles known as Greenland. From a legal point of view, the rights and powers of the Home Rule Agreement were not granted to us as a people or ethnic group, but as the inhabitants of a certain land mass. 25 Before the introduction of Home Rule in 1979 there were arguments among the political parties of Greenland on this very issue. For example, the Inuit Ataqatigiit Party claimed that Home Rule does not acknowledge the title to land of the Aboriginal people. 26 In the same vein, Hansi Golov noted that, in its work, the Commission on Home Rule has not used the Aboriginal right to sovereignty of the Greenland nation as a basis. 27 These statements indicate that the Home Rule Act of 1978 was 39. Not designed as a special form of self-government for the Inuit people of Greenland but applied to all inhabitants of the island. The Home Rule Act is a classic example of a statute based on territorial autonomy. However, over time, the system of governance created by the Act has evolved into one that, at a functional rather than a juridical level, goes far towards meeting the interests of the Inuit, who represent the majority of the population. 28 In contrast, negotiations around the creation of Nunavut were at the very beginning oriented towards some form of self-government for the Inuit, but in the end Inuit leaders chose the form of public government. The creation of the new territory of Nunavut was ensured by the Nunavut Act, and by a Nunavut political accord concluded by negotiators for the Tungavik Federation of Nunavut, the Government of Canada, and the Government of the Northwest Territories. 29 At the same time, this political settlement, which was a part of the negotiation of the Nunavut Land Claims Agreement, was explicitly included in the NLCA. 30 Nunavut system, like that of Greenland, is an example of public territorial governance for all inhabitants of the area. The Greenlandic model of governance was based on already existing legal concepts. 31 In Nunavut this choice was a pragmatic political move consistent with the patience and determination of the Inuit in pursuing their goal of regaining control over their lands. They recognized that the model of public government was more palatable than Inuit self-government to the federal government and Canadians in general. 32 John Amago Alec, often called the father of Nunavut, has noted that Nunavut is not purely Aboriginal self-government because, right from the beginning, we have proposed that Nunavut be a public government where everyone has the same rights and responsibilities. 33 Inuit leaders accepted that Nunavut was not formally recognized as an instance of Inuit self-government. At the same time, they pragmatically pointed to the de facto consequences of adopting the public government model in a territory with a clear Inuit majority. In the words of the Inuit leader Jose Kusugak, the creation of a new territory with a government representing all its residents is a workable and attractive form of empowering the Inuit of Nunavut. This is entirely a function of our demographics. Unlike Aboriginal people in other parts of Canada, we have never been a minority in our homeland. 34 A senior official with the government of Nunavut further notes that it is a public government, because anybody in Nunavut, who is a resident, 40, can run for an office, like the Legislative Assembly. But at the same time, if we look at the population ratio, and the control of the government, we can look at it as an Inuit government because Inuit are majority right now. Inuit control the government. At the same time, when we were establishing the Nunavut government, we did not want to see an Aboriginal self-government, as in the other parts of the country. We wanted to have a public government to be established in Nunavut. 35. As in Greenland, the Inuit majority in Nunavut transformed formal territorial autonomy into de facto Inuit governance. It is a public government with an Inuit face. 36. As Amago Alec has stated, no other land claim has involved creating a new territory with our own government. It is a victory. We've achieved what other Aboriginal people can only dream about. 37. The question becomes whether territorial autonomy alone can protect the rights of indigenous peoples or whether there is a need for a special type of indigenous autonomy for the Inuit living in Greenland or Nunavut. The Greenland and Nunavut cases prove that there is not. The Inuit majorities in Nunavut and Greenland in practice are turning de jure territorial forms of governance into de facto indigenous ones. Some differences in the Greenland Home Rule Act, the NLCA, and the Nunavut Act. Although both Greenland and Nunavut are genuine homelands for the Inuit, there are significant differences in the Home Rule Act, the NLCA, and the Nunavut Act. The major distinction is that Home Rule in Greenland is regulated by a single act of the Folketing, which treats Greenland as a distinct community within the kingdom with limited self-governing powers exercised within the framework of public administration. Two acts pursuing different goals regulate the legal status of Nunavut. Similar to the Greenland Home Rule Act, the Nunavut Act of 1993 is a creature of the Canadian Parliament. At the same time it ensured the creation of a new unit in the Canadian Federation, which was created as a result of division of the NWT. A territory of Nunavut came into being in 1999 with the form of public government. Importantly, the proposal for legislation establishing Nunavut and the recommendation and timing of the Nunavut Act were included in a political accord that was itself the result of long-term Inuit struggle for control over their homeland. Furthermore, the Inuit of Nunavut Nagoti 41 aided the NLCA, passed by the federal parliament in 1993, which ensured, among other things, Inuit title to approximately 350,000 square kilometers of land, of which 35,257 square kilometers include mineral rights. From the beginning, the NLCA, as an Inuit achievement, intended to embrace all possible Inuit interests. Its premise was that the Inuit should regain control of their lands and their lives. As Inuit leader Jack Anawak has stressed, what we have been seeking throughout the years is the acknowledgement by the Canadian government that this was, and is, our land and that we have the right to control what happens to that land, our homeland. 38. The NLCA is the largest comprehensive land claim settlement in Canada that is constitutionally recognized. Through the NLCA the Inuit receive defined rights and benefits in exchange for surrender of any claims, rights, title, and interests based on their assertion of an Aboriginal title anywhere within Canada. 39. Arguably, this controversial extinguishment provision of the NLCA brings some features of colonial legacy to the agreement. To some extent, features of the colonial legacy can also be observed in the Home Rule Act, the content and even the title of which highlights the continuation of voluntary colonialism. During the interviews I conducted, many of the Inuit respondents considered the extinguishment clause to be a weakness of the NLCA and an indicator of a continuing colonial mentality. As one of the key negotiators of the NLCA noted, it was hard for the Inuit to accept this clause. It is colonial legacy when you have to give up a certain thing in order to get something. This is not the Inuit way. That certainly is from another form, because the federal government adopted that policy, because that mentality of colonialism is always there. We had to accept it, but in return we said, give us Nunavut government, give us Nunavut territory. 40. When the Home Rule Act was introduced in Greenland, the Inuit greeted it enthusiastically and with high expectations. Notwithstanding the limited nature of the proposed Home Rule arrangement and its basis in Danish legal and political paradigms, Greenlanders were reluctant to reject it. As Lars Emil Johansson, then the member for Greenland in the Danish parliament, said in the first reading of the Greenland Home Rule Act in 1978, the people of Greenland have not been given many such possibilities, and we cannot afford to say no. 41 The Greenland Home Rule Act is less comprehensive than the NLCA and the Nunavut Act. It contains 20 sections with narrow and some 42 times vague provisions. 42 If the Home Rule Act is ambiguous partially as a result of its brevity, the Nunavut documents, despite their length and comprehensiveness, are also subject to problems of interpretation, largely because of their complexity. 43 In many ways the NLCA has failed to meet the expectations of the Inuit. It has been criticized for being a male-biased document that does not pay enough attention to women's rights, nor does it sufficiently take into consideration socio-economic rights and guarantees, or provide an adequate base for dealing with modern challenges of globalization or economic self-sustainability. 44 Critics are also concerned that via the NLCA the Inuit surrendered too much of their land in exchange for cash payments rather than negotiating a more solid block of Inuit ownership rights. There were also problems with providing an authentic translation of the NLCA into Inuttitut, a language that does not always have words to express some Western legal and political concepts. Consequently, it is a challenge for unilingual Inuttitut-speaking beneficiaries of the agreement to understand its provisions. This situation is exacerbated by the absence of a unanimous interpretation of the NLCA by Nunavut's various governmental institutions. 45 Other irritants include the lack of a mechanism to make a reluctant federal government fulfill its obligations, the continued dependence on Ottawa for economic support, and the existence of a federal ministerial veto over the decisions of Nunavut co-management bodies. In December 2006 a dispute that had been ongoing since 2001 between the Nunavut Tuengavik Incorporated, the Government of Nunavut, and the Government of Canada regarding the update of the implementation contract for the NLCA led to the $1 billion lawsuit against the federal government for breach of contract. In its lawsuit the NTI pointed out that the NLCA have been breached in a number of areas including inadequate funding for the Nunavut co-management bodies and for hunters and trappers organizations, failure by the Crown to provide funding for implementing the NLCA after the initial 10-year period following its coming into force, non-conclusion of Inuit impact and benefit agreements and lack of funding required for their realization, non-implementation of a general monitoring plan and of Inuit employment obligations. Clearly, the agreement and its implementation is a work in progress and a lot of effort will be required to bring it to fruition. 46 To more fully answer the question of the extent to which the Greenland Home Rule Act and the NLCA and Nunavut Act have resulted in 43. Effective self-government, it is important to examine the underlying principles of these documents. The constitutional place of Greenland in Denmark and Nunavut in Canada. Continuous evolution of Greenland's home rule system since its introduction in 1979 and the increase in political aspirations among Greenlanders towards obtaining greater independence in managing their own affairs have outstripped the provisions of the Greenland Home Rule Act of 1978. Greenland's development and, to some extent, its jurisdictional capabilities went far beyond what was imagined to be possible within the Home Rule arrangement and even the Danish constitution, as they were generally interpreted in the late 1970s. Currently, the recommendations of Greenland's Commission on Self-Governance for a partnership agreement between Greenland and Denmark with regard to Greenland's right to self-government point to the need to expand autonomy of the island. 47 Nonetheless, there will still be continuity between the new partnership agreement and the principles of the Home Rule Act. The work of the Commission on Home Rule for Greenland was influenced by three major considerations. First, a political solution was required that would strengthen the ties and relations between Greenland and Denmark. Second, the solution chosen had to be one that could be implemented easily by Greenlandic authorities, given the shortage of qualified Greenlandic manpower. Finally, all the arrangements arrived at had to conform to the Danish constitution. 48 For these reasons, among others, the Commission envisioned that preserving the principle of the unity of the realm should be the core element of the introduction of Home Rule. 49 Consequently, Chapter 1, Section 1 of the Greenland Home Rule Act reads, Greenland is a distinct community within the Kingdom of Denmark. Within the framework of the unity of the realm, the Greenland Home Rule authorities shall conduct Greenland affairs in accordance with the provisions laid down in this Act. 50 Under Home Rule, Greenland had to remain a part of the Kingdom of Denmark, and sovereignty belonged exclusively to the Danish authorities. The latter delegated to the Home Rule authorities part of their jurisdiction in those areas that relate exclusively to Greenlandic matters. 51 Thus, the Greenland Home Rule Act was limited by the principle of national unity. The Act reflected a respect for the interests and solidarity of all parts of Denmark as a unitary state. 52 This principle was 44. Designed to prevent the establishment of a Danish federation or the transformation of Home Rule to the independent state of Greenland. Despite this principle, some commentators consider Denmark as a federation or a special legal construction. In the opinion of Bogi Eliassen, Denmark today is not a unitary state but a structure with some federative elements of divided power. 53 This assessment is based on the divided Danish kingdom's membership in the European Union and Denmark's partial vesting of its sovereignty in that organization. Other factors contributing to the characterization of the Danish kingdom as a federation are a result of the legislative powers of the parliaments of Greenland and the Faroe Islands, and Denmark's inability to independently fulfill international obligations in spheres that are in the Home Rule Authority's jurisdiction. Frederik Harhoff states that Denmark is neither a federation, nor it is a confederation. 54 But, in his words, Home Rule of Greenland and the Faroe Islands has made an illusion of the unitary state. Denmark today is a rigsfællesskabet, or a form of commonwealth. It is a tripartite community of separate and autonomous parts, each with their own original powers, but with continental Denmark as the hegemonial part with residual authority. 55 J. Berglund Nielsen claims that the present Greenland Home Rule should be developed into something which could be labeled as extended or sovereign home rule with a new relation to the Danish realm, based on principles of commonwealth or unionism. 56 These varied opinions raise the issue of the status of Greenland's home rule within Denmark. Is Greenland just an integral part of the unitary state, following the Danish constitution, or is it an autonomous entity that has altered the unitary nature of the Danish state? Brian Holt Larsen argues that the Greenlanders became a self-governing nation within a de facto federal government. 57 If that is true, Greenland should have a status generally comparable to the subjects of federal states. Joel notes that the Home Rule government has wider governing power than an Australian state or Canadian province. 58 However, this is not evident from the legal framework of the Home Rule Act. Clearly, it is hard to classify Greenland's status within Denmark. Formally, it is an integral part of a unitary state with autonomous authority in a limited number of areas. Greenland's enigmatic constitutional status may be clarified with the introduction of a new partnership agreement on the island's self-governance, as it would move towards an extended form of political autonomy. Possibly on the basis of legal options available in the 45 framework of this new partnership, Greenland eventually might even opt for independence. Clarity on the legal status of subnational entities within a unitary or federal state is crucial for the scope of powers to be delegated to those entities. Unlike Greenland's enigmatic position within Denmark, Nunavut received the defined status of a territory. 59 This means, among other things, that it is a distinct member of the Canadian Federation. This fact is important for understanding Nunavut's legal status. There are significant differences between the powers exercised by a province and those exercised by a territorial government. Provinces derive their power from Section 92 of the Constitution Act, 1867, while territories receive theirs from specific federal statutes. This situation is analogous to that of Greenland, which is subject to centralized Danish legislation. However, much of the power they wield is not provided for by statute, but is in place due to discussions between political leaders in the north and the federal minister. In some cases, This is given formal recognition in letters of instruction, while in others it is instituted through unwritten understandings between the federal and territorial governments. 60. This is in contrast to the Danish practice, according to which statutory regulation is formally required, but sometimes the regulation simply recognizes a practice that had already been introduced by Greenlandic authorities. In the meantime, the Nunavut position as a new territory in the Canadian state is unique. Thomas Isaac argues that, Nunavut represents something more than a traditional territory and something less than a province. 61. This is analogous to Greenland's status within Denmark. It exercises more powers than other administrative units of the Danish realm but has less jurisdiction than most subjects of federal states. 62. Without a doubt, Greenland and Nunavut are distinct societies within Denmark and Canada. This distinctiveness was incorporated into legal and political governance arrangements for both societies. The legal status of arrangements for Greenland and Nunavut. What is the legal status of the territory of Nunavut and Greenlandic Home Rule? There is no easy answer to that question. The Nunavut Land Claims Agreement is constitutionally recognized, whereas the constitutional status of the Nunavut Act and the Greenland Home Rule Act is marked by ambiguities. Both systems of governance are based on the 46. Delegation of secondary powers from the state to the authorities in Greenland and Nunavut, partially with the purpose of alleviating central or federal responsibilities for remote lands. 63. Greenland Home Rule was created on the Commission on Home Rule's assumption that an irreversible division of the constitutional powers would be incompatible with the unity of the Danish realm. A truly independent legislative or executive power for Greenland, therefore, could not exist within the framework of the Danish Constitution of 1953. 64. Following the principle of national unity, Home Rule of Greenland could not be based on an international treaty or amendment to the Constitution. As Lisa Lyck concludes, Home Rule is a cooperation model. In other words, autonomy is not given by Constitution or by international agreement. 65. The Greenland Home Rule Act is an ordinary statute of the Folketing that formally can be amended by unilateral action of that body. As Harhoff states, from a strict constitutional legal point of view, all legislative and administrative powers are still vested solely in the Danish Parliament and the Danish government, the theory being that powers have been only delegated to the two Home Rule authorities subject to unilateral withdrawal by Denmark at any time. 66. Similarly, the Nunavut Act, as a federal statute, is subject to the direct jurisdiction of the federal parliament. Nunavut does not have the authority to amend the provisions of this act. Loreen Nowlankard notes that, as a delegated authority, the Nunavut territorial government only derives those powers which the federal government chooses to delegate to it. The federal government retains the ultimate authority to rescind the delegation or to alter the powers. 67. Furthermore, according to Section 28 of the Nunavut Act, the Governor-in-Council can override Nunavut's legislation. 68. It is also questionable whether the two Greenland members in the Folketing and the two representatives from Nunavut in the Canadian Parliament would be able to exert much influence over the legislature's decisions. 69. However, there is a remote possibility that the Danish and Canadian governments might be tempted to restrict unilaterally the Greenland Home Rule Act and the Nunavut Act. 70. Although the Nunavut Act is not a mini-constitution of Nunavut, the territory itself attracts constitutional protection because Nunavut was created as an integral part of the Nunavut land claim settlement, which is constitutionally recognized. As is the case for other comprehensive land claims agreements in 47. Canada, the NLCA is entrenched in the Constitution under Section 35 of the Constitution Act, 1982. 71. This section recognizes and affirms existing Aboriginal and treaty rights of Aboriginal peoples in Canada, and by treaty rights includes rights that now exist by the way of land claims agreements or may be so acquired. 72. Analyzing the Nunavut Agreement in principle, Isaac points out that the Inuit have held consistently that the creation of a Nunavut territory is the core demand for the Inuit agenda, with the claim as a means of attaining it. Therefore, because the creation of the territory is an integral part of the agreement, the territory itself will become constitutionalized. Once Nunavut is created, it could not be dismantled unilaterally by the federal government. 73 Gallagher Mackay discussed several options for constitutional recognition of Nunavut. She suggested, among other possibilities, that Nunavut is entitled to constitutional protection because of the status of both the Land Claims Agreement and the Political Accord as treaties between the Crown and the Inuit acting collectively as a people. 74 The arguments of both Isaac and Gallagher Mackay ultimately sanction the constitutionalization of the Nunavut territory. Furthermore, as Kevin Gray argues, the creation of a new political entity lessens the importance of entrenching the Nunavut government into the constitution. 75 In Greenland's case, there are various opinions on the necessity of amendments to the Danish constitution and directions for possible constitutional reforms dealing with Greenlanders' rights and status of their home rule. As Menenengwake Kleist suggests, there might be an option of solving the problem of repealing the Greenland Home Rule Act by taking the matter to the Danish Supreme Court. Another option is that Greenlanders demand that Denmark acknowledge constitutionally their right to nullification, which would allow Home Rule authorities to nullify laws and orders issued by the Folketing and the Danish government. They could also demand constitutional acknowledgement of Greenland's right to veto laws proposed by Denmark that cover the whole Danish Commonwealth. Demanding these rights would require changing the Danish constitution, which is theoretically possible. 76 Some observers argue that the Greenland Home Rule Act does, in fact, get constitutional recognition. Thus, Harhoff stresses that, despite the fact that Home Rule is not mentioned in the Danish Constitution Act, Faroese Home Rule, which preceded the current Constitution of 1953, was believed 48 to be in conformity with the old Constitution of 1915, and this view was also taken when Greenland achieved Home Rule in 1978. Thus, the Home Rule Act serves partly as a constitution for Greenland, although some parts of the Danish constitution, notably those relevant to the Danish currency, the monarch, and rights and freedoms, are still common to the entire Danish realm and are therefore in force in Greenland. 77. Harhoff notes that the Greenland Home Rule Act is believed to alter the Danish constitution by customary practice and, thus, the Home Rule Act has the status of a constitutional appendix that is superior to ordinary Danish legislation but remains under the Danish constitution. 78 If one accepts Harhoff's argument that the Home Rule Act is customarily entrenched and by itself the Act is valued as a constitutional appendix, then there is no need for amendment of the Danish constitution. As Harhoff has noted, Home Rule authorities perceive their autonomy as a permanent and irrevocable institution. 79 In contrast, in the opinion of J.B. Nielsen, the Danish constitution needs to be revised because a new relationship between Greenland and Denmark has to be developed. 80 Elaine Ward states that there is a need for some reform of the Danish constitution in order to entrench the Inuits' special rights. She further notes that there is also need for a separate constitution for Kallalit Nunaat enacted and passed by the Greenland Home Rule authorities, and officially recognized by the Danish government. 81 This constitution could begin with a Bill of Rights section, which could be a model constitutional document for other indigenous groups around the world who wish to exercise self-government short of complete political independence from a larger nation-state. 82 Ward's ideas have merit, but it can be argued that although the constitutional inclusion of indigenous rights may strengthen the legal position of the indigenous group, even constitutional provisions could be amended. The functionality of Greenland's system and protection of Inuit rights in several international documents ratified by Denmark mitigate the necessity for development of a separate Bill of Rights for the Inuit. The development of Home Rule transcended the enigmatic constitutional status of the island, the assumptions of the Home Rule Commission, and the limited legal scope of the Greenland Home Rule Act of 1978. Thus, in its recommendations the recent Commission on Self-Governance focused on the development of possibilities for the new partnership between Greenland and Denmark in conformity with exist. 49. Legal options, constitutional principles, and limits of the present constitution. 83 As mentioned above, the NLCA as a modern treaty is constitutionally protected. However, the question remains whether the Nunavut Act and the NLCA provide the Inuit with effective self-government. Nunavut has a public government, but to a certain degree it also reflects Inuit self-government where the Inuit culture, traditions, and language are supported by existing governmental institutions. 84 However, various commentators and interviews with Nunavummiut indicate that there is no unanimous view on the nature of Nunavut governance today. Some scholars believe that, despite some weaknesses, the new Nunavut government will mean de facto self-government for the Inuit. 85 At the same time, as one Akitsarak Law School student has noted, because of the shortage of skilled Inuit in the top bureaucratic positions, Nunavut does not mean self-governance for the Inuit. 86 Provisions of the NLCA or Nunavut Act per se do not identify the Nunavut settlement area or created territorial public government as self-government. By the terms of the settlement of the NLCA, the Inuit surrendered only their Aboriginal title to land and waters anywhere within Canada and adjacent offshore areas. In the NLCA there is no explicit reference to the right of self-government, and so this right must be assumed to continue. Under current federal policy, the Inuit could negotiate a self-government arrangement separate from the NLCA. 87 However, the Inuit chose to negotiate the NLCA and the form of public government as distinct from Aboriginal self-government. The Inuit chose the public governance model because it leaves them room to negotiate a separate self-government arrangement in the future if demographic or economic circumstances not in the Inuits' favor should arise. As a senior official with the government of Nunavut notes, this is a public government, which gives us a role in overall administration of governance of Nunavut, but there is no guarantee that Inuit are always going to be a majority, so we retain our right to self-government. 88 There is no ultimate answer to the question whether the current system of governance in Nunavut, which at many levels is interlinked with the land claim settlement, has led to the realization by the Inuit of their internal right to self-determination. During interviews, many Nunavut residents regarded the NLCA and the Nunavut Act as the results of political necessity and, partially, the Inuit right to self-determination. In other words, it is debatable whether the settlement of the land claim and the creation of the territory and government of Nunavut have led to 50. De facto or de jure expression of Inuit self-government. 89 As Isaac points out, the fact that the territory of Nunavut does not have its own constitution and is ultimately subject to federal jurisdiction makes the prospects for Inuit aspirations of self-government rather grim. 90 The question of a separate Inuit self-government arrangement is not on the agenda of Nunavut today. The system of public government takes into consideration Inuit culture and values. However, Nunavut governance is a dynamic concept that might someday lead towards Inuit autonomy. Similar to the experience of Greenlanders, the self-governance of Nunavut's Inuit will be shaped by the development of their homeland. As Gray puts it, any notion of self-government or self-realization for the Inuit ultimately relies not on the present wording in the agreement, but on participation at the community level as well as higher regional levels. 91 An examination of the legal status of the Greenland Home Rule Act, the NLCA, and the Nunavut Act reveals that these documents have different legal characteristics that result from distinct Danish and Canadian legal traditions and approaches to Indigenous peoples' rights and policies towards the Inuit. The different government systems in Greenland and Nunavut result from the fact that the creation of the territory of Nunavut was a basic precondition to the settlement of the NLCA. Such was not the case in Greenland. Thus, in Nunavut, a dual system of governance policies has developed. One is for the Inuit beneficiaries of the NLCA, the other is for all Nunavummiut but with clear consideration of Inuit values and interests in the framework of public governance. The Inuit of Greenland represent the nation of Greenlanders, and thus the system of home rule governance is not oriented towards special endorsement of the Inuits' indigenous rights. At the same time, the Greenland Home Rule Act, the NLCA, and the Nunavut Act share some similarities stemming from legal perceptions, influenced historically by colonial mentalities in the Danish and Canadian constitutional systems, including the imposition of foreign, positivist notions of governance and constitutional principles on the Inuit. Although none of the acts examined in this chapter explicitly guarantee Inuit autonomy per se, Greenland and Nunavut have a virtual form of self-governance based on the de facto development of home rule and the public government systems, rather than on the juridical provisions of the Greenland Home Rule Act, the NLCA, and the Nunavut Act. The development of Greenland's home rule since its introduction. 51. In 1979 has proved that this virtual autonomy is rather effective. However, forthcoming changes to home rule show that legal recognition of self-government is crucial for defining an equal partnership with Denmark and the ability to exercise a higher level of autonomy. It is too early to assess the effectiveness of the Nunavut public governance as virtual self-governance. 92. There is an undeniable element of paternalism in Canadian and Danish policies towards the Inuit of Nunavut and Greenlanders, though how much is a matter of opinion. Charles J. Marisick states that federal restrictions create a significantly modified version of self-government. The paternalism bleeds through. 93. Some critics have characterized Greenland's home rule as overdeveloped, a product of Danish colonial presence on the island. 94. Greenlander Avia Ajid Linge notes that Greenland did not go through a process of decolonization, even mental decolonization. She claims that her people were thankful to be colonized and were taught that they are the best colony in the world. Thus, despite more than 2 decades of home rule, the system is still characterized as the outcome of the Danish presence in Greenland since 1721, and Greenlanders still feel overshadowed by the Danes. 95. In many ways the functioning of the Greenland Home Rule Act, the NLCA, and the Nunavut Act is shaped by Danish and Canadian legal cultures. However, these documents should not be regarded as legal fictions in the alien clothes of Danish and Canadian jurisdictions because of their positivist and unknown features. Greenland's and Nunavut's governance systems are dynamic entities evolving towards greater Inuit involvement in the management of their affairs, despite the legal frameworks of the Greenland Home Rule Act, the NLCA, and the Nunavut Act. Another important factor is that Inuit values and traditional ways of life are changing over time and intersecting with the perceptions of other societies. However, incorporation of indigenous traditional knowledge and concepts into Western-based legal formulas and legislation remains a challenge. Furthermore, for the Inuit of Greenland the Home Rule Act is a political compromise between Danes and Greenlanders. Similarly, the Inuit of Nunavut had to compromise with the federal government and the Canadian public in political and practical terms. Therefore, the NLCA was divorced from the quest for self-government, and the Inuit accepted the concept of public territorial governance as more palatable to the Canadian system. The provisions of 52. The Greenland Home Rule Act, the NLCA, and the Nunavut Act reflect the compromises that underpin these documents. Finally, some may argue that Nunavut and Greenland continue to display voluntary colonialism because of acceptance of paternal practices and Inuit dependency on the dominant societies. I have argued that the Greenland Home Rule Act, the NLCA, and the Nunavut Act retain some features of colonial policies. However, the Inuit need time to regain control of their lands and their lives. In this context, the Greenland Home Rule Act, the NLCA, and the Nunavut Act are good starting points towards Inuit self-determination. They are tools whereby the Inuit can take matters into their own hands and create their futures. 96. It is debatable, however, whether these documents should be interpreted as a realization of this goal. 97. They are an expression of the Inuit people's right to internal self-determination and show that constitutional protection of autonomy, though important, is not a precondition for its effectiveness. Regardless of the limited powers entrenched in the Greenland Home Rule Act, and the comprehensive provisions of the NLCA and the Nunavut Act, the success of autonomy will depend on its progress in practice. Because of the dynamic development of the governance system in Nunavut and expected devolution deal with the federal government, there might be a shift towards more political autonomy of the territory, just as has happened in Greenland, where steps in the development of extended self-governance have already been taken. This self-governance does not stem only from the fact that the Inuit are a majority of the population in Greenland and Nunavut, as some authors claim, 98 but derives significantly from active Inuit participation in the political life of their territories and the work of home rule and public governance bodies. 3. Territorial government versus home rule, the structure of Nunavut's and Greenland's institutions. When we can make our own laws, we will be able to do things to make our lives better. We'll be able to communicate with the government in Inuttitut. I think the Nunavut government will be there to deal with issues that Inuit feel are important. As long as we hold tight to what we believe and as long as the Nunavut government responds to the needs of the people, Inuit will be a lot stronger. John Amago Alec, Inuit leader. The Greenland Home Rule Act, the Nunavut Land Claims Agreement, and the Nunavut Act provide the legal frameworks of governance, but the normative dimensions of these documents are not sufficient for understanding the internal developments and political institutions of Greenland's home rule and Nunavut's government. The effectiveness of Nunavut and Greenland governance systems and their institutions stems largely from thoughtful and active Inuit participation in politics. The autonomy of Greenland and Nunavut should be viewed through the policies of Greenlandic parties and Nunavut Inuit organizations. In this chapter I will examine the example of Greenlanders' democratic participation in the formation of home rule institutions and the processes used by the Inuit of Nunavut for building their governance institutions. In both cases, I consider the pillars of Greenland and Nunavut political organization to be a driving force behind the normative and functional exercise of autonomy. Political factors are shaping the nature of Inuit governance and internal politics and are affecting the Nunavut and Greenland legislatures and their legislation. 54. Political organizations, parliaments, and governments of Greenland and Nunavut. The Nunavut system of public governance is distinguishable in many ways from that of Greenland. Nunavut has a nonpartisan system in which political parties are absent during territorial electoral campaigns, whereas Greenland's system is rooted in party activities. The operations of Nunavut's and Greenland's institutions are grounded in the Canadian and Danish parliamentary systems, but their respective institutional practices are different, and this affects the composition and activity of the legislative and executive branches. There is also a difference between the decentralization efforts of Nunavut's governance and Greenland's centralization priorities. Finally, the details of Nunavut's system of governance have been crystallized in the numerous reports of the Nunavut Implementation Commission. 1. Although the 4-volume report of the Home Rule Commission on Greenland was ambiguous on the subject, the report from the Commission on Self-Governance paid special attention to the restructuring of public administration and the structure of Greenland's internal administration. 2. I will address some of the particularities of Greenland's party system and Nunavut's nonpartisan system in forming and operating the legislative and executive branches of governance. The Greenland Home Rule Act of 1978 created a quasi-parliamentary system, consisting of an assembly elected in Greenland, to be called the Landsting, and an administration headed by a Landsstyre. 3. In a similar vein, Nunavut has a legislative assembly and an executive council. 4. Greenland's political parties play a key role in the composition of the legislative and executive institutions of Home Rule. They emerged before the enactment of the Greenland Home Rule Act and became significant during the first election to the Landsting in 1979. 5. The leading Social Democratic Party, Samut, which since 1975 had developed into a broad political movement with a common ideology and strong support among hunters, workers, and fishermen in the majority of villages and towns, influenced the course of development of Home Rule and its institutions. 6. As Dahl notes, the Samut Party dominated the Home Rule process, formulated the political demands on the Home Rule Commission, and became the most powerful social force in Greenland, especially after winning the first election, in 1979, and gaining the majority of seats in the Landsting. 7. Samut was originally united under slogans such as, the New Policy, Development in Greenland on Greenlandic Terms and Greenlandization. 8. Its ideology is based on 55. Moderate socialism combined with nationalism, and its political goals include the creation of a Greenlandic society with equal rights and opportunities for all, the creation of an educational system of international standard, the protection of the environment and a sustainable exploitation of the living resources, and the continuation and strengthening of an open democratic leadership of the country. 9. Samut favors independence from Denmark, but only on the condition of economic sustainability. 10. Although Samut was and remains the dominant party in Greenland, other parties developed as well. Chief among them was the Atasut Party, which arose from the moderate liberal political movement of the same name. 11. Oriented towards interdependence and strengthening the solidarity between Greenland and Denmark, the Atasut Party supports home rule for Greenland within the framework of the realm. It believes in increasing independence for Greenland without complete severance from Denmark. 12. Finally, the socialist Inuit Ataqatigiit Party has to be mentioned. Shifting from opposing home rule to accepting it, the party today stands for the values of Greenlandic ethnicity and promotes the process of developing Greenlandic autonomy. 13. In 2002, Greenland's political landscape changed with the creation of a new center-right party called the Democrats. 14. In addition to the existing parties, a new self-government network group, INASIC, was launched on May 1, 2006 to facilitate cooperation among national organizations and Greenlandic parties in strengthening the independence movement. 15. In Nunavut, political parties are not prohibited as such, and to some extent they are relevant to Nunavut's politics, especially during federal elections. 16. In other words, political parties are not completely absent from territorial politics, but they are not the main method of organization in territorial election campaigns. 17. Where candidates contest seats as independents. The lack of a party system works in Nunavut's small, geographically remote communities. 18. Although Greenland's conditions are similar to those in Nunavut, its population has embraced the political party system. The practice of party politics in Greenland is common for municipal and parliamentary elections. 19. As Dahl has commented, it is difficult to imagine how Greenland's parliament and government would have handled the many complicated issues if each member had only been elected on the basis of his personal character and local status. 20. The greater role of party politics in Greenland compared to that in 56. Nunavut can be explained by different levels of development of political systems and varying levels of political consciousness among the Inuit. Historically, the Inuit of Canada's eastern Arctic had a less developed political system than that of Greenlanders. 21. As Graham White and Jack Hicks point out, only 30 years before the Nunavut Implementation Commission presented its recommendations on a political system for Nunavut, the federal government introduced an oversimplified notion of democracy to the Inuit. Several men in the community will have been nominated to each position on the council. In order to decide which of the men should have those positions, an election was held. Each person was probably asked to write, on a slip of paper, the name of the man he or she wished to have on the council. When the voting was completed, the votes were counted and the man who received the highest number of votes was declared elected. It is unlikely that everyone voted for the man who was elected. People do not all think the same way, so they are not likely at all to want the same man in office. The man who won the election was elected by the majority of the voters. The minority of the voters had to accept the decision of the majority. This is what democracy means. 22. In contrast, Greenland's political system emerged long before the introduction of home rule. 23. Ultimately, a well-educated Greenlandic political elite arose that was eager to use the party system to take power from the Danes. In the opinion of André Legari, the Inuit of Nunavut have traditionally opposed the introduction of the party system because of their preference for expressing their opinions individually instead of subordinating themselves to party discipline. 24. As White, analyzing the case of the Northwest Territories, has noted, idealism and pragmatism both play a role in the rejection of parties. Political parties are rooted in, perpetuate and accentuate social divisions, and many in the NWT wish to avoid what they see as the harmful, artificial divisions that parties would engender. Those who believe in the superiority of the NWT's consensus government recognize that it would not survive the arrival of political parties. On a more pragmatic level, native leaders believe that the introduction of parties could imperil native unity and deflect attention and energy from the attainment of their primary political goals in the realm of land claims and self-government. In interviews, several indicated distaste for the structures of conventional party discipline. Auth. 57. ERS, citing the Yukon experience, argued that in a small legislature a party system would mean the exclusion of too many of the best members from the cabinet. 25. White's observations are true for the governance of Nunavut, which, though distinct from that of the Northwest Territories, of which it had been a part, in many ways follows the practices and traditions of that administration. The institutions of Nunavut and Greenland are rooted in different types of parliamentarism. Nunavut has a structure similar to the institutions of the other Canadian territories and has adopted a model of British parliamentarism modified to northern realities. Greenland's quasi-parliamentary system stems from Danish parliamentarism and party politics. 26. As Greenlander Finn Lynch notes, in Greenland traditionally, people vote for the person, not for an ideology. The Danish pattern, however, of voting for a party program, has clearly gained ground. Thus, one can well maintain that political behavior in Greenland is becoming less and less Greenlandic and more Danish. 27. Although the Greenlandic members of the Folketing have traditionally joined with Danish parties that are ideologically familiar, the two present Greenlandic members of the Folketing have formed a new separatist group with Faroese politicians in the Danish parliament. 28. The parliamentary systems of Nunavut and Greenland are particularly influenced by the electoral structure. All residents of Greenland 18 and older are eligible to vote. 29. Usually the parliament is elected for a 4-year term. 30. At the time of writing, the most recent election had been held on November 15, 2005. Table 3.1 compares election results from 1979 to 2005. The data show that the Social Democratic Samut, which has governed alone or in a coalition for the period in question, has held a stable leading position. 31. Inuit Ataqatigiit is also stable, but Atasut's support has decreased. The Democrats' Party has seen its popularity rise with the most recent election. As Dahl states, the political picture in Greenland has changed. It is a mistake to rely just on the party labels. Now much depends upon the person in charge of the political party or fraction thereof. 32. This is evident from the success of the Democrats, which has profiled itself on a conservative status quo policy that is more often characterized as being populist. 33. The 2002 election was a turning point for Greenland, bringing significant challenges to the stability of Greenland's political system. 34. Samut. 58. Formed a new government in coalition with Inuit Ataqatigiit. 35. However, the coalition did not last. One major disagreement between the two parties concerned Samut leader Hans Inuksen's recruitment of political friends for positions without following the required procedures. 36. One such recruit was Jens Liberth, a top civil servant, who set off another controversy when he hired an Inuit healer to cleanse the government offices of evil spirits. He also urged the 600 bureaucrats under his control to use methods similar to his to improve the strained relations between Greenlanders and the Danes. 37. As a result of this political crisis, a new coalition government was formed on January 17, 2003, between Samut and Atasut. 38. This partnership did not last either. Samut broke the coalition because the leader of Atasut, who was the Minister of Finance, refused to resign over a budget miscalculation of approximately $16 million. 39. On September 13, 2003, Samut and Inuit Ataqatigiit again formed a coalition government. 40. Further wrangling followed in September 2005, when an audit commissioned by the Premier reported that 2 members of the land sting were freely using public money to cover entertainment expenses for themselves and their family and friends. 41. According to the official statements, the Premier called an election because Samut could not come to terms with its coalition partner on a new child benefit program, but in reality the split had its roots in the expenses scandal. 42. Following the 2005 election, no two parties could team up and have a majority of seats in the Landsting. Thus, Samut formed a new three-party Northern Lights coalition with the Inuit Ataqatigiit and Atasut 43 as Dal states. All the initiatives from the coalition partners are focused on the process of stronger Greenland self-government. They aim to create the basis for increased societal equality, economic and political self-reliance, environmental sustainability, and greater Greenlanders' influence at various levels of society. 44 Since 1999, elections have been conducted under a new electoral system. Greenland was turned into one electoral district, instead of being divided into 8 ridings, as was formerly the case. 45 This system was introduced to deal with the regional approach of many members of the Landsting, who were often also mayors of their electoral districts. Turning Greenland into one electoral district allowed voters to evaluate politicians on the basis of their national political accomplishments, rather than judging their roles in local communities. 46 Reformers hope that this system will strengthen Greenland's nation-building process and that the country will become a unified entity. 47 At the same time, this electoral system is criticized for being unfair to rural areas, which, because they are less populated than urban centers, may get fewer seats in the Landsting. 48 In order to provide representation for all regions in the Landsting, the Commission on Self-Governance recommended the introduction of an arrangement whereby the most distant districts with small populations be allowed to become individual constituencies, while the rest of Greenland is kept as one constituency. 49 Greenlandic political parties have been instrumental in shaping the institutions of home rule and further developing self-governance. Despite some political cataclysms in Greenland, they have created an enduring political system that works well for the realization of Inuit interests. Although the Greenland Home Rule Act was not framed as a special form of autonomy for the Inuit population, the political parties make up for this deficiency by promoting a truly Greenlandic agenda. In Nunavut, several Inuit organizations, including Nunavut Tuingavik Incorporated, the Qikiqtuni Inuit Association, the Kivalliq Inuit Association, and the Kitikmeot Inuit Association, safeguard and advance the rights of the Inuit in the 3 regions of the territory. 50 These groups are important political actors and have wide responsibilities under the NLCA and participatory powers in the bodies of public government. One of the most powerful organizations is the NTI, which, in dealing with the implementation of the NLCA, represents and protects the interests and rights of the Inuit of Nunavut. 51 The NTI is the main channel for communication between the regional Inuit Associa. 60. Shins and the government of Nunavut. It is a watchdog for the implementation of obligations by all the parties under the NLCA. Due in part to the NTI's powerful position, its relationship with other decision makers has been worn thin, and tensions have arisen between it and the government of Nunavut. 52 Because of its mandate and 100% Inuit representation, the NTI creates a second level of governance in Nunavut, a corporate governance along with the public one. This phenomenon does not exist in Greenland. Acting on behalf of the Inuit majority with a broad mandate, Nunavut regional organizations and the NTI are a powerful political force. 53 Considering the small size of communities and the familiarity of the population with potential members of the government and the Malays, the indirect role of these organizations in forming public opinion is as important as party agitation is in Greenland. The parallels with Greenland on this point are telling. Despite the absence of political parties in Nunavut, the influence of Inuit organizations has had a role similar to party politics in Greenland. In both jurisdictions, the Inuit majority in the legislative and executive bodies hold Inuit interests paramount. In contrast to the Landsting's 4-year term, the Nunavut Legislative Assembly has a term of no longer than 5 years. 54 After much debate, Nunavut leaders decided that the territory would consist of 19 single-member electoral constituencies. 55 Nunavut's first election took place on February 15, 1999, the second on February 16, 2004. 56 candidates put their names forward for the 19 seats, running as independents. The operation of the Nunavut legislature is akin to that of the Legislative Assembly of the NWT, which functions according to a consensus model. 57. It includes some uniquely northern modifications to the standard Westminster parliamentary system. 58. Political parties are absent in the Legislative Assembly of Nunavut, which allows each MLA to vote according to his or her wishes. However, approval of each decision requires consent by the majority of the MLAs. After a general election, MLAs choose from among themselves the Speaker, the Premier, and the Cabinet. The Premier of Nunavut is the head of the executive government. 59. In Greenland, members of the Landsting elect the Cabinet, which is headed by the Premier. 60. To be elected, the Premier and Cabinet ministers need a simple majority in the Landsting. Since the introduction of the Home Rule arrangement, it has so far always been the leader of the party with the largest number of seats who becomes the Premier after closing a formal or informal agreement with. 61. One or more parties with whom the leader can form a majority. In Nunavut, the Cabinet is drawn from the members of the legislature. In Greenland, most of the members of the Cabinet are members of the Landsting, although this double role is required only for the Premier. In this sense, the legislative and executive branches overlap. Furthermore, in both jurisdictions, the Cabinet and the Premier, who assigns the ministerial portfolios, play the most important roles. Significantly, in Nunavut there is hardly any ideological divergence among members of the Legislative Assembly along party lines. By contrast, members of Greenland's parliament can be placed along two continua. One is the more or less traditional left/right split with regard to economic policy. On this continuum, the Atasut has been to the right, Samut just left of the center, and Inuit Ataqatigiit to the left. In the past decade, positions have become more complex. IA has moved to the right on issues such as privatization and market orientation, but kept to the left on redistribution. Atasut has moved to the left. They compete with Samut in relation to protecting subsidized private business in the primary sector. The second continuum concerns relations with Denmark and the Danes. Here the position of the traditionally pro-Danish Atasut has been taken over by the Democrats. The IA is at the nationalistic end of the continuum. It has legitimized its movements along the left-right continuum under the slogan "We need to get competitive to gain independence." Nunavut's and Greenland's parliamentarians are not divided along structural lines, as members of the legislatures almost always form the cabinet. Finally, there are few cultural demarcations in these institutions because of the small number of non-Inuit representatives. 61. Unlike the situation in the NWT and Greenland, the Nunavut Implementation Commission recommendations considered the possibility of directly electing the Nunavut Premier. 62. That would have added a new element to the Westminster system of parliamentary government, but it did not materialize in the first and second territorial elections. However, during the 2006 Nunavut Leadership Forum, the question of direct election of the Premier was raised by several MLAs, and Iqaluit City Council passed a resolution in its support. 63. It is questionable to what extent Nunavut's governmental institutions are adapted to Inuit culture or Inuit Qajimajatuqanjat, Inuit traditional knowledge and values. The MLA from Uktamiut, David E. Kakrialu, commenting on the first election in Nunavut, noted that although elections were not part of Inuit Qajimajatuqanjat, Inuit have embraced. 62. Elections as a measure of public support throughout the land claims process and the steps leading to the creation of the new territory. Elections allow us the means to govern ourselves. 64. Elections, though unknown in traditional Inuit life, are now recognized as an important part of modern Inuit society. Compared to that of Landsting, the representation of women in Nunavut's legislative assembly is low. 65. The issue of gender parity in the Nunavut legislature has been a matter of much academic and public discussion and many NIC recommendations. 66. The NIC suggested legally guaranteeing an equal number of male and female members. Such a step would have made the Nunavut legislature the first parliament in the world with guaranteed gender parity, but voters rejected this proposal in a referendum. 67 Greenland's experience shows that a significant representation of women in politics is possible without a legislative requirement. It is probable that over time women will form half of the Landsting's members. Despite the failure of the Women's Party to win any seats during the election of December 2002, and the party's dissolution in 2004, there is general acknowledgement that Greenlandic women are assuming political positions previously occupied by men. Moreover, women are becoming more outspoken in political debates and decision-making forums. 68 Current successes are the result of a long process of recognition, marked by a struggle against male-dominated traditions inherent in the system, and hampered by numerous obstacles. 69 In Canada, Inuit women actively participate in Inuit organizations such as the Inuit Circumpolar Council, Pakchuuti, and the NTI, but that participation has not yet translated into substantial representation in the legislature. 70 There is a significant difference in the number of members in the Landsting of Greenland and the Nunavut Legislative Assembly. This difference stems from the fact that Greenland's population is greater than Nunavut's. However, in 2006 a report of the Nunavut Electoral Boundaries Commission, created by the Nunavut Legislative Assembly, proposed the redrawing and adjusting of the boundaries of several electoral districts in the territory to better reflect the interests of Nunavut communities. The Commission's considerations were based on a number of factors. One was to create equitable representation for all Nunavummiut and especially to accommodate concerns of small communities that share the MLA with a larger community and thus often feel underrepresented in the territorial legislature. The Commission proposed to increase the total number of 63 electoral districts to 23. The Legislative Assembly of Nunavut will make final decision on this matter, with implementation of the change being probable. 71 Both Nunavut's and Greenland's legislatures are unicameral, which is typical for the parliaments of small entities. Presiding over the legislatures is a chairperson of the Landsting in Greenland and a speaker in Nunavut. 72 The Legislative Assembly of Nunavut sits at least once every 12 months. Meetings of the Landsting are normally held twice during the parliamentary year, once in the spring and once in the autumn. 73 In designing the future Nunavut government, the Nunavut Implementation Commission underlined its essential principle, decentralization. This was dictated by several realities, including the availability in the villages of employable people for clerical work and the fact that life in Iqaluit was seen by some as unhealthy compared to that in the settlements because of social problems. 74 Decentralization has been implemented gradually in Nunavut over the past few years with the expectation that it will yield benefits in the long term. According to evaluations, residents of Nunavut saw decentralization as a more IQ form of government, and as expensive but necessary for Nunavut. 75 Although it is questionable whether decentralization itself is an Inuit value, an attempt to incorporate IQ into the government of Nunavut on a decentralized basis is in keeping with the approaches of indigenous culture, which is more receptive to decentralized power. 76 No plans were undertaken to introduce Inuit traditional knowledge into the administration of home rule. Greenland's system was originally centralized, with the major administrative powers concentrated in the capital, Nuuk. This led to a further increase in centralization and intensification of communications by Greenlandic politicians with their Danish and foreign counterparts. Greenlandic senior officials were criticized for spending too much time outside Greenland, which resulted in less attention being paid to the internal political structures of Greenland. 77 It also was the reason for the further alienation of elitist Greenlandic politicians from populations in the settlements. The government of Nunavut's dispersion in major Nunavut communities, instead of being concentrated entirely in the capital of Iqaluit, was a cornerstone of the NIC policies, which recommended that the size of the headquarters staff in the capital of Nunavut be kept to a minute. 64. To allow for the sharing of government employment opportunities with as many communities as reasonably possible, the community that is selected to be the capital should not continue to be a regional center as well. Regional offices located in that community should move out to other communities in that region, and, A high level of program, financial, and personnel authority and accountability should be delegated to managers and officers at the regional and community level. 78. Despite such efforts, the administrative power of the government of Nunavut has become de facto re-centralized in Iqaluit, where major decisions are made. 79. Moreover, some observers have questioned the benefits of decentralization policy. 80. Political parties shape the structure and priorities of the legislative and executive powers of the Home Rule government and influence the movement of Greenland towards extended autonomy. Regardless of the existence of an effective system of Inuit parties in Greenland, and the lack of such a system in Nunavut, the institutions of Home Rule and public governance are characterized by the Inuit majority and oriented towards the expression of Inuit needs and concerns. At the same time, the institutional and structural elements of Greenland's and Nunavut's legislatures and executive derive from a foreign neocolonial authority, which raises the issue of their legitimacy among the Inuit. Can structures created under neocolonial power facilitate the development of autonomy or self-government among the Inuit? The Inuit and other institutions of governance in Greenland and Nunavut. Although Greenlandic politicians and cabinet ministers were the titular heads of government, if you peeled back that layer, they were all blonde blue-eyed Danes running the new Home Rule government. Dennis Patterson. Initially, enthusiasm for Home Rule was somewhat dampened by recognition of the dominance of Danes in the new government. Now, happily, the Greenlandic involvement can boast more depth. But, this cosmetic autonomy speaks to the fears of Inuit leaders who are determined, sooner rather than later, to fill the depth charts of their own public sector. 81. The people of Nunavut and Greenland were given political power. 65. Over their affairs by way of democratic representation in the Western pattern of legislative and executive institutions. Consequently, the main elements of the legislative assemblies and executive bodies of Nunavut and Greenland mimic Canadian and Danish institutions of governance, which contradict Inuit traditions. 82. That raises the question of whether Inuit representation and participation in these institutions in itself transforms these institutions into agents of genuine Inuit self-governance. Interviews with residents of Greenland and Nunavut show that traditional Inuit structures, values, or ways of decision-making have had minimal effect on modern institutions of governance. 83. The government of Nunavut has been following what is known as the Bathurst Mandate or Pinnisuak Tavut, that which we've set out to do, our hopes and plans for Nunavut, a 5-year plan developed by the first government in 1999. This document emphasized the importance of the introduction of the Inuit Kajimajatukanjit in public administration for developing responsive, open, and accountable government. 84. In the updated version of Pinnisuak Tavut, the government of Nunavut reconfirmed that IQ is essential to the management of local affairs and elaborated that Inuit societal values are particularly relevant for the conduct of affairs of the government. These values include the following. Inyukatajiatsi Arnik, respecting others, relationships, and caring for people. Tuanganarnik, fostering good spirit by being open, welcoming, and inclusive. Pijatsirnik, serving and providing for family and/or community. Ajikatajianik, decision-making through discussion and consensus. Pila Maxernik/Pijariuxernik, development of skills through practice, effort, and action. Pilarikatajianik/Akajiktajianik, working together for a common cause. Kanaktuernik, being innovative and resourceful, and Avititnik Kamachurnik, respect and care for the land, animals, and the environment. 85. Although these values serve as guiding principles for delivering programs and services by the government of Nunavut and they are incorporated into policy documents of the territorial government's departments, it is hard to evaluate their implementation in practice. Most of the interviewees in Nunavut were not able to identify which Inuit values form the basis of the modern administration of their government. In 2003 an Elders Advisory Council, Kadamagiat, was created to provide advice to the government on how to use the IQ and how to incorporate Inuit language and culture into its operations. 86 In 2005 the government appointed a second Katamasiat to advise departments on their efforts to incorporate traditional Inuit values into their daily operations. 87 There are numerous discussions and studies on making the IQ the living policy of Nunavut governance. 88 Of importance in this respect is an innovative Wildlife Act containing a set of IQ principles to guide wildlife management in the territory. 89 Despite these developments, the question of how to incorporate IQ into the institutional governance culture of Nunavut and how to make it workable within various governmental departments is a challenging one. 90 The Inuit of Greenland and Nunavut do not share or show cultural affinity for the institutions that have been imposed upon them. This reduces the legitimacy of these structures among the Inuit. Not accidentally, in 2001, 10 Mlays on the midterm leadership review of the Legislative Assembly of Nunavut stated, "The government system is not our traditional Inuit way of life. If we had governed in an Inuit way, we would not be judging whether our leaders are good or not, as we are doing in this review. But, although we have agreed to use the parliamentary system, we still want to be incorporating Inuit Kajimajatukanjit within the system. We are using a system that contradicts our way of life, because we have to abide by legislation now. But we want to get our values back into government." 91 Although in both jurisdictions the Inuit constitute a majority of parliamentarians, and this should guarantee the priority of Inuit interests and direct the policies of these institutions towards Inuit needs, from a legal standpoint Nunavut's and Greenland's legislative and executive bodies are non-indigenous structures. It is hoped, however, that indigenous elements will constantly be incorporated into these institutions by the pervasiveness of Inuit culture at a functional level. Ideally, the fact that Inuit representatives, who are known to the Inuit communities, form these bodies should increase their legitimacy among the Inuit population. There is the threat that the significance of these bodies will be undermined by growing class stratification of Nunavut society, a situation paralleled by the clash between the Greenlandic elite and the unskilled working classes. At the beginning, home rule was based on the Danish model with excessive paternalistic control. As the system evolved, it incorporated 67 more Greenlandic elements, including Greenlandic politicians. In Nunavut, notwithstanding that the adopted system of public government has had to follow and operate within Canadian principles of parliamentary democracy, there are attempts to blend Western traditions with Indigenous values. However, similar to the situation in Greenland, which relies heavily on the Danes for assistance, the newly created territory of Nunavut had to accept help from mostly non-Inuit Canadians. In both jurisdictions, presence of Indigenous elements in governance structures is not sufficient, despite the Inuit majority. The adjustment to the patterns of Western modes of governance puts genuine Inuit self-governance, in the form of public governance, in question. The incorporation of traditional Inuit knowledge, values, and decision-making practices at the juridical level could make a difference in the status of the legislative, executive, and other institutions in Greenland and Nunavut. The Greenland Home Rule Act and the Nunavut Act do not stipulate Inuit institutions of governance. However, the establishment under the NLCA of several regulatory tribunals and co-management agencies with equal federal government and Inuit participation brings some Indigenous element to Nunavut's wildlife, fishery, land, and water resource management. 92 In legal terms, these agencies, often referred to as institutions of public government, provide comprehensive co-management regimes and do not substitute for Inuit self-governance institutions. 93 Moreover, since these agencies' mandate is mostly advisory, and they share joint decision-making powers with federal representatives, their capacity for autonomy is limited. 94 Currently the land and its resource management is one focal point of the Inuit political agenda. Thus, according to Jack Anawak, even negotiations on the NLCA were seen by the Inuit primarily as the means to preserve our relationship with the land and ensure our survival as a people in the larger society surrounding us. Therefore, we are also taking economic and political means to control what happens on our lands. 95 Some Inuit of Nunavut view their responsibility for the management of their lands as self-governance. Thus, Paul Kwasa, the Tungavik Federation of Nunavut's chief negotiator, stressed that what we wanted all along and what we negotiated is a series of management regimes that will eventually give us self-governance. 96. Non-Aboriginal scholars maintain different views on this issue. White suggests that by allocating important government functions in the realm of land and resources to public governments, it could be argued. 68. That the boards derogate from the possibility of full-fledged self-government. They constitute a new genus of institution within Canada's federal system, existing at the intersection of the three orders of government. 97. Gurston Dax states that these agencies represent the fullest measure of self-determination and political control over important aspects of their lives and, because they are created within the NLCA, these agencies are protected under Section 35 of the Constitution Act, 1982. 98. Nonetheless, the constitutional protection of the above-noted boards, and Inuit participation in their management, does not make them Inuit institutions of self-governance or provide for the fullest measure of self-determination. Thierry Rodin, in his analysis of these agencies, states that their powers are more akin to self-management than to self-determination. Thus, such co-management can be seen as essentially a process of co-optation because it allows Inuit participation only in accordance with Western standards. 99. Similarly, Gallagher-Mackay finds that co-management boards in many respects resemble Southern technocratic institutions, aside from providing translations of their documents into Inuktitut and a high level of civility, they hardly can be distinguished from other boards working in the North. 100. So far, the main goal of co-management boards, to incorporate traditional Inuit ecological knowledge into administration and policy decision-making, has not been sufficiently met. Formed on the basis of Western legal structures, these agencies of public government are foreign to Inuit institutions. At a functional level, despite Inuit participation, these bodies operate within the bureaucratic frameworks of the Canadian state. 101. Nunavut's and Greenland's bodies of public governance include other agencies, the evaluation of which might shed some light on the nature of autonomy. In order to provide a link between the central state and the Inuit homelands, the former is represented by the Commissioner in Nunavut and the Riksombudsman in Greenland. The Riksombudsman is the chief of the Danish administration in Greenland. The position's functions include control over local legislation and matters concerning family law, reporting to the Danish Prime Minister's office, planning and organizing meetings between Home Rule and Danish authorities, overseeing referendums on Danish-Greenlandic relations, organizing visits in Greenland by the royal family, and recommendations for royal distinctions. The Riksombudsman is also in charge of elections in Greenland to the Folketing. 102. The Commissioner for Nunavut, appointed by 69. The Governor-in-Council, acts in accordance with any written instructions given to him or her by the latter or by the Minister of Indian Affairs and Northern Development. 103. The role is similar to that of a provincial lieutenant governor. There is no clause mandating that either the Commissioner or Riksombudsman should be Inuk. 104. Whereas in Greenland the High Commissioner is usually a Dane, in Nunavut, according to the existing practice, the Commissioner is Inuk. 105. As in Greenland, the Commissioner's role is mostly ceremonial, the Commissioner does not interfere in the running of the Legislative Assembly. Other offices of state in Greenland and Nunavut include the police and court systems and various committees in Greenland representing the Danish administration. 106. Since 1995 there has been a Greenlandic Ombudsman, known as the Parliamentary Commissioner for Administration. 107. The Ombudsman hears complaints about administrative actions as part of the task of creating more openness in public administration. 108. He or she also submits an annual report on the office's activities to the Landsting. 109. However, since the office of Parliamentary Commissioner was inspired by the Danish Ombudsman institution and was created following Western tradition, it is seen by the Inuit as alien to their tradition. 110. The degree of autonomy and effectiveness of Greenlandic and Nunavut institutions is in part determined by the competence of administrative personnel. Since its introduction, the administration of Greenland has overcome enormous challenges, including adapting to the modified Danish model and dependency on Danish civil servants and know-how. 111 Because of the ambitions of Greenland's political elite, Home Rule authorities took over powers that they could not effectively wield without qualified Danish manpower. Though a new generation of Greenlanders is replacing Danish personnel, the administration of Greenland still has to deal with frequent exchange of employees, insufficient and unclear political goals, and ethnic differences. 112 Underdeveloped infrastructure, financial dependency on Denmark, insufficient economic resources, the significant size of the public sector, a shortage of skilled and educated workers, and social problems all hamper the administration's functioning. 113 As well, there is a gap between younger educated Greenlanders and uneducated, unskilled workers and hunters who would prefer to follow the traditional ways of life. To this are added the ambitions of the Greenlandic elite to manage in the context of modernization and globalization. 114 To reduce the size of the public sector. 70. The Commission on Self-Governance suggested regionalization, redistribution of jurisdiction and responsibility to the regions, restructuring of cooperation with the Home Rule authorities. Reform of the administration of municipalities, including the introduction of consolidated framework legislation and incorporation of a proximity principle, which would bring performance of public tasks and the public authority closer to Greenlanders. 115 At the time of writing, Nunavut is encountering many similar problems. The government of Nunavut is better staffed now than it was at its inception, but it's clear that many employees still don't know what they're doing, and that some departments are still suffering from the effects of decentralization. 116 The Nunavummiut are facing the challenge of building up a cohort of Inuit civil servants. Potential employees come from a generation of Inuit who often lack the required qualifications and are ill-prepared to work for the government. 117 During the early days of Nunavut, the shortage of trained Inuit to staff government positions led to the recruitment of Kalanate. 118 To increase the Inuit labor force within the government and improve Inuit training, an affirmative action clause was included in the NLCA. Article 23 of that agreement requires that the level of Inuit employment within the government of Nunavut be increased and maintained at a representative level, that is, that the level of Inuit employees within the government should reflect the ratio of Inuit to the total population in the Nunavut settlement area. Thus, about 85% of government personnel should, in time, be Inuit. 119 The extent of the challenge is revealed by the fact that the government hopes to have 56% Inuit employment by 2010. 120 The government faces substantial difficulties in implementing Article 23 because of the shortage in financing for Inuit employment and training programs. A long-running dispute between Nunavut Tuangavik Incorporated, the government of Nunavut, and the government of Canada over a new 10-year implementation contract for the NLCA has also hindered bringing the requirements of Article 23 to fruition. In its December 2006 lawsuit against the federal government, the NTI emphasized that, as a result of the Crown's failure to develop Inuit employment plans and to fund not only initiatives to increase Inuit employment in the territory to a representative level but also measures that would provide a basis for realistic employment plans to guarantee Inuit employment in the federal and territorial public service, the Inuit have lost approximately $130 million per year in direct employment income. 121. 71. Affirmative action was not introduced as a legal measure in Greenland. Danes still hold some key governmental positions, and government services and written administrative tasks are carried out mostly in Danish. 122 There has been ongoing debate over the dominant use of the Danish language in public administration and the job promotion preference given to Danish-speaking experts compared to equally qualified Greenlanders. 123 There are also suggestions to use Greenlandic as the language of the Home Rule government, the Landsting, and municipalities. 124 Furthermore, Danes still dominate high-profile positions in business, education, and central and local administrations in Greenland. 125 Greenland faces the problem of attracting a large number of inexperienced Greenlandic and Danish specialists, who often do not know how to deal with internal issues. There are growing demands to hire more native Greenlandic-speaking representatives for leading positions to close the era of Danish bosses. 126 in Nunavut, where the use of Inuttitut, Inuinnaqtun, English, and French is intended to reinforce the policy of multilingual administration, efforts have been made on the legislative level to protect both Inuit languages spoken in Nunavut. However, because Inuttitut is used by the majority of the Inuit of Nunavut and Inuit government employees, there are suggestions to introduce bureaucratic Inuttitut as a working language among senior government officials by 2008. 127 Expectations of perfect Inuit self-governance are unrealistic for Greenland and Nunavut. Unique northern and cultural circumstances and the borrowing of Western patterns of governance and administration throw into question the viability of Inuit autonomy. The issues of how to address cultural differences and entrench Inuit traditional values and methods of decision-making into a developing Nunavut system of public governance and home rule in Greenland are of great concern. Notwithstanding more than 2 decades of home rule in Greenland, and approaching a decade of Nunavut governance, the Inuit in both regions are being challenged by the transition and adjustment to non-Inuit values of other societies and the risk of being overwhelmed by Western concepts of governance. Without further strengthening the role of Inuit in the public service and continuous incorporation of Inuit values and practices into Western forms of governmental institutions, these bodies will not be able to promote Inuit self-governance or maintain clear legitimacy among the Inuit population. The Inuit are developing their policies in the framework of Western institutionalism. This may work for cooperation with other levels of government and the international community, but it raises the question whether Inuit represent a 72. In the alien Western institutions of Nunavut and Greenland can mean true Inuit self-governance. Currently, the Inuit are repeating the schemes and stages of development of former colonial societies, with some cultural modifications. Nevertheless, because of the Inuit majority and active participation in regional policy making, Greenland and Nunavut governance systems are evolving towards a greater measure of Inuit autonomy. For the jurisdiction of Greenland and Nunavut, the competence of Greenland and Nunavut in the justice system, international and foreign affairs, and security and defense policy is limited because these are areas where jurisdiction is traditionally non-transferable to subnational entities. Yet, the evolution of Greenland's system of governance shows that Greenlandic authorities aspire to acquire more responsibilities than those envisaged by the Home Rule Act. As was indicated by the report from the Commission on Self-Governance, if the island is to expand its autonomy and conduct its own affairs on a more independent basis, jurisdiction in these spheres must be reconsidered. The report examines issues such as natural resources, the economy and business development, human resources, foreign policy, security, language, and the central internal administration of Greenland within the framework of a new partnership between the island and the Danish realm. A similar tendency can be seen in Nunavut, with the gradual devolution of powers from Ottawa to the territory and evolution of the public government system. Nunavut is expected to conclude a devolution agreement with the federal government by 2008, dealing with policy areas such as the environment, governance, social issues, economic development, northern science, and circumpolar affairs. 2 of particular significance will be Ottawa's transfer to Nunavut of responsibility for the management of oil, gas, and mineral extraction on Crown lands and offshore. The further development of Nunavut as a political entity will likely mean that the territorial government will be drawn into taking over more responsibility in what are presently non-transferable areas of jurisdiction. One could argue that, as a part of Canada, Nunavut should not be 74. Treated differently than other territories. If Nunavut is granted special autonomous status or rights, the other northern territories may wish to pursue the same course. Nunavut has a stronger argument than other territories do for political autonomy by virtue of the Inuit people's right to self-government under domestic law. The Inuit of Nunavut retain their inherent right to autonomy despite the establishment of a territory with public government and settlement of the Nunavut Land Claims Agreement. Moreover, according to developments in international law and practice, the Nunavut Inuits' right to autonomy finds justification as an emerging right based on an outgrowth of the right to self-determination. 3. The jurisdictional challenges of Nunavut are in some ways similar to those of the Northwest Territories and the Yukon Territory because of the specifics of Arctic political geography. However, Nunavut has a unique governance system, the effective implementation of which requires more flexibility in the boundaries of its legal jurisdiction. In addition, Nunavut has a different legal status than the other territories. For example, as we have seen, the territory of Nunavut was created as an integral part of the NLCA settlement, which is constitutionally entrenched. Thus, the territory itself attracts constitutional protection, and in that respect it is different from other Canadian territories. If Nunavut is distinct from the other territories, it is also different from the 10 provinces, some of which are seeking to expand their jurisdiction in non-transferable areas and may already have expanded this jurisdiction in practice. The concerns of Nunavut are unique. Most Canadian provinces and regions are not located in the high Arctic, and thus are not affected by such harsh climate conditions or issues arising from the assertion of Canada's sovereignty in the north. The way of life and cultural existence of most of the residents of the Canadian provinces are not so deeply and directly affected by issues such as global warming or pollution in the Arctic. In contrast to Greenland, which is looking to expand its jurisdiction into traditionally non-transferable areas, Nunavut presently has other priorities. It has to deal with serious problems with regard to the process of institution building within its government. Proper implementation of the NLCA and exercise of existing jurisdictional capacity in areas such as education, social, linguistic, economic, and business development are currently more important than increasing capacity in the areas of non-75 transferable jurisdiction. The experience of Nunavut reveals the necessity of a pragmatic approach to the scope of jurisdictional opportunities. One must ask whether there is a need for the formal legalization of Nunavut's or Greenland's jurisdiction over non-transferable spheres. There are, for example, informal methods of participation in international forums. Problems may be addressed through meetings, conferences, the establishment of advisory councils, and so on. However, informal approaches are not always either sufficient or efficient. Thus, there is a need for some legal capacity of Nunavut and Greenland in traditionally non-transferable jurisdictions on matters that directly affect the development of these territories and the existence and livelihood of their citizens. This does not mean that Nunavut or Greenland should have an absolute say or veto in these areas. Control could, for instance, be exerted in specified spheres by means of an agreement with the federal or central government. I am not suggesting that Nunavut or Greenland should receive preferential treatment and expand their jurisdiction simply because it is desired by their residents. More political autonomy is not necessarily the best solution. Moreover, most subnational entities with autonomous status enjoy no powers whatsoever over the justice system or foreign affairs, including security and defense policy. But it is important to be aware of the particular jurisdictional challenges that arise from Nunavut's and Greenland's unique situation and geopolitical position in the Arctic. Some legal capacity of Nunavut and Greenland in non-transferable areas would not threaten Canada's or Denmark's sovereignty in general. Thus, jurisdiction in these areas can be partially transferred to subnational entities in the process of devolution. The scope of self-governing jurisdictions can vary, and may include competence in, among other things, social, educational, language, health, transportation, intergovernmental activity, mineral rights, resource management, environmental, and economic areas. The effectiveness of Nunavut public governance and Greenland home rule depends substantially on the breadth of powers delegated to them. The legal framework for home rule and Nunavut's jurisdiction is pulled in two directions, by Inuit people's aspirations and their expectations for effective governance, and by the realities of the isolated North and pragmatic expectations for future economic sustainability. Theoretically, both Nunavut's and Greenland's systems should become economically self-sufficient and responsible for managing their own affairs. Yet, this is hard to achieve in practice without significant financial assistance from 76. The national authorities. The problem is that both Greenland and Nunavut were created without an adequate economic base. If there is no adequate economic development and no local financial base sufficient to fund all areas of Greenland's or Nunavut's jurisdiction, then how can the idea of expanded political autonomy, which means self-reliance, be reconciled with the need for substantial funding from the national governments? This economic reality throws into question the viability of home rule/self-governance in the Arctic and makes the concept of autonomy rather artificial. Continued financial dependency on Canada and Denmark is the key factor prohibiting true self-determination and self-governance in Nunavut and Greenland. Both regions are struggling to develop a self-sufficient economy, which would considerably reduce Danish block grants to Greenland and Ottawa's transfers to Nunavut. The Commission on Self-Governance considered the question of Greenland's self-sufficiency and mitigation of the island's dependence economy as a core prerequisite for effective autonomy. In particular, the Commission outlined that foreign trade, restructuring of the public sector in correspondence with the economic capacity of the society, citizen-wide input into the economy, and developing a sustainable economy and businesses may allow Greenland to achieve economic independence and replace the block grant. 5 economic analyses of Greenland's dependency show that there are several obstacles to Greenland's economic self-sustainability and that the island continues to be highly dependent on Denmark in terms of financial transfers and the economic expertise of Danish advisors. 6. However, the Commission on Self-Governance is optimistic about a self-sufficient economic future for Greenland. High expectations for economic sustainability derive from wind, solar, oil, gas, and hydrogen energy production projects, the huge hydroelectric potential of Greenland and possible offshore reserves of oil can eventually make the island a major hydrogen and an oil producer. 7. This can boost economic progress and have long-term consequences for Greenland's future. 8. Likewise, Nunavut's economic viability is vital for the success of the public government. According to the findings of reports on Nunavut's economic outlook by the Conference Board of Canada and the Nunavut Economic Forum, the key elements of Nunavut's economic future include a collective approach to socio-economic development and a focus on economic activities primarily at the community level, a move towards greater self-reliance and more Inuit political and economic control of Nunavut and its environment, integration of Inuit traditional. 77. Knowledge and values in consultation and decision-making, land-based economic activity, and sustainable development with equal importance given to the development of human and natural capital and a wage-based economy. 9. There are both obstacles to and opportunities for the long-term growth of Nunavut's economy, the major part of which is still government employment and government spending. 10. It is expected that, over the next 5 years, development of hydroelectric and wind energy projects and investment in the private sector, especially in mining, will increase. The building of a deep-water military/civilian port in Nunavut is also seen as an important step for the territory's economic development. 11. However, the participation of Nunavummiut, strong political leadership with clear government spending priorities, and dealing with disastrous infrastructure are key to Nunavut's sustainability. 12. The government of Nunavut has taken some steps for economic development of the territory based on the priorities of sustainable development, youth training, education, application of new technologies, innovation and the new economy, investment, export development, and infrastructure. 13. The forecast for Nunavut in 2020, based on strategic directions for building a sustainable economy, strengthening self-reliance, and maintaining diversity, is for a place where Nunavummiut own and manage a strong mixed economy where residents have productive choices for economic participation. 14. The major legal challenge is how to reconcile the idea of self-sustainability and liability with financial dependency on Ottawa. Nunavut hopes to boost its economy by concluding the devolution deal with the federal government, which could help to reduce Nunavut's dependency on Ottawa. 15. In addition to these economic challenges, the legal authority of Nunavut and Greenland is limited by Canadian and Danish legal paradigms, which do not fully take into account the specific interests of the Inuit population. It is possible for the citizens of Nunavut and Greenland to shape their own policies of public/home rule governance, but they can expand their homeland's areas of jurisdiction to a very limited extent. Gradually this challenge can be addressed by the development of Greenlanders and Nunavummiut political consciousness, public initiatives, increased economic sustainability, and socio-cultural predominance. Despite the limits of the competence of the Nunavut and Greenlandic authorities, the evolution of these governance systems inevitably will dictate greater local involvement and responsibility for matters not currently included by their jurisdictional frameworks. To date. 78. The Inuit have used the methods and language of their ex-colonizers to overcome their subjugation. At the same time, they demonstrate how they value their own cultures by their aspirations for self-determination and autonomy. Arctic indigenous peoples may have an image of governance and its institutions that differs from that of their former colonizers. There is a need for greater flexibility and rethinking of the boundaries of the Danish-European/Anglo-Canadian legal imagination in order to adapt to Inuit realities and better serve the aspiration to self-governance. Some features of the Inuit traditional legal order. We are run by coldness and our natural laws. When the white man's law comes to a cold place, it never works out. Because white men don't understand the Inuit, laws today aren't working out. People making laws throughout the North should have Inuit working at it too, not just Kalanak, so that it would be fair to both. Unnamed Inuk. The trouble is that it's so different, it's so dangerous, it's so wrong to impose a foreign alien system on people in a totally different culture. Hans Christian Rafnso, Chief Justice, High Court of Greenland. An examination of the role of the legal institutions of Greenland and Nunavut in developing the right to indigenous autonomy raises the question of whether Inuit societies should develop their own juridical bodies or use existing ones. Because Inuit legal institutions are not well understood, customary Inuit mechanisms of social regulation and control have to be considered in any possible reform in the field. Can Inuit legal tradition sustain the institutions of an independent system of justice or one that is parallel to the mainstream system? Some argue that informal arrangements are the best way for introducing uniquely Inuit forms of social control and legal culture into Greenland's and Nunavut's contemporary legal systems. However, strictly informal approaches are not feasible, as they require a tremendous amount of government and human resources. Others believe the rule of law in Nunavut and Greenlandic societies should generally follow the legal order of their dominant states. For example, despite long debates over whether Nunavut's Human Rights Act was alien to Inuit values, it was passed by the Nunavut legislature because of the necessity and pressure. 79. To follow similar legislation in the rest of Canada. 16. However, this practice does not accommodate concerns of Inuit, who are eager to preserve their traditional ways of dealing with matters of legal significance. Thus, neither view on its own is persuasive. Furthermore, it can be argued that legal recognition of the Greenlandic justice system and Nunavut's Inuit judiciary or legal institutions is possible theoretically if, in practice, it finds strong support in contemporary Greenland and Nunavut societies, and if legal interpretation of the scope of the right to autonomy will encompass more or less independent justice systems for these subnational entities. At the present time, despite their Inuit majorities, Greenland and Nunavut do not embrace separate indigenous justice systems. To understand the possibilities of legal reforms in contemporary Greenland and Nunavut societies, I explore the extent to which lex loci can be adjusted to the system of Danish and Canadian laws and fulfill Inuit aspirations for governance. 17. Traditional Inuit society included a number of lawways or legal ways, that is, methods of social behavioral control and beliefs that functioned as laws and created a basis for Inuit customary, informal, folk, or natural norms of justice. 18. These norms flowed from unwritten rules applicable and transferable within Inuit communities and transmitted through generations. Presently, Old Inuit systems of social control are underused or have disappeared because of colonial practices, exposure to Euro-Canadian culture, and changes in the Inuits' ways of life. Instead, Greenland and Nunavut often copy or adapt to impose Danish-Canadian legislation. What should be done about the gap between Western and Inuit traditional systems of social control? What legal/judicial system would best suit the Inuit? The legal ways of the Inuit are embedded in and dependent upon their culture. Community and independent households shape the structure of traditional Greenlandic and Nunavut societies. 19. Any perception of Inuit traditional norms and order should be evaluated through the prism of Inuit understanding and their socio-cultural patterns of behavior. But relatively few Inuit representatives have expressed their opinion on the subject. 20. Study of the Inuits' traditional legal concepts is also complicated by differences within Inuit groups inhabiting Greenland and Nunavut and is limited by the Euro-American literature's interpretation of these concepts. 21. It is possible to give only a general overview of the Inuit of Greenland's and Nunavut's customary practices that existed prior to the introduction of Western legal culture. 80. An analysis of existing scholarship shows striking differences between Inuit and Western legal beliefs. 22. It also points to the limitations of studying a non-Western social order on the basis of modern law concepts. In trying to apply Western legal categories to the Inuit social order, many scholars have questioned whether traditional Inuit forms of social control can be considered law within the framework of Western legal thought. This questioning has led to different analyses of the existence of law among the Inuit and divergent views of the nature and concepts of their lawways. 23. For example, according to Geert van den Steenhoven and E. Adamson Hobel, traditional Inuit society exhibited minimal legal mechanisms and structures. 24. Others recognize adjudicative mechanisms and legal structures among the Inuit. Norbert Ruland, for example, concluded that traditional Inuit forms of social control had a legal nature and that legal structures were developed among the Inuit. 25. In his opinion, the failure by many observers to recognize that Inuit legal systems of social regulation, practices, and beliefs amounted to legal status reflected ethnocentric bigotry on the part of Western jurists and legal anthropologists. 26. René Fawcett found that the Inuit created a highly complex and holistic system of law and justice. 27. In a similar vein, Norman Hall Andy argued that a traditional system of justice once existed on southwest Baffin Island. He had been shown in Akitsarikvik, a place with a structure made up of a circle of stones, by an elder from Cape Dorset. According to the elder, this was the place where the Great Council met and justice was exercised before the arrival of white people. The last known traditional trial in that area occurred in 1924. 28. Inuit representatives claim that they had a system of law and justice prior to colonization. Susan Inuarik notes that before the Europeans brought their system of law upon the Inuit, they had a system of their own like most of societies. The legends and the power of the elders and shamans were intertwined together to form a very unique system of justice. 29. Similarly, Zebedee Nungak contests the claim that Inuit did not possess any semblance of a justice system before contact with European civilization. That our people lead a nomadic existence in a harsh, unforgiving Arctic environment may lead Kalanate or others to conclude that Inuit did not have a sense of order, a sense of right and wrong, and a way to deal with wrongdoers in their society. Inuit did possess the sense of order and right and wrong. The way it was practiced and implemented may never have been compatible with European civilization's concepts of Jus 81. Tice, but what worked for Inuit society in their environment was no less designed for conditions of life in the Arctic than that of Kalanate was for conditions of their life. 30. Those who claim that Inuit legal mechanisms and structures were underdeveloped generally approach the subject with the preconceptions of Western legal systems. For such observers, it is significant that, as Van den Steenhoven's linguistic analysis concluded, there were no words for crime, justice, and law in the Inuit language. 31. Nelson Grabern suggests that different conclusions about the existence of Inuit legal practices stem from Inuits' variant behavior in the field of law, and their preference for judging each situation of conflict in terms of the particular factors and the personalities of the people involved. 32. Although it is difficult to conceptualize traditional Inuit law from a Euro-American perspective, I have attempted to identify some aspects of traditional Inuit justice and legal concepts by analyzing sources on Inuit social order. 33. Inuit legal culture did not exist in written form, it was elaborated by oral traditions planted in people's minds by elders and shamans and transmitted from one generation to another. According to Greenlander Robert Peterson, the relationship between different households and the relationship between people inside and outside the household structures were regulated by unwritten rules and a strong demand for self-control. 34. As an elder from Rankin Inlet, Mariano Apalarjuk, puts it, the Molygate of the Inuit are not on paper. They are inside people's heads and they will not disappear or to be torn to pieces. It is part of a person. It is what makes a person strong. 35. There was no codification of the Inuit laws as such. 36. The Inuits' spiritual beliefs and rituals formed the basis of their society's moral code. One belief that underpins Inuit legal thought is animaism. The Inuit view people and animals as equal creatures, and ascribe human characteristics to animals. They believe that both humans and animals have a soul, character, and the capacity to think. 37. Consequently, every object, every rock, every animal, indeed even conceptions such as sleep and food, are living. 38. The paucity of legal rules in the traditional Inuit system was compensated for by religious norms that controlled and directed the Inuits' social and economic life. 39. Taboos played the role of regulatory mechanism in Inuit daily life. 40. As E.A. Hobel notes, legal action was rare. 82. Despite the fact that the consequences of sinful behavior may be believed to result in famine and starvation for the entire community. 41. In the traditional Inuit society, custom served as a source of law and rights. According to Ruland, law arose from such sources as the opinion communis and the repetition of precedents. Customary rule protected the individual from the aggressive forces of the environment against the group. Thus, custom was not a biological or instinctive behavior but was a result of empirical thinking initiated by the fear of anything the individual considered beyond him. 42. The rights and duties that emerged had a collective communal rather than an individualistic nature. 43. Public communal opinion had great value in enforcing the lawways, and no one was allowed to break the law without colliding with public opinion. 44. The definition of right and wrong is based on traditional behavior codes, which were governed by common sense, realism, self-criticism and a happy absence of righteousness. 45. E.A. Hobel shows how the postulates of jural significance in Inuit culture shaped such definitions of right and wrong. For example, he notes that, the third basic postulate and its corollary are expressed not in the form of legal injunctions but, on the contrary, as privilege rights. Infanticide, invalidicide, senilicide, and suicide are privileged acts, socially approved homicide. 46. These forms of homicide were legally acceptable in traditional Inuit society and were not regarded as criminal acts. 47. Traditional Inuit society lacked courts, police, penitentiaries, or any other forensic or law enforcement institutions. The administration of justice was exercised by the community, shamans, and headmen who often possessed quasi-legal powers. 48. For instance, by initiating legal action, a reputable shaman could denounce a group member as guilty of an act repulsive to spirits or animals, and could command penance, which in its lightest form meant abstention from food suggested by the shaman. 49. The Inuit traditional system of social control was marked by its flexibility in reaction to conflicts. Inuit laws were oriented towards restoring peace and communal conciliation, rather than exercising justice through punishment. 50. In sharp contrast to the Euro-Canadian definition, traditional Inuit sanctions sought to aid the offender instead of imposing a punishment. As Kai Birkett Smith puts it, in essence it is not the mission of the society to execute law and justice, but 83. Exclusively to restore peace, using this word in the medieval sense of the ordinary, regular course of life. On this basis the settlement may, for instance, combine in killing a man or a woman suspected of witchcraft, for such persons are a menace to the peace of the society. The killing is not, however, a punishment for the practicing of witchcraft, for the society may in the same manner get rid of a man with a wild and brutal temperament, or of old or sick people who are a burden upon the settlement. 51. The determination of guilt was measured, and decisions were reached individually on the basis of the offender's situation and not on the basis of the offense itself. 52. At the same time, R. Peterson points out the distinction between violence and insult in Greenlandic society. In his words, with regard to non-criminalized actions, the interest of both parties was often in efforts to prevent tension from developing into an uncontrolled conflict rather than in indemnifying the victim. In connection with criminalized actions, the reaction was most likely to be revenge. 53. The normative application of traditional Inuit systems of rules and beliefs fluctuated according to the situation. Graburn notes that at different times the members of Inuit society reacted in a different way to the same infraction. Inuit legal actions represented situational pluralism and also differed depending on the season of the year. 54. Inuit vision and application of lawways were determined by specific northern conditions. This implies a special spiritual connection with the wildlife and the land that is not apparent in modern Euro-Canadian law. Ruland notes that for each level in Inuit society there was a corresponding legal system. Internal family disagreements were settled by the family leader. Anything that could disturb the balance of the group as a whole belonged to the Umialik. 55. Inuit forms of regulation or the social order were based on self-control and methods of conflict resolution shaped in accordance with Inuit values and understanding of right and wrong. For example, as Raising notes, for violation of the norm of contributing to the survival of the group, a person could be mocked, gossiped about, ostracized, or castigated in a song, but violations of this nature were not punishable under the Canadian law. 56. Furthermore, emotionality and visual/musical perceptions of conflicts and moral norms, rather than contextual interpretation of legal canons, marked the traditional Inuit system. Postulates with juridical functions were embedded in mythological narratives, song duels, dancing, and music. 57. Generally, individuals avoided acting in contravention of such. 84. Postulates not because of the threat of sanctions per se but because of their desire to be a part of the community. The Inuit language, which is full of metaphorical ways of describing situations and practices and lacks abstract legal terminology, also contributed to the development of normative visual culture in the traditional Inuit society. 58. Alan Pattanaud has described a range of responses to conflict resolution that existed within traditional Inuit societies. Informal methods included gossip, mockery, derision, ignoring, and threat of magical retribution in cases of insult, failing to share food, poor or lazy hunting, theft of property, offenses related to women. Formal methods included song/drum duels, physical contests, banishment, and execution, which might apply in cases such as theft of a woman, witchcraft, insanity, and murder or retributive murder. Finally, there is individual duty, that is, action by an individual required in accordance with custom, which was evident in cases of infanticide, suicide, assisting suicide, and senilicide. 59. These methods of conflict resolution were not based on law enforcement mechanisms in the form of an institutionalized authority. 60. Song duels were of particular significance in the process of conflict resolution and restoration of peace in Greenland and Nunavut. As E.A. Hobel observes, they were used to work off grudges and disputes of all orders, save murder. The song duels are juridical instruments insofar as they do serve to settle disputes and restore normal relations between estranged members of the community, and insofar as one of the contestants receives a judgment in his favor. But like the medieval wager of battle, the judgment bears no relation to the rightness or wrongness of the original actions which gave rise to the dispute. There is no attempt to meet justice according to the rights and privileges defined by a substantive law. It is sufficient that the litigants feel relieved, the complaint laid to rest, a psychological satisfaction attained. The juridical song contest is above all things a contest in which pleasurable delight is richly served, so richly that the dispute settlement function is nearly forgotten. 61. Such traditional dispute resolution acted as a sort of psychotherapy, whereby through recasting the conflict in the form of a song competition, and through dancing and singing, emotions and grievances were released and the confrontation was brought to the public and resolved. 85. Openly and without judgment. 62. The idea was to give the victim and the victimizer a chance to air their frustration in such a way so as not to judge the offender. It is known that society stimulated the free expression of aggressive feelings. Song duels thus undoubtedly had a cathartic value for the individual opponents, and in this particular sense conflicts became resolved. 63. Evidently the main purpose of these duels was to restore peace rather than to exercise justice. 64. According to some scholars, formal song duels did not qualify as a kind of court with the audience acting as the judge, since no judgment was passed nor any of the parties punished. 65. Others argue that during song duels community members fulfilled the functions of a judge. 66. As Inga Cleven further notes, by bringing interpersonal and intergroup antagonisms out into the open in this formalistic way, more overt forms of hostility were avoided, and more importance was attached to their function as punitive remedies for violation of the norms than to their role in preventing a breach in social relations. 67. In addition to their cathartic value, song duels had an ethical significance, and were compared by some to moral lectures. 68. At one time the phenomenon of song duels was one of the most important mechanisms of dispute resolution. Regrettably, with the imposition of Western culture, it has almost ceased to exist. Brian Holt Larson points out that traditional conflict management among the Greenlandic Inuit was based on personal restraint, including suppression of irritated feelings and hostile expressions. Most conflicts were dealt with in an indirect manner, such as talking ill about a person behind his back, covert use of sorcery, or antagonists simply moving away from each other until tempers cooled. 69. Cleven expresses a similar position. Examining the West Greenland Inuit, she notes that social order is maintained not only by external but also by internal controls. Through the socialization process the members of society acquire insight into which behavior society does and does not value. This knowledge can act as a restriction, so that the wish to behave in a manner unacceptable to others either does not arise or is accompanied by so much mental discomfort that the idea is given up, even if the desire to violate the norms is still present. 70. The study of traditional Inuit lawways and methods of social control shows that the Euro-Canadian legal culture is not universal. A system of social order and control based on Inuit practices and customs functioned as something resembling law for traditional Greenlandic and 86. Nunavut societies. There is another image of law, which may be determined by visual normativity and morals conveyed by visual images of normative significance. 71. Perhaps, as Han Peterson notes, we need to consider whether the visual norms and normative visual cultures may be taking over some of the important functions carried out by the written normative culture, creating a minimum of common considerations, values, and demands. 72. According to this view, the traditional Inuit images of lawways and beliefs could be regarded as law by Western jurisprudence. Beginning with colonization, an alien social structure and legal culture were imposed on the Inuit. The adversarial nature of Western legal procedures sits in sharp contrast with the Inuit practices, which are oriented towards reconciliation and the restoration of peace. The clash of legal traditions can also be observed from the differing perspectives on punishment. The clash is a result not just of substantial differences between the modern administration of justice and traditional Inuit legal practices with respect to conflict resolution, but of a gap between two legal cultures, traditions, and approaches to justice. The recognition of this gap raises the question of the cross-cultural transferability of Inuit natural justice and customs to the legal systems of Denmark and Canada. How is the Inuit lex loci reflected in the contemporary administration of justice in Greenland and Nunavut? If Inuit methods of social control and lawways are alien to Western concepts of justice, how can imposed Kalenate legal beliefs fairly and effectively regulate the Inuit? These issues are a crucial aspect in the consideration of Greenland's and Nunavut's autonomy. For a long time, Western culture and institutions of governance have had very little respect for existing Inuit legal traditions. Traditional Inuit legal ways as well as the complexity of lex loci and their effectiveness in dispute resolution challenge this exclusiveness. The existence of this prior system raises the question of whether parallel or independent Inuit judicial and law enforcement institutions should be created or whether it is possible to go back to more traditional lawways in dealing with certain aspects of modern justice systems in Greenlandic and Nunavut societies. Until a few decades ago, the impact of Canadian law on the legal acculturation of the Inuit of Baffin Island has been minimal, because of the fundamental differences in Inuit and Euro-Canadian legal concepts, the insignificant participation of the Inuit in the administration of justice, and their limited understanding of Canada's legal system. 73-4. 87. Example, John S. Mathieson found that in the 1960s the Tununarmiut of Pond Inlet had a knowledge of Canadian laws limited to murder and game regulations, a cloudy understanding of the law enforcement system, and almost no comprehension of the court system. He concluded that, despite more than 40 years of contact with local police and exposure to Canadian law, the Inuit were influenced by these institutions to a minimal extent. The legal acculturation progressed slowly as a result of continued reliance on the traditional Inuit legal system in dealing with property, territorial, and family matters. 74. In the 1970s, Harold W. Finkler revealed an information gap among the Inuit that was impeding their understanding of the concepts and mechanisms inherent to Canadian law, in addition to a lack of Inuit participation in the tasks of formal agencies of social control. 75. Some may argue that Canada is a multicultural society, which absorbs various legal traditions, Western and non-Western, more easily than would the relatively homogeneous society of Denmark. Whatever the merits of that argument, it is apparent that the case of Greenland is different from that of Nunavut. The Danish civil law system is rather inquisitorial, in that it looks for the truth, whereas the Canadian common law system, which is dominant in Nunavut, is adversarial, with judges assessing the evidence. That said, the question of whether the contemporary Greenland and Nunavut systems of governance manifest any difference in making the legal system and administration of justice more amenable to Inuit traditional knowledge and ways of dealing with wrongdoers needs to be addressed. In other words, did the Inuit of these Arctic jurisdictions attain any powers for a greater degree of control over existing legal institutions or possibilities for the creation of an autonomous judiciary in the wake of the creation of Nunavut and the development of home rule in Greenland? The administration of justice of Greenland and Nunavut. Inuit turn to the formal justice system much less than other people, preferring their own traditional methods of working out disputes within their social system. It is important that an administrative framework for justice matters be developed with due regard to the cultural traditions and needs of the Nunavut people. Nunavut Constitutional Forum. To understand the modern administration of justice in Greenland and 88. Nunavut, it is important to explore the nature of colonial legal systems and institutions from a historical standpoint. The legal evolution of Greenland and Nunavut did not parallel the development of law in other parts of Denmark and Canada. Therefore, the contemporary organization of the Greenlandic and Nunavut judiciary shows the unique nature of the administration of justice in these Arctic jurisdictions. Starting with the assertion of Canadian sovereignty in the Arctic at the beginning of the 20th century, the legitimacy of Inuit methods of social control was ignored. 76. Some of the traditional Inuit ways of conflict resolution, peace management, and rituals steadily eroded and almost ceased to exist. In Canada, the national legal system was imposed on the Inuit without accommodation for their cultural milieu. 77. This imposition was achieved largely by the activities of the Northwest Mounted Police, although the courts also played a role. The first murder trials of Inuit under Canadian law demonstrate how the legal system was imposed on them. In 1917, 2 Inuit men, Sinisiak and Uluksuk, were charged with the murders of Fathers Revere and Eliru. In the words of the prosecuting counsel, these remote savages, really cannibals, the Eskimo of the Arctic regions, have got to be taught to recognize the authority of the British Crown, and that the authority of the Crown and of the Dominion of Canada, of which these countries are a part, extends to the furthermost limits of the frozen north. It is necessary that they should understand that they are under the law, that they must regulate their lives and dealings with their fellow men, of whatever race, white men or Indians, according to, at least, the main outstanding principles of that law, which is part of the law of civilization. They have got to be taught to respect the principles of justice, to resort to British justice. The great importance of this trial lies in this, that for the first time in history these people, these Arctic people, prehistoric people, people who are as nearly as possibly living today in the Stone Age, will be brought in contact with and will be taught what is the white man's justice. 78. By contrast, in Greenland, prior to the administration of justice and law reforms in the early 1950s, the colonial dualistic law system made a distinction between Danish law and Greenlandic customary law. Thus, one set of legal authorities administered Danish law and the other, 89, administered Greenlandic law. 79. In accordance with Greenlandic customary law, Greenlanders settled their own conflicts excluding serious offenses. A specific Greenlandic conception of law later became fundamental in the development of the laws and administration of justice in Greenland. 80. Clashes and conflict between Greenlandic traditional lawways and the moral and legal systems of the colonizers led to the introduction of Danish legal patterns. 81. Throughout the 18th and 19th centuries, the Danes tended to consider more and more actions as criminal offenses in accordance with their own cultural views. Nevertheless, the Danes were able to introduce their punitive measures only to a limited extent. 82. A hybrid kind of colonial law gradually evolved. One milestone was the creation in the second part of 19th century of boards of guardians, which, in addition to other functions, kept order, administered law in civil and criminal matters, and acted as special Greenlandic courts. 83. As Jensen points out, although the first legal regulations to be used by the principal councils laid down only a few rules on punishment for theft and other major violations, a Greenlandic practice in the administration of justice gradually developed. Through these courts, it has been stated that, as a starting point, these courts turned to the customary law of Greenland. 84. The dualistic legal system was extended with the law on the administration of Greenland of 1925. 85. Conflicts between the Inuit and Danish cultures and the introduction of new technologies to Inuit daily life had prompted the emergence of new types of crime among the Inuit and increased criminal activity. 86. The collision resulting from the overlapping of the Danish and Greenlandic legal systems, and the need for a common legislative scheme and administration of justice, led to the juridical expedition, which was sent to Greenland in 1948, and the consequent reforms to the administration of the justice system and law in Greenland. 87. Prior to the early 1870s, the Hudson's Bay Company had almost total jurisdiction over law and administration in Canada's eastern Arctic. In 1873, the Dominion government appointed stipendiary magistrates. In addition, the commissioner and each superintendent of the newly established NWMP were entitled to function, by virtue of their office, as justices of the peace. Stipendiary magistrates presided over trials for the vast majority of offenses, although the most serious cases fell within the jurisdiction of one of the judges of a provincial Supreme Court, such as that of Alberta. 88. 90. Major change to the judiciary of the NWT occurred in 1955, when a Superior Court of Record was created. This court was composed of one judge appointed by the Governor-in-Council. Mr. Justice Jack H. Sissons was appointed as the first judge of the Territorial Court. 89. There was also a system of police magistrates and justices of the peace. 90. The work of the Territorial Court under Judge Sissons revealed numerous problems with the administration of the Canadian justice system with regard to the Inuit. 91. By attempting to bring justice to every man's door, Sissons tried to blend Inuit concepts of right and justice into the Canadian system. 92. In his words, if the other culture lacks some concept, allowance must be made for it. Even with a full vocabulary of words, it would not be possible to explain satisfactorily to all Eskimos the importance of some procedures in the white man's legal system. 93. The necessity of adapting the Canadian justice system to Inuit legal practices and the particular conditions of life in the North was obvious. 94. Further, the judiciary of the NWT and later Nunavut attempted to bridge the gap between traditional Inuit and modern ways in the administration of justice. 95. The late 1940s and early 1950s were a time for review and reform of the administration of justice and legal system in Greenland. The topic was considered in the 1950 report of the Royal Commission on Greenland, but the most important milestone in bridging the gap between Greenlandic customary law and Danish law was the work of the Jurex. A member of the Jurex, Agnete Weiss-Benson, notes that the purpose of the expedition was to clarify to what extent Danish law could be introduced unamended in Greenland as a common law for Danes and Greenlanders. 96. The Jurex also aimed to clarify how far it was possible to introduce unity of law between Denmark and Greenland, or at least between Danes and Greenlanders in Greenland. 97. The legislative work was stimulated by the need to place Danes and Greenlanders on an equal footing. 98. In 1951 the Law Reform Committee was created. The committee was guided by the Jurex's findings to prepare legislation within all fields of civil law, in order to abolish the dualistic legal system in Greenland, and to unify Danish and Greenlandic law, as far as possible, but with due consideration of differences in material and cultural conditions between Denmark and Greenland. 99. The work of the Jurex, the Royal Commission, and the Law Reform Committee led to the introduction of the Greenland Administration of Justice Act in 1951, followed by the adoption of the Greenland Criminal Code in 1954. 100. 91. These documents formed the basis for the modern justice system in Greenland. Because of possible changes to the administration of justice in Greenland connected with anticipated expansion of Greenland's jurisdiction in the framework of a new partnership arrangement on self-governance, and the recommendations of the Commission on Greenland's judicial system, including consideration of substantial revisions or amendments to existing legislation, or the enactment of new legislation dealing with Greenland's judicial and penal systems, only some features of the current Greenlandic judicial system warrant mentioning. 101. The Greenland Administration of Justice Act of 1951 abolished the dualistic system of law in the island and made Greenlanders and Danes subject to the same rules. It separated the judiciary from the prosecution and allowed for the appeal of decisions by the Greenlandic courts. 102. As an abbreviated and simplified version of the Danish Administration of Justice Act, it incorporated an important feature: high priority was given to the lay judge institution. 103. Currently, there are 18 judicial districts in Greenland with the magistrate courts of common jurisdiction. 104. Each court has 2 lay assessors without legal training and usually 1 lay judge, who does not have judicial training but who receives short specific training in connection with appointment and current advisory aid from the staff in the Court of Appeal of Greenland. 105. Lay assessors for magistrate courts are elected by the local district council, whereas the lay judge is appointed by a judge from the High Court of Greenland for a renewable term of 4 years. Lay judges work part-time. In addition to the magistrate courts, Greenland's current administration of justice system comprises the appeal instances, the High Court of Greenland and the Danish courts, the High Court of Eastern Denmark and the Supreme Court. 106. Decisions made by the magistrate courts can be appealed to the High Court of Greenland. Its presiding judge is a lawyer, who is assisted by 2 lay assessors. The High Court of Greenland judge is appointed by the monarch, and the lay assessors of the High Court are elected by the Landsting upon recommendation by the High Court judge. 107. The current administration of justice in Greenland is based on the principle of proximity, as the lay judges and lay assessors are recruited from among the local population and speak Greenlandic. 108. The system is less expensive than hiring professional judges, and lay judges are more familiar with the cultural values and linguistic characteristics of 92. Their districts. Consequently, they are more adept at handling cases and make more intelligible decisions for Greenlanders. The magistrate courts try civil, criminal, matrimonial, and probate cases. If a case requires specific knowledge, the magistrate court or one of the parties may ask the Greenlandic High Court to try the case as a court of first instance. 109 Bronsted notes that criminal cases are rarely referred to the High Court. The basic principle behind the Administration of Justice Act and the Criminal Code is that members of the local community, who are familiar with the accused and his background, are regarded as better qualified to act as judges than Danish jurists. 110 The idea was that lay judges and lay assessors would consider the Greenlandic customary law. 111 This trait that the judges were lay people with close connections to the small, widespread Greenlandic communities was in itself a special feature of the culture. The use of Greenlandic lay judges implied that the legislators to a great extent could leave it to the discretion of the judges to take the traditional way of life and ways of thinking into consideration as needed. 112 The Commission on Greenland's judicial system proposed several changes to Greenland's court structure. The division of the judicial districts would be retained. Local district courts would have permanently employed and trained district judges, the number and location of which would be determined on the basis of caseload, infrastructure, and the nature of district. To handle the most complex cases and to provide training and guidance to district judges, there would also be a lawyer-based court of first instance, the Court of Greenland, which would cover all of Greenland and would be headed by a professional judge. Thus, the district courts and the Court of Greenland will jointly handle court functions at first instance, while the High Court of Greenland will be second instance exclusively, and the Supreme Court of Denmark will be the third instance. The High Court of Eastern Denmark would no longer form part of Greenland's system for the administration of justice. Finally, to assist in the appointment of district judges, and, where necessary, to consider their dismissal, the Commission recommended that a council of judges be created, composed of the High Court judge, the Court of Greenland judge, and a district judge. 113 The administration of justice system in Nunavut differs from the Greenlandic system in several ways. Following the Nunavut Implementation Commission's recommendations on the unification of the court system and consultations with the Inuit, and in light of some practical 93 considerations, a single-level trial court was established in the territory to make the formal court system as simple and efficient as possible. 114 The Nunavut Court of Justice came into being on April 1, 1999. As a single-level trial court, it has powers of a superior court of record and the territorial court. 115 Its judges have the status of superior court judges and are appointed by the governor in council. 116 As yet, none of the judges have been Inuk or Inuttitut speakers. This problem has been partially resolved by the work of elders advising the judges, employment of mostly Inuit staff at the court, who are able to converse in Inuttitut with clients, and the role of justices of the peace, also called Nunalingni Iktikchuljet. Most of the justices of the peace are Inuit who have usually not received a legal education. Importantly, in February 2003 Alexina Kublu, an Inuk who is fluent in Inuttitut, was appointed as Nunavut's first full-time senior justice of the peace to the Nunavut Court of Justice. 117 justices of the peace are appointed by the Commissioner in Executive Council. 118 The participation of justices of the peace in restorative justice at the community level is extremely important. They act as a bridge between the judicial system and their local communities. 119 The Nunavut Court of Justice is a circuit court, a flying court that travels throughout the territory, whereas the Greenlandic magistrates are local courts. 120 Taking into account the expense of transportation in the Arctic, unpredictable climatic conditions, and the non-Inuit composition of the Nunavut Court of Justice, the Greenlandic system of magistrates' permanent residence in the community seems to be a more appealing model for the administration of justice in circumpolar jurisdictions. Some authorities note that the model of delivery of justice services via a circuit court is foreign to the Inuit communities. For example, A group of researchers of community perceptions of the territorial court in 1995 found out that the lack of understanding of the role and activities of the court by Inuit residents was the major problem. As one Inuit elder expressed himself, "To me, I find them useless. I am an Inuk and they are all Kalanate. Yes, they deal with some people that have been charged with offenses and they hold court. But those that go to jail never learn from their mistakes. They are sent away to jail, but it does not deter them from repeating offenses once they are back." 121 According to one social worker, this mumbo-jumbo ceremony really has no meaning for people here. They fly away. They take a few people with them who magically reappear 6 months or a year later. It's like justice from another planet. 122 Furthermore, the circuit court has a high 94 rate of acquittals and is known for its delays. 123 In contrast, others point out that a circuit court system provides a bridge to traditional indigenous resolution practices and gives meaning to the representative and public involvement functions of the criminal jury. 124 Similar to Greenland's High Court, there is a Court of Appeal in Nunavut with the powers and rights that the NWT Court of Appeal had at the time Nunavut came into being. 125 The Nunavut Court of Appeal is composed of justices from other territories and provinces, and the court may sit in Nunavut or in any other territory or province. 126 Whereas the High Court of Greenland sits in Greenland. However, at the 4th Annual Northern Premiers Forum, which took place in Iqaluit on November 7, 2006, it was suggested that a Northern Court of Appeal should be established, which would hear appeals on decisions made by the courts in Nunavut, Yukon, and the NWT. If created, this new institution is expected to be more reflective of Northern specifics and would establish a consistent body of Northern jurisprudence. 127 Despite forthcoming law reforms of Greenland's judicial and penal systems, the current Greenland Criminal Code of 1954, which incorporated some unique features of Inuit traditional lawways and customary law, deserves particular attention. 128 Codifying Greenlandic legal practice, the code installed a special system of sanctions that were determined by a global assessment of the offender's individual and social situation at the moment of conviction. 129 The goal of the Greenland Criminal Code is not retribution but rehabilitation. For the same reason, in this document the words "will be sentenced" are used instead of the words "will be punished." 130 The code does not contain provisions concerning insanity. 131 It includes extensive possibilities for altering decisions made by retrying cases. 132 And reflects the community's condemnation of criminal behavior, regardless of the cause of crime. 133 The drafter of the code, Werner Goldschmidt, underscored that this document has solely been based on systematic observation of concrete legal reactions and on information as to the geographical and social background of the decisions made. Thus the code is an attempt at expressing the pattern of behavior of the legal authorities in legal terms. 134 As it is based on Inuit legal tradition, which doesn't promote punishment but seeks to eliminate conflict and put forward a more restorative view of justice, the Greenland Criminal Code sanctions are not measured by the gravity of the crime. Judges are given broad discretion to impose a wide variety of sanctions on the basis of the individual offenders. 95. Personal background, and can freely choose between a number of sanctions. 135 Created by the Greenland Criminal Code of 1954, the Arctic Peace Model, which aims to restore social harmony, could work for small isolated communities, but it does not accommodate contemporary Greenland's realities. 136 The Greenlandic system of law and justice has come under increasing scrutiny, and in general the advantages of codifying Inuit customary law have not been convincingly demonstrated. 137 The Greenland Criminal Code has been criticized for giving lenient sentences, as rapists and other sexual offenders are not given more severe sentences than, for instance, thieves. 138 The Commission on Greenland's Judicial System, which recommended revisions to the 1954 Code, proposed to maintain its fundamental idea of rehabilitation as the basis of criminal sanctions. However, observing the development in case law and rapid changes in Greenland, the Commission suggested reconsidering the application of the pure offender principle, according to which only the individual offender's personal and social circumstances are considered, without regard for the type and gravity of the crime committed. It also rejected the application of the pure offense principle, which takes into account only the type and gravity of the criminal offense without consideration of the offender's personal and other circumstances. The Commission proposes drawing on the advantages of both principles. Thus, it recommended that in choosing and meting out sanctions, the court has to consider the gravity of the offense, including the interest of society in discouraging acts of the type in question, and the offender's personal situation, including what is deemed necessary to keep the offender from committing further offenses. 139 The Commission also proposed the application of a sanction ladder, 140 based not just on the assessment of the severity of the criminal act but also on an overall assessment which may also include considerations such as age, motive, and whether the offense is a first-time offense or a repeated crime. Particular consideration would be given to flexible sanctions for mentally ill offenders, as an alternative to the ordinary sentences on the sanction ladder. 141 In line with the provisions of the Danish Criminal Code, the Commission also suggested introducing in Greenland's revised criminal code provisions that would regulate criminalization of acts such as child pornography, trafficking in human beings, computer fraud, and others that are currently not included in the code. 142 Greenland's rapid development, the increasing complexity of legislation, the growing number of new types of crimes and cases before lay. 96. Judges and lay assessors require specialized legal knowledge and further improvement of the district lay judges system. Lay Judge Mill S. Peterson notes from his experience that the largest problems are the recruitment of suitable lay judges, the high volume of juridical work falling within the normal working hours of their principal occupation, training and education, and remuneration for the work. 143 Consequently, the Commission on Greenland's judicial system has recommended preserving the advantages of the proximity principle and recruiting local district judges and staff, but with a significant professional strengthening and increase in the legal expertise of the magistrate courts. The Commission also suggested that magistrate judges complete a special district judge training program as a condition for permanent employment as a district judge. 144 The possibility of criminals being able to serve sentences in Greenland is hampered by several factors. These include a lack of maximum security penitentiaries and an urgent need for a high-security jail to reduce waiting lists for incarceration, poor training among Greenlandic staff working at detention centers and correctional facilities, and the need for qualified personnel to provide psychiatric treatment. Even though in 2006 for the first time ever, a prisoner serving an indefinite sentence has been jailed in the new correctional facility, there are still problems in connection with local incarceration. 145 Increased criticism by the community and victims calling for more protection and harsher sentencing, few facilities for alcohol and drug abuse treatment, and financial difficulty in supporting the system add to the list of problems facing the administration of justice in Greenland. 146 Therefore, the Commission on Greenland's judicial system has recommended reforms and a modernization of the entire administration of justice system, as well as the potential transfer of parts of it, including the creation of prison facilities and probation service, to the Home Rule authorities. Problems connected with the administration of justice are not new for Nunavut. Among the problems it has faced partially as a result of the legacy of the NWT is the ineffectiveness of the circuit justice system to solve the issue of crime in the communities, given the scant knowledge of traditional Inuit wisdom by mostly Kalanate juridical personnel. Other problems include language barriers, case delays, the adversarial approach of the Canadian criminal justice system, overcrowded correctional facilities as a result of the growing number of remand prisoners, and inappropriate leniency in sentencing. 147 Other critics have also noted that 97. Some regard the local correctional facility as an offender's paradise. According to one research study, Nunavut residents referred to the Baffin Correctional Center as the Baffin Hotel or the Baffin Country Club. Many offenders regard jail as the chance to get out the community. They look forward to it. They see it as a reward. 148 to conclude, compared to their Canadian counterparts, who historically have imposed their own legal system upon the Inuit, Danish legislators have attempted to preserve some of the unique features of Greenlandic customary law. The question that arises is whether the creation of public governance in Nunavut in 1999 or the introduction of home rule in Greenland in 1979 made a difference in the Inuit political or legal capacity to maintain their traditional customs in the modern administration of justice or the legal systems existing in these Arctic jurisdictions. Developments in the justice systems in Greenland and Nunavut. A consideration of the possibility of further integrating or reviving traditional Inuit lawways in the contemporary justice systems in Greenland and Nunavut raises the question of the importance and validity of lex loci in bringing justice to the Inuit. The existing legal systems in Greenland and Nunavut are products of Western legal thinking. Further, according to some authorities, after obtaining home rule status, Greenlanders had to manage the conflict between remaining traditional customary law practices and modern legislation. 149 In both entities one can still observe the phenomenon of mimetic legislation, that is, the duplication or imitation of Canadian and Danish laws, which are not rooted in Inuit cultural values and are framed in Western legal language. 150 Understanding of this legislation by local practitioners who do not have special legal training is hampered by a number of difficulties, which in Greenland's case include problems with translation of Danish legal concepts, or with following imported laws that are frequently amended. This also alienates the local population from enforcement of such legislation. 151 At the same time, in the opinion of H. Peterson, contemporary Greenlandic legal culture is still strongly affected by Inuit tradition. Despite the growing influence of a rights culture, the Greenlandic system is still oriented towards situational consensus. 152 In Canada generally and in Nunavut in particular, some elements of Inuit customary law were incorporated into common law by judicial practice within the past decades. 153 And attempts were made to integrate customary law within. 98. The overall justice system in Nunavut. 154 Importantly, in Nunavut, all laws passed by the territorial legislature must be translated in Inuttut and most of them contain provisions for consideration of Inuit Kojimajatukanjit or even attempt to employ IQ as a legal principle. At the same time, Canadian legal culture is still foreign to some Inuit. For example, recently there have been precedents where the accused did not understand what was happening in the court and pleaded guilty without knowing the meaning of the word complainant. 155 Despite these developments, the question remains as to whether the introduction of an Inuit judiciary in Nunavut and Greenlandic courts is feasible. The study of non-legal predicaments of any possible reform in that regard is not the focus of this chapter, nor is an assessment of legal impediments to the recognition and establishment of Greenlandic and Inuit courts or other changes to the justice system. My presumption is that Greenlanders and the Inuit of Nunavut would be able to negotiate with central governments to create a more or less independent Inuit judiciary or some parallel justice system if there were support from all the residents. This could be done on the grounds of extending the scope of autonomy within current Greenland and Nunavut legal arrangements and in the framework of the Inuit people's right to self-determination. Thus, Greenlanders can negotiate with Danish authorities for extended self-government, including Greenland's jurisdiction in judicial affairs. The Danish legal expert Frederik Harhoff sees no definitive reason why Greenland should be barred from establishing its own courts to settle questions under Greenlandic law. 156 As he notes, according to the Greenland view, the judiciary cannot be excluded from the areas as summed under Home Rule. Any autonomous legal system has the right to establish a judicial structure for the solution of legal conflicts within the system itself. The Greenland authorities therefore believe that they are entitled to establish a separate Greenlandic judiciary with independent courts. 157 Though a Greenlandic judiciary is legally feasible, in practice, the existing Danish courts have proved to be loyal to the Home Rule legislation, and there has been no incentive to institute a parallel and costly separate system of courts. 158 The Commission on Greenland's judicial system found that the Danish constitution does not prevent a transfer of all elements of the judicial system to Greenland, but requires that the competence granted to the Home Rule government must be exercised within the framework of the constitution, including that the Supreme Court remains the Supreme Court of the realm. 159 Consequently, a Connect 99 between the Danish and Greenlandic judicial systems will remain, and the Supreme Court, as a court of last resort, will have to determine disputes, including control the administration and monitor observance of the limits of the legislative power. 160 The transfer of legislative jurisdiction and administration of the judiciary to the Home Rule authorities is possible with the amendment of the Home Rule Act. However, the Commission did not develop its proposals for reforming Greenland's judicial system with such transfer in mind, which might be highly burdensome for the Home Rule authorities. 161 The Commission evaluated advantages and drawbacks of this transfer and considered it to be doubtful that the Home Rule government will become able, within a foreseeable time, to build up the requisite administrative and professional capacity, especially legal capacity, to cope with both the issuing of rules for and actual administration of the fields of responsibility that a transfer involves. 162 There is no definitive answer as to whether the constitutional development of Nunavut provides for realization by the Inuit of their right to self-determination. 163 In the future, the Inuit of Nunavut could negotiate the establishment of an independent justice system through the framework of self-determination. Further development of Nunavut's system of governance, and problems arising with the impact on the Inuit of a justice system based on the Canadian model, may at some point place this issue on the political agenda. 164 The Nunavut Act does not confer the authority to create an alternative Inuit system of courts or administration of justice. However, hypothetically, if residents of Nunavut wished so, there might be a legal possibility for this development based on Canada's constitutional law. For example, Patrick Macklum's analysis of the question of which level of government possesses the constitutional authority to create an Aboriginal justice system and the judicature provisions of the Constitution Act, 1867, concludes that there is no serious obstacle to the establishment of a separate or parallel system of justice for Aboriginal people. 165 Moreover, Section 35 of the Constitution Act, 1982, guarantees support for the recognition or creation of Indigenous courts. 166 Macklum has also found that legislative initiatives aimed at vesting greater control over criminal justice in Aboriginal communities do not infringe upon constitutional guarantees enshrined in the Canadian Charter of Rights and Freedoms. 167 Macklum's arguments notwithstanding, the introduction of an Inuit justice system was not at the forefront of the debate when Nunavut was created in 1999. 168 This may be partially explained by the challenges the young government had 100 to face connected with the building of Nunavut and making it a homeland for all its citizens. Today, the administration of justice in Nunavut is a subject of criticism. The complaints cover a variety of problems, including the serious shortage of criminal defense lawyers, delays in the processing of civil and criminal cases, lack of access to civil law among Nunavut residents, and misguided attempts by non-Inuit in the justice system to show sensitivity to Inuit culture, which have resulted in cases of domestic violence being condoned and a high number of repeat offenders. To protect Nunavummiut who are experiencing family abuse, the Family Abuse Intervention Act was passed by the Nunavut legislature in 2006. However, a lot of work remains to be done to deal with violence and escalating addiction rates leading to criminal behavior. 169 Nunavut elders say that the Inuit are forced to use a court system they know nothing about and that Inuit traditional law ways should be integrated into the Canadian court system, especially with respect to minor offences. 170 There is great concern about the way elders are treated in the justice system. As Payujuk claims, elders are often invited to give their opinions before sentencing at trials, but they are just being used. The elders are listened to but they don't have any say. 171 There is some desire among the elders to see a system where they will share equal power with the judges. Elders representative Natalia Loukacheva emphasizes that before the white man came, Inuit treated people differently than today's culture. Elders can offer counsel and forgiveness. 172 In the words of former Crown Prosecutor Pierre Rousseau, Nunavut's dysfunctional justice system destroys lives, ignores Inuit culture and is a major cause of inter-ethnic conflict. 173 He further states that the use of interpreters, local justices of the peace, diversion programs, provisions for unilingual Inuit-speaking jurors, and elders panels sitting with judges are just crumbs thrown at Aboriginal communities. 174 One solution, in Rousseau's opinion, is to restore the power that the Inuit once had to resolve conflicts in their communities. To the list of concerns may be added letters from Nunavut residents who are furious with justice system that does not sentence sex offenders to adequate jail time. 175 Nunavut's rate of violent crime is the highest in Canada and includes a high incidence of sexual and domestic assaults. 176 Clearly, further change to the administration of justice in Nunavut is needed, recognition of some form of Inuit judiciary, a return to more traditional Inuit methods of social control and dispute resolution, and there further. 101. Introduction into the contemporary justice system are important reforms for consideration. However, in the words of Francis Payugatuk, a court worker from Iqaluit, a separate justice system for the Inuit is never going to become a reality, because the crimes the Inuit people commit are the same as the crimes white people commit. The Inuit system is usually rehabilitation if possible. We have a system of justice in place and what we have to do is make the present system work to our advantage. Hopefully there will be Inuit lawyers in the future and maybe we can have a hand in making the system a little bit more flexible. 177 Indeed, thanks to a Kitsarak Law School program, which was organized as a result of a partnership between the Kitsarak Law School Society, the Faculty of Law at the University of Victoria, and the Nunavut Arctic College, and included some Canadian Aboriginal scholars, the shortage of Inuit lawyers has been alleviated. Inuit-speaking law graduates will naturally tend to look at customary and informal approaches to law. 178 In the words of a Kitsarak Law School graduate Sandra Inutik, we are going to challenge the black-letter approach to law, where written legislation is valued in court, more than Inuit Kajimajatu Kanjit. 179 In a similar vein, Kajik Robinson noted there will only be justice in Nunavut when Inuit traditional law is viewed as equal with Canadian written law. 180 Even though the legal system in Nunavut remains rooted in the Euro-Canadian justice system, there have been some initiatives for bridging the gap between Inuit values and the administration of justice. It is expected that eventually the role of justices of the peace and community-based justice committees will increase, and alternatives to the existing justice system that are based on Inuit traditions and values will be promoted. It is also hoped that over time the Inuit will take more responsibility for and control over justice issues in their communities. 181 Nunavut's residents themselves are taking steps to make the justice system more amenable to their needs. For example, the Kitikmeot Inuit Association has tried to banish repeat offenders from moving in and out of their communities and took their campaign to the federal government. 182 Victims of crime in Iqaluit are seeking justice from the elders. The collaboration of a group of elders and professional mediators in the Iqaluit Restorative Justice Society is one example of a popular alternative for handling lesser crimes, such as vandalism, petty theft, or minor assaults. Most of the cases the society mediates involve young offenders. In their work outside the official justice system, Inuttitude. 102. Speaking elders share their traditional knowledge with offenders about how the Inuit dealt with criminals in the past. They ask the perpetrators questions about the crime they have committed and give them advice. If the victim requests, the accused may also meet with a trained mediator, instead of the elder. These mediation sessions help the victim and the offender agree on some form of conflict resolution. 183. In 2005, the Restorative Justice Society launched a video across Nunavut explaining how elders would use age-old techniques to resolve crimes today. 184. The hope is that, in the future, the justice system in Nunavut will develop towards more flexibility in dealing with dispute resolution outside the court system, and will involve more Inuit knowledge to accommodate cultural identity in the existing juridical structures. 185. Greenlanders and the Inuit of Nunavut have some opportunities for employing their legal practices and incorporating Inuit legal culture into the administration of justice. It is not clear to what extent Inuit legal traditions and lex loci have survived the imposition of the Danish and Canadian legal systems. Because many Inuit lawways are informal, it is debatable whether customary law is inconsistent with or complementary to Western legal traditions. Inuit legal culture is valuable itself, and there should be further dialogue between Inuit and non-Inuit legal traditions so that the legal systems in Greenland and Nunavut can embrace the best of both worlds. Although, according to some authorities, there are no legal obstacles to establishing an alternative Inuit judiciary in Nunavut and a more or less independent justice system in Greenland, in practice it is not clear how this can be done, given the erosion of traditional Inuit practices and the financial resources required. The cases of Greenland and Nunavut show that via self-governance, further evolution of Greenland home rule, and development of Nunavut's governance, bringing a community-based approach and increasing Inuit involvement in legal services and the judicial system should open more possibilities for the application of lex loci, and will enable the Inuit to be tried by their own peers. Recognition in the legal framework of autonomy of the possibility of Greenlandic or Nunavut administration of justice with strong Inuit involvement could make a difference in the delivery of justice to northern residents. 5. Greenland and Nunavut in international affairs. As Inuit, we have a responsibility to our people and our communities to secure greater international recognition of Inuit rights. At the same time, Inuit from all circumpolar countries must contribute to the integrity of the world environment and world peace, by advocating coherent policies and initiatives and the establishment of an international forum where all these concerns can be discussed and acted upon. Mary Simon, President, Inuit Circumpolar Conference, 1987. The scope of the Home Rule Act, the Nunavut Land Claims Agreement, and the Nunavut Act does not go so far as to permit Greenland or Nunavut jurisdiction over international relations or defense and security policy. Despite this, Nunavut and particularly Greenland want to be involved in the security activities of their national states when the issue at hand concerns their lands. They are also active in various forms of international cooperation and indigenous internationalism, although formally their legal personality in international or domestic law does not permit such activities. 1. In this chapter, I examine the legal capacity of Greenland and Nunavut in international affairs and security policy by looking at the main international forums in which these jurisdictions have a voice, regardless of the limitations imposed by their legal status. There is no legal clarity on the competence and boundaries of subnational territories' participation in the international field. 2. Nonetheless, there is clear growth in the importance of international involvement by constitutional dependencies such as Greenland and Nunavut. Since the first days of the Home Rule, Greenlandic authorities gradually took 104 over elements of foreign affairs and pursued a strategy that allowed Greenland to become a genuine actor in its own sphere of foreign policy. 3. The report from the Commission on Self-Governance highlighted the necessity of expanding Greenland's capacity to take a stand in foreign affairs and security policy issues in the areas of fishery, hunting, environment, tourism, transportation and business in order to strengthen the country's economy for unique cultural, geographical, environmental, linguistic, and economic conditions, as well as current trends towards globalization and the existing practice of Inuit internationalism have created a need to expand the legal vision of autonomy in some areas of the traditionally non-transferable domain of foreign affairs. 5. In this chapter, I argue that Greenland and Nunavut should have a legislated right to cooperate in international activities and the formulation of security policy as subnational territories, when the issue has direct or indirect significance for them. Recognition of this right would open up more opportunities to accommodate both local concerns and the development of these jurisdictions in the global and Arctic contexts. The transfer of this kind of jurisdiction, with specified limits on the autonomous region's capacity in international forums, would not pose a threat to national sovereignty or statehood. The Danish and Canadian interests in the preservation of the legal status of Greenland or Nunavut are not based on international law. The protection for these interests is promoted by active Inuit participation in international organizations. Tacit approval by Danish or Canadian authorities for Greenland's or Nunavut's participation in international cooperation creates a precedent that justifies the limited international legal capacity of these Arctic jurisdictions. However, in the opinion of the Commission on Self-Governance, the practice that developed in the form of consultations built on goodwill will not be acceptable in Greenland's future self-governance agreement. Therefore, the Commission on Self-Governance called for a new arrangement recognizing Greenland's formal participation in this area. An important step in this direction was the introduction, after negotiations between the Government of Greenland and the Government of Denmark as equal parties, of the Act concerning the conclusion of agreements under international law by the Government of Greenland. 6. In practice, some of the spheres in the field of foreign affairs are becoming legitimately transferable to Greenland. This may also become an option for Nunavut in the long run. 105. The legal status of Greenland and Nunavut as international actors. There are striking similarities and differences in the legal status of Greenland and Nunavut with regard to international relations. Greenland and Nunavut have no special status in international law stemming from an international convention. Although in practice these jurisdictions could be subjects of the legal regime of Arctic international law, constitutionally the territories are a part of Canada and Denmark. 7. Consequently, from a legal standpoint, the authorities of Nunavut and Greenland cannot undertake foreign affairs. Their jurisdiction in the international domain is limited by rights and obligations derived from treaties or other international documents signed by Canada and Denmark. The Canadian and Danish authorities have exclusive priority in decision-making powers over foreign relations regarding the interests of their states. Greenland and Nunavut cannot be independent members of international organizations that are composed of sovereign states. These territories are not allowed to conclude unilateral agreements with foreign countries and cannot have their own diplomatic missions. All this means that Greenland and Nunavut do not have international legal capacity or an international legal personality and cannot be classified as subjects of international law. This situation is changing to some extent, especially in Greenland's case. In order to advance foreign policy collaboration, in 2003 the governments of Denmark and Greenland signed in Itilleq a joint declaration on the involvement of Greenland's Home Rule government in foreign and security policy matters of significance for the island. This declaration supported Greenland's participation in international negotiations along with the Danish government for assertion of Greenlandic interests. It also noted that the government of Greenland must be consulted prior to the ratification of international agreements whose implementation is incumbent on Greenland. Furthermore, apart from some areas, the declaration noted that it will normally be possible to accede to international agreements with effect solely for Denmark, so that Greenland can independently take a decision on the extent to which the agreement concerned should apply to Greenland. 8. Some areas of foreign affairs are in fact transferable to Greenland Home Rule when they do not limit the constitutional responsibilities and powers of the Danish government related to conclusion of agreements. 106. Under international law. Since the introduction in 2005 of the Authorization Act, the Greenland Home Rule government is allowed to negotiate and conclude agreements under international law with foreign states and international organizations, including administrative agreements, which relate entirely to subject matters where legislative and administrative powers have been transferred to the authorities of Greenland. These arrangements, however, cannot apply to agreements under international law affecting defense and security policy, or agreements which are to apply to Denmark or which are negotiated within an international organization of which the Kingdom of Denmark is a member. Further, these agreements shall be entered into on behalf of the Danish realm by the government of Greenland under the designation of the Kingdom of Denmark in respect of Greenland. It is presupposed that Greenland cooperates with Denmark and informs the Danish government about upcoming negotiations and before international agreements are entered into or terminated. The Act also allows Greenlandic representatives to be appointed to the diplomatic missions of the Kingdom of Denmark to address issues related strictly to powers taken by Greenland Home Rule authorities. Finally, according to Section 4 of the Act, where this is consistent with the constitutional status of Greenland at the request of Home Rule authorities, the Danish government may grant or support Greenland's application to attain membership in its own name in international organizations that allow membership of entities other than states and associations of states. Despite the fact that the Home Rule government was authorized to act on behalf of the Danish realm in international affairs related exclusively to legislative and administrative jurisdiction that was transferred to Greenland, the Authorization Act does not limit the constitutional powers and responsibility of the Danish government in the field of foreign affairs, including powers of the Minister of Foreign Affairs and the Danish authorities in relation to Greenland. Also, it does not replace the provisions of the Greenland Home Rule Act of 1978, which is still in force at the time of writing. The developments towards gradual expanding of Greenland's foreign policy involvement are taking place within increasing cooperation with Denmark and with special consideration of the Danish constitutional framework. According to Section 19 of the Danish Constitution, the King acts on behalf of the Kingdom in international affairs, and the principle of national unity presumes that foreign affairs are part of the indivisible sovereignty of Denmark. 107. Correspondingly, the Commission on Home Rule has isolated foreign affairs as an absolute jurisdiction of the national authorities that cannot be delegated to the Home Rule authorities. 9. As a result, Section 11 of the Home Rule Act vests jurisdiction in the central authorities of the realm regarding questions affecting the foreign relations of Denmark and obliges the Home Rule government to first discuss with Copenhagen any measures that would be of substantial importance to the foreign relations of the kingdom. Moreover, Section 10 of the Act stipulates that Greenlandic authorities shall be subject to obligations arising out of treaties and other international rules that are binding on Denmark, and that the powers delegated to international authorities under Section 20 of the Constitution shall at all times prevail over the powers of the Home Rule authorities. The Home Rule system is meant to work in the interests of the Danish nation as a whole. Even if some spheres of foreign relations are transferred to the Home Rule government, Greenlandic and Danish authorities must cooperate if an issue falls under an international treaty or other obligation. Section 13 of the Home Rule Act obliges the central authorities to consult with the Home Rule government before concluding treaties that require the assent of the Folketing and that specifically affect Greenland's interests. Likewise, Denmark is not entitled to enter into an agreement of specific interest to Greenland without prior consultation with the Home Rule authorities. 10. When matters of particular interest to Greenland are at stake, Copenhagen may, at the request of the Home Rule government, authorize it to negotiate directly with the collaboration of the Foreign Service, provided such negotiations are not considered incompatible with the unity of the realm. 11. The Authorization Act extended and modernized some provisions of Section 16 of the Home Rule Act dealing with employment of Greenlandic representatives within the Danish diplomatic missions. According to these changes, Greenlandic authorities may request that representatives of the government of Greenland be appointed to Danish diplomatic missions to attend to subject matters where legislative and administrative powers have been entirely transferred to the authorities of Greenland. 12. Thus, the previous term officers was replaced with representatives of the government of Greenland, and the scope of activities was expanded from special commercial interests to the powers transferred to the Home Rule authorities. 13. Clearly, according to the provisions of the Home Rule Act, before the introduction of the Authorization Act, Greenland had some say in international relations that 108 included specific Greenlandic interests. Sometimes these interests were the cornerstone of the Denmark-Greenland relationship. For example, before 2005 the Home Rule authorities were not allowed to conclude agreements with foreign countries, even on matters exclusive to Greenland jurisdiction. In practice, however, Greenlandic authorities have concluded such agreements with some neighboring countries. 14. According to Harhoff, the Danish government has tacitly accepted these treaties as true international agreements, indicating that only the Home Rule government could be held responsible in the case of breaches. 15. Nonetheless, it was understood that this limited international treaty-making power applies only to local Greenlandic matters under Home Rule jurisdiction that have no general implications for Danish foreign and external security. 16. These precedents showed that national authority in foreign affairs was not absolute and was, in fact, transferable to some extent. It was not surprising, then, that in 2003 the Commission on Self-Governance concluded that the Home Rule Act was limited in meeting Greenland's need for a greater say in international affairs. It recommended that the Act be revised to reflect today's reality, particularly with respect to the legally recognized duty of state authorities to negotiate with Greenland's government before undertaking any international initiatives of significance to the island. 17. Greenlandic authorities saw international agreements only at the stage of ratification and did not have much chance to influence the context of the agreement. The Commission suggested changing this practice so that mandates in principle to enter into international negotiations were presented not just to the Folketing but also to Greenland's government and the Landsting, which should be in the position to express their views concerning the negotiation mandate. 18. Also, the Commission raised the question regarding the participation of Greenlandic representatives in Danish delegations in cases where international negotiations for Denmark concern the European Union. The Commission noted that in international relations, Denmark is sometimes used to cover all the parts of the realm, and in some cases Denmark is understood only as an EU member country. Because Greenland is not a part of the EU, the Commission suggested that in those areas where Denmark acts on behalf of the realm, it should be assumed that the necessary negotiations have taken place with Greenland concerning those areas that are marked by a Greenlandic interest. When Denmark acts only as an EU member state and may be obliged by common EU policies, Greenland should be allowed to maintain 109. Other interests, whereas the Danish legislation should be revised to deal with this potential conflict. 19. To conclude, despite increasing Greenland's jurisdiction in some areas of foreign affairs, the Authorization Act did not amount to an actual transfer of powers from Denmark to Greenland to act independently in international affairs, as the Danish kingdom is one subject in international law. Greenland's government was authorized only to act on behalf of the Danish realm in international affairs that related solely to Greenland and did not affect or challenge the integrity of other parts of the realm. Thus, the legal scope of the Act was extended to already existing Danish Greenlandic practices in the area of foreign affairs. The case of Nunavut is different. Compared with Greenland, the territory has insignificant legal capacity to perform internationally even in the matters related entirely to Nunavut's jurisdiction. The Nunavut Act does not deal with the issue of Nunavut's participation in international affairs. In Canada, foreign affairs are primarily under the direction and control of the federal government. However, the legislative jurisdiction to implement international treaties is divided along federal and provincial lines. Even though Nunavut does not have the full status of a province, the NLCA recognizes that any legislation implementing an international or domestic interjurisdictional agreement shall be interpreted and administered to treat Inuit on at least as favorable a basis as any other Aboriginal people in Canada, and that the Government of Canada shall include Inuit representation in discussions leading to the formulation of government positions in relation to an international agreement relating to Inuit wildlife harvesting rights in the Nunavut settlement area, which discussions shall extend beyond those discussions generally available to non-governmental organizations. 20. Further, Section 12.11.2 of the NLCA specifies that the Government of Canada and the Government of Nunavut, assisted by the Nunavut Impact Review Board, shall do their best in negotiations with other jurisdictions to provide for cooperation in the review of project proposals which may have significant transboundary ecosystemic or socio-economic impacts. 21. Beyond this point, however, provisions of the NLCA do not provide the Government of Nunavut with a solid jurisdiction in international matters. Despite the extension of Greenland's authority in the area of international affairs and Nunavut's limited capacity in that sphere, the question remains as to the necessity of a legal recognition of the right of subna. 110. National entities to exercise jurisdiction in some areas of foreign affairs. The transferability of some areas of foreign affairs to subnational units such as Greenland and Nunavut is the subject of constitutional and international law and can be considered in the framework of the right to self-determination. I argue that limited jurisdiction in this area can be transferred to Nunavut and Greenland within the scope of the right to internal self-determination, and that this is already the case for Greenland. At the same time, though neither public international law nor the constitutional law of Denmark or Canada entitles Greenland and Nunavut to perform as independent subjects of international law, these Arctic jurisdictions are involved in fostering international relationships in order to realize their cultural, social, environmental, and economic interests. Danish, Greenlandic cooperation in foreign affairs is workable as long as it does not affect the major principles of Danish foreign policy. The continued evolution of Greenland, the growing desire for greater self-government, the need for sustainable economic development, and the capability to respond to global challenges support the involvement of Greenlanders in foreign affairs, particularly concerning international environmental and trade policy initiatives. 22. Steadily increasing recognition of subnational territories such as Greenland and possibly Nunavut as legitimate participants in international relations contradicts traditional conceptions of national sovereignty and reduces the sovereign powers of the state. However, the developing practice of involving subnational units in international affairs shows that they are progressing in this direction in cooperation with their respective national governments. Inuit involvement in international relations, for example, via the Inuit Circumpolar Council, which will be discussed below, bears some similarity to the simultaneous involvement of both the Canadian and Quebec governments in La Francophonie. Yet the Inuit aspiration does not grow out of any interest in separatism. 23. Indeed, the Commission on Self-Governance has underscored that even in the renewed self-governance model there would be areas where jurisdiction in foreign affairs cannot be transferred to Greenland. Thus, the legal parameters for Greenland's activity in foreign affairs should be based on cooperation and partnership between the Danish and self-governance offices. 24. Forms of Greenland's and Nunavut's international activity. To understand the breadth of areas where jurisdiction in foreign affairs 111 can be transferred to Greenland and Nunavut, it is useful to look at existing forms of their involvement in international forums and evaluate their potential interests in that area. The variety of forms, certain of which are summarized below, indicates that involvement in certain areas of international affairs is of the utmost importance for subnational Arctic entities. Greenland is more actively involved in this field than Nunavut, and it successfully pioneered and enhanced transnational diplomacy even within the context of its limited autonomous status. Greenland and Nunavut have particular interests in international cooperation, and these interests define their priorities and forms of international activity. These forms can be classified in the following principal ways. Regionally: Arctic cooperation, Nordic cooperation, European cooperation. 25. Cross-border cooperation between Greenland and Nunavut and between Greenland and Canada. 26. Internal cooperation indirectly affecting international decisions. 27. The North Atlantic cooperation. 28. Globally: via the World Trade Organization, the UN. 29, UNESCO, the ILO. Functionally: interparliamentary cooperation, supranational cooperation, non-governmental cooperation, the International Arctic Science Committee. 112. Indigenous cooperation. By subject matter: environmental cooperation, fishery and hunting cooperation, the Canada/Greenland Joint Commission on the Conservation and Management of Narwhal and Beluga, international trade cooperation, cultural, educational, linguistic cooperation. 31. Greenland is involved in the process of Nordic collaboration, whose legal basis today is the Treaty of Cooperation among Denmark, Finland, Iceland, Norway, and Sweden, which was signed in Helsinki on March 23, 1962. 32. Amendments to the treaty show that there has been a renewal and expansion of Nordic cooperation in the light of the greater participation by the Nordic countries in the process of European cooperation. 33. Today, major Greenlandic interests are expressed via participation in the activities of the pillars of Nordic collaboration, such as the Nordic Council and the Nordic Council of Ministers. 34 The roots of the Nordic 113 Council date back to its predecessors in 1907 and even earlier. 35 Since its founding in 1952 as a forum for interparliamentary collaboration, the Council has promoted discussion among the parliaments and governments of Denmark, Iceland, Norway, and Sweden, and, later, Finland, on matters of Nordic cooperation. 36 The status of autonomous territories in the structures of Nordic cooperation was consolidated and clarified in 1980 in the report of the Petrie Committee. Composed of the executive body of the Nordic Council and the ministers of justice of the Nordic countries. 37 As a result, in 1984 Greenland entered the Nordic Council after having obtained the status of permanent participant within the Danish delegation. 38 The Council consists of 87 elected members, representatives of Nordic governments and governmental representatives of the Åland Islands, the Faroe Islands, and Greenland. As is the case for other autonomous territories, the Landsting of Greenland elects 2 members to the Nordic Council, and the Home Rule government appoints representatives it wishes to send. The Greenlandic delegation, although formed separately, joins the national delegation of Denmark on the Council. 39 Because Greenland has only 2 elected members, representatives of Home Rule government are allowed to participate and speak on matters affecting Greenland in different committees of the Council on which they don't have elected members. However, these governmental representatives do not have voting rights. 40 As regards jurisdiction, the Nordic Council is an informal cooperative structure with purely advisory and supervisory functions. It may adopt recommendations, make representations, or issue statements on its views to the national governments of the Nordic countries or to the Nordic Council of Ministers. 41 Thus, it is not an independent decision-making body, each Nordic parliament has to separately enact the Council's recommendations. 42 The Nordic Council's mandate makes it an exclusively consultative organ of the Nordic parliaments. 43 Another structure of Nordic cooperation in which Greenland participates is the Nordic Council of Ministers, which was formed in 1971 as a forum for intergovernmental cooperation to develop collaboration between various governments and the Nordic Council. 44 De jure, the Prime Ministers are responsible for overall coordination of matters of Nordic cooperation, and in each country they are assisted by a member of the government and an under 114 Secretary of State or government official. 45 In practice, overall responsibility for the Nordic Council of Ministers is delegated to the Ministers for Nordic Cooperation and to the Nordic Committee for Cooperation. The Nordic Council of Ministers consists of several individual councils of ministers. Most of the Nordic ministers for specific policy areas meet in Council of Ministers a couple of times a year. Thus, the composition of the council may vary depending on what issues need to be addressed. 46 As is the case for other autonomous territories, the Home Rule government of Greenland is allowed to take part in the work of the Nordic Council of Ministers. Greenland has representatives at various councils of ministers, and it cooperates via a Minister for Nordic Cooperation. 47 Greenland views its limited participation in these high international forums as a chance for furthering its integration with other Nordic regions, and for broadcasting its international voice within the Nordic community. According to one authority, if Greenlanders express their will to do so, there is no constitutional obstacle to their full membership in the Nordic Council or the Nordic Council of Ministers. However, it is not clear whether such an argument corresponds with Denmark's position. 48 That position may soon become apparent. In 2006 Greenland expressed interest in having its own delegation in the Nordic Council. Greenland wants to take part in decision-making processes and participate more independently in the work of the Nordic Council and the Nordic Council of Ministers. 49 Currently, Greenland's far-reaching associate status within the Nordic Council and the Nordic Council of Ministers provides Greenlanders with some degree of authority in the processes of Nordic cooperation. This collaboration is further enhanced by cooperation between the Nordic Council and the West Nordic Council, which in 2006 signed an agreement allowing Greenland, Iceland, and the Faroe Islands to exert greater influence on the Nordic Council's decisions and agenda. 50. Although, according to some commentators, formal Nordic cooperation is in crisis, challenged by the growth of the European Union's supranational institutions, of which most of the Nordic countries are members. 51. Greenland's current participation in the institutions of interstate Nordic collaboration is a positive example of the potential for transferring some areas in international relations to subnational entities. 115. Greenland and the European Union. We confirm our relations with Denmark, and with Europe, but we have also realized that our full membership of the European community as a European region is inadequate and unworkable along with our self-determination established through our home rule. Our climate, norms, culture, ethnicity, social structure, economic and industrial pattern, infrastructure, and basis of existence are so different from Europe that we can never equate with the European countries or regions. Our country does not fit into Europe, and we do not fit within the European community. This is not to indicate that any relation to Europe should be cut off. But a loose relation with Europe would in a much more realistic way reflect the differences, and the connections, between Greenland and Europe. In political terms, the step out of the community is one step away from all that, which for centuries has made us believe that we cannot manage on our own. Moses Olsen, Greenland's Home Rule Minister for Social Affairs, 1983. The complexity of Greenland's relations with the European Union is conditioned by two important factors. First, Greenland as a part of Denmark, an EU member state, has to harmonize its non-European features and home rule interests with EU policies. Second, Greenland has no direct jurisdiction in the supranational institutions of the EU. Despite this, Greenland's loose relation with Europe has developed into a political love affair marked by mutual cooperation and benefit. Some of Greenland's political figures publicly support EU membership for the island, imagining the use of the EU machine as a counterweight to the United States and speculating on the benefits of the EU taking economic responsibility for the island. 52. How did this political love affair become legally possible for a subnational territory that is not an EU member? In 1972, Greenland, as an integral part of Denmark, had to join the European Economic Community, notwithstanding the mixed reaction of Greenlanders to the idea. 53. On February 23, 1982, 53% of Greenland's population voted to rescind its membership, and the Home Rule government requested that Danish authorities begin negotiations with the EEC regarding Greenland's withdrawal. 54. On February 22, 1983, the Commission of the EEC issued a formal communication approving Greenland's withdrawal, and Greenland left the EEC on February 1, 1985. 55. 116. Greenland had reaped some economic benefits from participation in the EEC, but withdrawal became necessary for several reasons. 56. Because of Greenland's history as a colonized entity, it was reluctant to further compromise its autonomy by ceding it to the supranational authority of the EEC. 57. Culturally, socially, and geographically, Greenland does not fit into Europe, and Greenlanders thought of themselves as quite separate from the continent. 58. Greenland's membership in the EEC suppressed expectations for home rule development and imposed limitations on possibilities for self-determination. 59. Membership in the European superpower was seen as a potential threat to Greenlanders' ethnic identity. 60. In economic terms, as a fishery-based society, Greenlanders found it humiliating that their politicians would have to bargain with EEC representatives about the right of Greenlandic fishermen to fish off their own coastline. 61. Finally, there were considerable practical problems in exercising Greenland's membership. 62. Legally, Greenland's withdrawal created a negative precedent in EEC law, but reluctance regarding Greenland's secession was overcome by the exceptional circumstances. 63. In 1985, after numerous legal and political considerations, Greenland obtained a new legal regime designation within the EEC as an overseas country and territory, with special arrangements regarding its unique circumstances. 64. Greenland as an OCT within the EU. The legal status of Greenland within EU law is regulated by the regime of the overseas countries and territories. 65 On February 1, 1985, in accordance with so-called Greenland Treaty, Greenland was added to the list of the OCTs associated with the EEC. 66 The general OCT legal formula was applied to Greenland as a basis for reassociation with the EEC in 1985, with certain provisions tailored to fit Greenland's particular circumstances. 67 And the Protocol on Special Arrangements for Greenland was annexed to the treaty that established the EEC. This protocol exempted Greenland from customs duties, equivalent charges, and quantitative restrictions on import into the community of fishery products originating in Greenland, with the condition that the EEC obtain access to fish in Greenland's waters in conformity with the fisheries agreement. 68 The initial goal of the OCT's association with the EEC is to promote the economic and social development of the countries and territories and to establish close economic relations between them and the COM 117 community as a whole. 69 This association also includes non-discrimination in trade arrangements between the OCTs and member states. 70 In addition, Declaration No. 25 of the Maastricht Treaty regulates Greenland's position as an OCT. According to this, Denmark is entitled in exceptional circumstances to act separately from the EU in the interests of Greenland, without this affecting the interests of the EU. 71 The detailed relationships between the OCTs and the EU are governed by periodically updated decisions of the Council of the EU on the association of the overseas countries and territories with the European Community. Currently the OCT decision of 2001 still applies to Greenland until 2011. It contains an exhaustive mechanism of association with the EU on the principles of cooperation, dialogue, and partnership. 72 This collaboration, which is of the utmost importance to Greenland, comprises a wide range of areas such as economic, trade, social, regional, and cultural cooperation, as well as fisheries, agriculture, industry, mining, energy, transport, finance, and water. 73 Thanks to Greenland's OCT status, the residents of the island have access to numerous EU programs in the fields of education, entrepreneurship, culture, research, information technology, and communications. 74 Thus removal from one end of the EU treaty system to the other has turned out to be more favorable for Greenland, which, without direct membership in the supranational EU institutions, is still able to manage its own interests. This Greenland-EU relationship may be partially explained by Greenland's proactive approach to the decision-making process. One of Greenland's interests includes the possibility of having a policy-making mechanism to influence the EU legislative process with its unique Arctic perspective. 75 As Greenland's system of home rule evolves, so too does its participation in the EU. Currently, it qualifies for a higher status than that of simply an offshoot of Denmark but less than that of a member state. Does this require a new partnership with the EU, or does the OCT status work well? Experience has shown that the Greenland-EU relationship is effective within the framework of the OCT and would be workable even if Greenland changed its home rule status. 76 At the same time, the current Greenland-EU relationship has evolved to the point that the need for negotiation of an ad hoc EU-Greenland partnership agreement and review of all the conditions and entitlements of OCT status and the fisheries agreement became apparent. Proposals for a new arrangements with Greenland based on a comprehensive partnership for sustainable 118 development were considered at various bodies of the EU in light of priorities connected with the enlargement of the EU and the fact that the fisheries agreement and successive protocols did not reflect the real fishing levels. 77 The need for a new partnership was urged by broadening the areas of the EU-Greenland collaboration. Thus, in 2006 the Commission of the European Community submitted a proposal that a new comprehensive partnership with Greenland should be rooted in adoption of a new Greenland OCT decision based on Article 187 of the EC Treaty, which will regulate cooperation not related to fisheries, and the conclusion of a new fisheries partnership agreement negotiated in accordance with general rules and principles applying to such agreements. Consequently, in 2006 a new partnership between Greenland and the EU was strengthened and affirmed in a joint European Community, Denmark, Greenland Declaration, the EU Council decision on the relations between the parties, and a new fisheries partnership agreement. Greenland, EU collaboration was further extended in areas other than fisheries. Moreover, the EU Council's decision on relations between the European Community and Greenland and Denmark opened the possibility for the adoption of a programming document for the sustainable development of Greenland with support from the EU budget in the period of 2007 to 13. Since 1985, Greenland received development aid from the EU via the Fisheries Agreement and the successive fishery protocols instead of getting financial assistance through the European Development Fund. However, this situation has changed in 2006 with adoption of a new Greenland OC decision that applies rules analogous to those of other OCs that benefit from a territorial allocation from the EDF. 78. Greenland, EU fishery relations. Fishery interests are a cornerstone of Greenland, EEC/EU relations. In light of a new Greenland, EU comprehensive partnership, on January 1, 2007 the Fisheries Partnership Agreement replaced the previous Fisheries Agreement, which had been in force since 1985. 79 The new deal reflects more adequately the system of payments from the EU to Greenland and their correspondence to actual fishery possibilities in Greenland's waters. It includes broader priorities in developing cooperation. 119. In the fisheries sector and provides fishing arrangements with regard to several species in Greenlandic waters. In addition to the EU financial contribution, substantial payment is expected to be collected from shipowners' license fees. 80 It is revealing to explore the developments that gradually led to these changes in fishery policy. In 1985 the Framework Agreement on Fisheries between the EEC, the Government of Denmark, the Home Rule Government, 81 and the Fisheries Protocol 82 came into force. Fishing forms a substantial part of Greenland's economy. The Framework Agreement on Fisheries established the principles and rules for regulating the fishing activities in Greenland's waters by vessels that fly the flag of, and are registered in, a member state of the EEC. 83 In return for the potential catch realized under this agreement, the EEC agreed to pay Greenland financial compensation as fixed in the Implementation Protocol. 84 Since 1985, there have been several fishery protocols concluded by the EU and the governments of Denmark and Greenland. Protocols specified the EEC/EU quotas and the annual compensation to be paid to Greenland for access to fishing areas in its exclusive economic zone. The fourth protocol, which was in force from January 1, 2001 to December 31, 2006, was criticized by EU member states for, among other things, providing Greenland with generous financial compensation despite the fact that catch quotas for fishing in Greenlandic waters were not met. 85 Fishery relations between Greenland and the EU are the subject of much EU legislation. Before the new Fisheries Partnership Agreement came into force in 2007, a number of changes have been made that intended to improve the relationship between the parties and took into account the special development needs of Greenland's economy, including the vital importance of the fishery, and broader cooperation between Greenland and Europe. Greenland and the EU share mutual interests in managing fishery policies that make a joint contribution to the Greenlandic and EU economies. Greenland and the Northern Dimension of the EU policies. Launched in 1999, the Northern Dimension is an EU policy initiative that focuses on trans-regional and cross-border collaboration to draw the attention of the EU's members to Northern Europe and to develop cooperation with northwestern Russia and Northern Europe. 86 It aims at addressing the regional development challenges of Northern Europe. 120. Such as harsh climatic conditions, long distances, widespread disparities in living standards within the region, environmental challenges including problems with nuclear waste and wastewater management, insufficient transport, and poor border crossing facilities. 87 Framed and implemented in a number of documents, the Northern Dimension Initiative has become a well-established part of policy making within the EU and in the partner countries. 88 It plays an important role in enhancing integration and collaboration within the northern region. Greenland has a unique position as a bridge between the Arctic region and the EU. As such, in 1999 the Greenlandic government presented the idea of emphasizing the Arctic dimension of EU policies by introducing the Arctic window into the EU's northern dimension. Greenland considers the Arctic window the political space within the northern dimension where the Arctic nations and the EU share mutual interests. This initiative should help build a circumpolar dialogue on Arctic policies and initiatives and enhance Arctic, Northern Europe cooperative structures. 89 At the first EU Ministerial Conference on the Northern Dimension, the Arctic window was seen as an additional reason for fostering close links between the EU and Arctic jurisdictions, with a particular focus on indigenous people in the Northern Dimension region. 90 In order to define the main priorities of this cooperation, the Home Rule government produced a report on the Arctic window. This document identifies the following as key areas of Arctic, EU collaboration, trade and industry in the Arctic environment, cross-border pollution, natural living resources, human resources development, telecommunications, research, Arctic know-how, and regional and cross-border cooperation. 91 Greenland regards its participation in the European Union's Northern Dimension policy as a political privilege that allows for involvement in the EU and contributes to that organization's initiatives. 92. The Greenlandic authorities want the EU to become a constructive partner in supporting Greenlandic and Arctic interests even on the legislative level. 93 This development is an important milestone in strengthening relations between Greenland and Europe. It is also crucial for safeguarding common interests within the Arctic, dealing with structural and development needs of Greenland, and addressing the cultural, social, and economic challenges facing the Inuit of Greenland. 94 Greenland's relatively active participation in Nordic collaboration and its developed relations with the supranational institutions and Mecha 121. NISMs of the EU have added unique elements to the island's forms of international cooperation. Although there is no direct link between Nunavut and the EU initiatives, Canada has observer status in the Northern Dimension and reflects its Arctic interests by participating in the ministerial and the senior official meetings. But there is more to the cooperation and acknowledgement of shared interests between the EU and Canada vis-a-vis the Arctic. There are implications for Nunavut from the implementation of the Northern Dimension of Canada's foreign policy, which emphasized the importance of Canada, EU Northern cooperation, and its 2005 evaluation that outlined Canada's progress in EU, circumpolar North collaboration, as well as joint Canada, EU statements on Northern cooperation, defense, and security. 95 According to the EU-Canada Partnership Agenda, both parties are committed to fostering their Northern Dimension policies through coordinated actions in the field of environmental, health, and social issues, strengthening links in education via the University of the Arctic, enhancing cooperation in economic development, legal instruments, transportation and communications, and deepening collaboration on cultural matters to ensure the multilateral promotion of recognition of cultural diversity. 96 These Canada-EU initiatives on the Northern Dimension are significant for Nunavut and suggest its greater participation in the implementation of Canada's foreign policy as it applies to the Arctic. Nunavut and Greenland, as Arctic regions, share many similar challenges and problems, some of which can be solved by Arctic cooperation. As former Premier of Greenland Jonathan Mosefeldt emphasized, we look to high-level forums such as the Arctic Council, the European Union, the Nordic Council of Ministers and others to support our efforts in protecting and developing the Arctic. We believe that our lessons learned may be of use to others. There are many similarities in the problems facing the Arctic part of Russia, in the Arctic parts of the EU, Greenland, or Canada. Greenland therefore strongly supports Northern and Arctic bridge building. We have many mutual problems and challenges calling for the same type of solutions, or rather, solutions based on cooperation. 97. Thus, the next section focuses on Greenland's and Nunavut's representation in the Arctic collaboration. 122. Greenland and Nunavut in the Arctic cooperation. Although international cooperation in the Arctic dates back to the 19th century, during the past few decades there has been enormous growth in the development of international initiatives centered on recognizing the Arctic as a distinct region. 98 The region is seen as an arena for the promotion and protection of numerous interests, which vary from environmental concerns to issues of Arctic governance and indigenous peoples' rights. 99 The Arctic has become an important area of international cooperation for both institutional and informal actions. 100 The establishment of the Arctic Council in 1996 by the 8 Arctic states is one example of an informal arrangement. 101 Having emerged as a result of efforts of various stakeholders, and based on a Canadian initiative, the Arctic Council was created as a high-level forum for promoting cooperation, coordination, and interaction among Arctic governments, indigenous communities, and other northern residents on common Arctic issues. 102 In particular, these include issues of environmental protection and sustainable development in the Arctic, the dissemination of information, encouraging education and promoting interest in Arctic-related matters, and coordinating and overseeing activities established under specific Arctic programs. 103 At the end of its meetings, the Arctic Council issues soft law declarations and recommendations for further action. 104 Conducted under the auspices of the Arctic Council, the Arctic Human Development Report and the Arctic Climate Impact Assessment Report are examples of the Council's initiatives. 105 Established as a high-level forum, the Arctic Council lacks a legal personality and cannot be classified as an international organization under international law. This affects the mode of the Council's operation. Its work is based on consensus. 106 Further, at the time of writing, it does not have a permanent administrative structure or resources of its own. 107 Although it has been criticized for its limited organizational capacity, lack of authority to make binding decisions, severe shortage of financial and other resources, and increasing overlap in its activities with other international actors in the Arctic region, the Arctic Council plays an important role as a voice of the Arctic. 108 The Inuit of Greenland and Nunavut exercise their mandate in the Arctic Council via the Inuit Circumpolar Council, which holds the status of permanent participant. The ICC partakes in activities and consultations with the Arctic. 123. Indigenous representatives within the Arctic Council. 109 The ICC can participate in all meetings and activities of the Arctic Council, and may be represented by a head of delegation and such other representatives as each Arctic state and permanent participant deems necessary. 110 Ministerial meetings of the Council are held in consultation with the permanent participants. In addition, the ICC can make proposals to the Arctic Council regarding cooperative activities. 111 The Indigenous Peoples Secretariat functions within the Arctic Council to provide technical support to facilitate the work of the permanent participants. 112 Though the ICC does not have the status of a member state in the Arctic Council, its jurisdiction is similar. 113 The Arctic Council, through creating the category of permanent participant, considers the aspirations, needs, and opinions of Arctic indigenous residents in its activity. This involvement should bring about a new role for the participation of subnational entities in Arctic international cooperation. Although the perception of the Arctic Council as an intergovernmental structure of national member states does not allow much room for Nunavut's or Greenland's involvement via the ICC, the role of the latter should not be underestimated. 114 Active Inuit participation and support for the Council's projects indicate strong potential for further Indigenous peoples' collaborative initiatives in the circumpolar north. Furthermore, according to some authorities, the work of the Arctic Council on the soft law approach provides Indigenous peoples with a better standing in intergovernmental cooperation and opens up more of an opportunity for international representation. 115 The Inuit are involved in the activities of intrastate, intergovernmental, interparliamentary, and supranational forms of international cooperation via the Nordic Council, the Nordic Council of Ministers, the EU, the Arctic Council, and other forums. 116 This involvement is challenged and limited by the dominance of national states' doctrines and the limited legal capacity of subnational entities in international law. Greenland's and Nunavut's participation in the institutional complex of the Arctic is not based on a legally binding regime, and instead relies upon informal mechanisms. There are no adequate international or domestic regulatory provisions legalizing the international activity of Greenland and Nunavut. However, despite fragmentation and relatively weak institutional organization in the Arctic, non-state actors such as the Inuit Circumpolar Council are able to influence and express their interests within intergovernmental settings, thus enhancing the Inuits' voice in international forums. The level to which international cooperation b. 124. Between indigenous peoples can be promoted on a non-governmental level is closely connected with the modern phenomenon of indigenous internationalism, Inuitism, or pan-Inuit collaboration, to which I now turn 117. Indigenous internationalism and the Inuit of Greenland and Nunavut. Indigenous internationalism is the cooperation of indigenous peoples with each other across or beyond national borders to share ideas, information, and inspiration, to concert moral and political influence on national governments and international bodies, and to establish better international standards for themselves and other indigenous peoples in matters of shared or universal interest. Peter Joel. Inuit cooperation across Alaska, Canada, Greenland, and Chukotka and with other indigenous peoples has developed in a variety of forms. The Inuit of Nunavut and Greenland are geographic neighbors whose homelands and culture share similar natural features and characteristics. Their desire to foster and maintain extensive cultural, personal, and social relations led them to sign 118 the Memorandum of Understanding on Cooperation in 2000. 119 Cooperation in several areas was given high priority. These areas included human resources, staff training and professional development, sustainable management of the polar bear population, mutual growth in trade via private business initiatives and deeper collaboration among business schools, councils, networking organizations, tourist councils, trade unions, and interest organizations. 120 Common to both constituencies, sustainable fisheries management in their common waters, exchange of expertise in energy conservation and waste disposal, and collaboration between Statistics Greenland and Nunavut on data exchange and related studies. 121 The cooperation between Nunavut and Greenland has been attested to by the signing of other documents of mutual interest, visits by the premiers and other government officials, conferences and workshops, and cultural, trade, and educational exchanges. 122 Transborder or multilateral Inuit cooperation, as a form of indigenous internationalism, is distinguished by Inuit participation in indigenous peoples' organizations, governmental and parliamentary organizations, and non-governmental organizations. 123 Today the Inuit Circumpolar Council provides a major international collective voice for more than 155,000 Inuit from Canada, Alaska, Greenland, and 125. The Chukotka Peninsula. Having emerged in 1976 as an outcome of the indigenous internationalism movement, it obtained official status in June 1977 at the first ICC General Assembly. 124 The ICC came into being as a formal organization 3 years later, when the 54 delegates to the Second ICC General Assembly voted unanimously to adopt its charter. 125 According to Article 3 of this document, the purposes of the conference are, a. to strengthen unity among the Inuit of the circumpolar region, b. to promote Inuit rights and interests on the international level, c. to ensure Inuit participation in political, economic, and social institutions, deem relevant, d. to promote greater self-sufficiency among the Inuit in the circumpolar region, e. to ensure the endurance and growth of Inuit culture and societies for both present and future generations, f. to promote long-term management and protection of Arctic and subarctic wildlife, environment, and biological productivity, and g. to promote wise management and use of non-renewable resources in the circumpolar region, incorporating such resources in the present and future development of Inuit economies, taking into account other Inuit interests. 126. The ICC has become a leading organization in the Arctic in promoting international collaboration among the Inuit and other indigenous peoples of the world. 127. The scope of its activities, its achievements in advancing indigenous peoples' rights and interests, and its advocacy of policies safeguarding issues of importance to the circumpolar region are impressive. 128. They cover Inuit rights on the national and international level, security, environmental, social, economic, cultural, educational, and scientific issues, communications, international development and trade, sustainable development, and human rights. 129. The ICC's strong stand on fighting climate change is breaking new ground in the environmental rights of indigenous peoples. Of particular significance in this regard is the ICC's petition to the Inter-American Commission on Human Rights against the United States for its failure to protect the environment and for violation of the human rights of people living beyond its borders, undertaken in response to human-induced climate change that threatens the survival of the Inuit and infringes on their environmental and other human rights. 130. In 1983 the ICC was granted consultative status Category 2 of a non-governmental organization within the Economic and Social Council of the United Nations. 131. Despite its limited advisory status. 126. And lack of voting rights, the ICC has obtained a solid mandate for promoting Inuit/indigenous rights within the UN. 132. For example, it contributed to the establishment in 2000 of the UN Permanent Forum on Indigenous Issues, and it took part in the development of the UN Draft Declaration on the Rights of Indigenous Peoples, which was adopted by the UN Human Rights Council in 2006. 133. The ICC's NGO status within the UN has advantages and disadvantages. 134. For now, the ICC plays an increasingly influential role in international public policy through its participation in numerous international organizations and forums. Because of its non-governmental nature, it is more effective than government bodies in lobbying national governments. Embracing the Inuit of 4 countries and based on Inuit culture, the ICC is a uniquely trans-Arctic NGO. 135. It was able to enhance a new diplomacy in the circumpolar north by being a small organization whose voice is strong globally. 136. Indigenous internationalism and the ICC's influential role prove that Inuit have a legitimate, extensive, and varied role to fulfill in international matters. 137. The work of the ICC shows that Inuit of Canada, Greenland, Alaska, and Chukotka are succeeding in their international activities and are often ahead of national governments in their vision of indigenous needs and the challenges of the Arctic Rim. The extensive international involvement of the Inuit of Greenland and Nunavut in intrastate, transnational, global, and indigenous politics is a manifestation of a new era in international relations development, and shows that these subnational entities are gradually becoming de facto subjects of international law. The evolution of Greenland's home rule system and a gradual increase in Nunavut's jurisdictional capabilities in the process of devolution of powers from Ottawa to the territory will further speed up the demand for the participation of these entities in international forums. This demand has also been prompted by the need for stronger representation of these entities in international bodies as a countermeasure against possible neglect and non-consideration by the mother states in fulfilling their international obligations. 138. These activities do not challenge the sovereignty of the former colonizers. However, they do require a new approach in national doctrines and international and domestic legal regimes regarding the legal personality and role of subnational regions in international affairs. The forms of Greenland's and Nunavut's involvement in international relations show that national jurisdiction in external affairs is transferable to subna 127. National entities to some degree. This transferability can be legally regulated to safeguard Greenland's and Nunavut's interests in those areas of international relations that do not conflict with the management of Danish and Canadian foreign affairs. Currently, Nunavut has less of an interest in active participation in international policies because it is preoccupied with building its new government. Greenland has more specific priorities in this regard. Due to the structural, financial, and legal limitations on the current institutions of Nordic and Arctic cooperation, and constraints on the development of indigenous internationalism, these areas are less realistic arenas for Greenland or Nunavut to legitimate their international policy. Thus, international activities in trade and environmental policy issues will most likely become a priority for Greenland and Nunavut. 139 Given their lack of jurisdictional power in decision-making processes and the fact that most of their participation in international forums is with only an advisory mandate, Greenland and Nunavut have a limited role to play in the institutional complex of the Arctic. Despite their active participation in Arctic collaboration, their potential for global impact is extremely small. At the same time, the impact of global issues on the development of Greenland's and Nunavut's governance systems means that their authorities need to develop strategies and legal mechanisms to deal with the external challenges they face. Bogi Eliason has argued, on the basis of empirical data, that the international and global community is open to flexible solutions to deal with non-sovereign polities, and a majority of international organizations would allow some form of full or associate membership to entities such as Greenland. 140 According to some authorities, the legal possibility for recognition of indigenous internationalism can be rooted in the external aspects of the right to self-determination that do not entail secession. The representation and participation of the Inuit of Greenland and Nunavut in activities that transcend state boundaries can be regarded as an external dimension of this right. 141 However, it can be argued that this international activity and participatory rights of the Inuit of Greenland and Nunavut in international forums constitute a part of their internal right to self-determination and evolving right to autonomy, as this jurisdiction is crucial for addressing local matters and strengthening self-government. Some of the provisions of the Authorization Act, discussed earlier in this chapter, recognize this right. 128. Greenland, Nunavut, and Defense and Security Policy. We do not wish our traditional territories to be treated as a strategic military and combat zone between Eastern and Western alliances. For thousands of years, Inuit have used and continue to use the lands, waters, and sea ice in circumpolar regions. As Aboriginal people, we are the Arctic's legitimate spokespersons. Since our northern lands and communities transcend the boundaries of the four countries, we are in a unique position to promote peace, security, and arms control objectives among states of the Arctic Rim. Mary Simon. Because of strategic military interests, Inuit lands are vulnerable to militarization, missile defense plans, and other security/defense doctrines of their respective states and outside countries. Traditionally, jurisdiction in defense and security policy is the domain of national states. Significant changes in the approaches to security, caused by the end of the Cold War, technological developments, and the emergence of politically evolving Arctic entities, call into question the absolute non-transferability of security jurisdiction to subnational territories where the legitimate interests of those units are concerned. 142 In terms of the legal scope of autonomy and the competence of the Greenlandic and Nunavut governments, the following questions emerge: is the fate of the Inuit homelands in the hands of Southern alliances and politicians, or of the northern communities and governments themselves? Should citizens of the subnational entities of Greenland and Nunavut have some legal capacity in national defense and security policies when these policies concern or affect their homelands? Should security matters become a legitimate part of the Home Rule or Nunavut jurisdictions, or can they be regulated by informal methods, such as consultation, shared advisory councils, or meetings? These questions are linked to the issue of the extent to which there should be special consideration for the northern indigenous peoples in the framework of the public governance systems. Home Rule in Greenland is developing greater competence in the area of external affairs policy, and the Nunavut system will eventually develop more extensive involvement in this area as well. Possible jurisdiction in security matters is a part of this evolution. In light of the principal elements of Greenland's and Nunavut's evolving interest in security policy, their governments should have greater opportunities for participating in the security agenda of their national states as it relates. 129. To the Arctic region. Moreover, this activity of the Nunavut and Greenland authorities should be legally regulated. The potential strategic political importance of Greenland and Nunavut entitles their authorities to greater cooperation with national agencies on security matters. There is no challenge to Canadian or Danish sovereignty caused by Nunavut's or Greenland's representation in the security decision-making process regarding their lands. In light of new international political realities, the legal understanding of autonomy of Greenland and Nunavut has to be reassessed with respect to their jurisdiction in security issues, because currently the effectiveness and viability of their governance are challenged by the insufficient powers of local authorities to act on security matters. Thus, in its findings, the Greenland Commission on Self-Governance has emphasized that security policy should become a legitimate part of Greenland's jurisdiction, that Greenlandic authorities should participate in formulating defense and security agendas that concern Greenland, and these authorities should be able to contribute a Greenlandic perspective to the international security policy debate in matters of the common security of the realm as a share of mutual responsibility for Denmark's security. 143. An important step in this direction was the 2003 joint Danish-Greenlandic Declaration on the involvement of Greenland authorities in foreign and security matters of significance to Greenland. This partnership cooperation approach was further enhanced in 2004 with the modernization of the 1951 Defense Agreement, the upgrade of the Thule Air Base, and the signing of several important declarations. However, the Authorization Act of 2005, which enabled Greenland to conclude international agreements in certain areas on behalf of the Danish Kingdom, does not apply to agreements affecting defense and security matters. Greenland's and Nunavut's interests in defense and security policy. I am not going to analyze Greenland's and Nunavut's security policies within the broad frameworks used by some scholars within the last decades. 144. Instead, I mean to concentrate on defense issues that affect the development and livelihood of the citizens of Greenland and Nunavut. I will attempt, on the basis of existing facts, to show why it is of vital importance that these regions maintain some jurisdiction in defense policies regarding their lands. In so doing, a brief overview of the military significance of these territories is appropriate. Being major parts of the Canadian North and the Arctic territory of 130. Denmark, Nunavut, and Greenland have been strategically important because the Arctic has gradually been transformed from a military vacuum prior to World War II, to a military flank in the 1950-70 period, and a military front in the 1980s. 145. Though Canadians have never been fully wedded to the primacy of a military understanding of security affairs, 146. The Canadian military has played a definitive role in establishing Canadian sovereignty over the Arctic frontier by developing northern infrastructure and by assigning military responsibility to the Canadian forces in the north. 147. Observers differ on the seriousness of attempts by the military to consult with or engage Indigenous people in this assertion of sovereignty. However, it is clear that, since the negotiation of the NLCA, Inuit provide essential information before defense activities occur. 148. Greenland and the NWT/Nunavut had to face similar challenges connected with the militarization of their regions. Besides, both entities share similar interests for involvement in security developments in the Arctic when it concerns their lands. Both Greenland and Nunavut are part of NATO member states, and Greenland and the NWT/Nunavut have been regarded through the lens of the alliance's security interests. Indeed, Denmark's main contribution to the security of NATO was through Greenland. 149. Thus, Greenland has far-reaching interests in the alliance's security policies. In the future it may seek to obtain first-hand information from NATO and the possible accreditation of the Home Rule's representative to its headquarters. 150. Modest Danish and Canadian defense abilities led to the extensive military discovery of Greenland by the United States, and provided a long-term American presence in the Canadian Arctic, causing Canada's quasi-dependence on the military potential of its southern neighbor. Greenland and, to a lesser extent, the NWT/Nunavut have become integrated into American defense plans. Although this forced marriage has been regarded as a threat to Inuit sovereignty over their lands and has posed challenges to Canadian sovereignty in the north, it also had the positive effect of mobilizing Canadian civil activity on behalf of the Inuit. 151 Generally, military activity in Greenland is alien to Inuit tradition. In the words of Greenlander Henrik Lund, then the mayor of Qeqertak, war and the means of mass destruction are historically alien to Greenlanders, who are pacifists and cannot accept attitudes leading to the eradication of life that are a possible threat to the people. 152 This position is supported by Willie Ostrang, who also emphasizes that Inuit tradition, the core value of which is civility, influences and shapes Greenlandic security policy. At the same time, Greenland and Nunavut. 131. Having experienced the consequences of the Second World War and the Cold War, should have developed some immunity against militarization. Greenland's experience shows that there can be an external military threat to the island, and thus the government of Greenland must be involved in security policies. 153 The development of Nunavut, the increasing powers of Greenlandic authorities, and both territories' growing security concerns mean that national defense policies can no longer ignore the opinions of Greenlanders or the Nunavummiut. 154 The Inuit Circumpolar Conference has elaborated a wide range of measures to advance security and peace objectives in the circumpolar north. 155 Representatives of the Inuit have developed a concept of sustainable security as an alternative to militarization. 156 These measures correspond to Greenland's and Nunavut's interests in security policies, which can be summarized as the right of Greenland's and Nunavut's authorities to be informed about all questions relating to the security policies regarding their homelands, waters, ice, and airspace. The protection of game and other limited resources from any sort of military activity, security for the population from any military actions on Inuit territories, the right of Nunavut's and Greenland's authorities to be included in the decision-making processes and formulation of national defense policies that directly or indirectly concern these Arctic entities, and the possibility of changes in legislation to enable Greenland and Nunavut to influence Denmark's and Canada's security policies, when relevant. 157 The Greenland Commission on Self-Governance suggested evaluating Greenland's security through the prism of the geographical position of the island, including military aspects and soft security policy. 158 One can argue that the efficiency of the Greenlandic and Nunavut systems of governance is not conditioned by their possible jurisdiction in defense matters. Besides, economic and environmental security issues are of vital importance for Greenland and Nunavut. 159 In the meantime, there are direct connections between defense matters and questions of a safe environment and economic viability. Further economic development of Greenland and Nunavut is linked to defense/security policies. There is an interdependence of local economies on any fluctuation in the Arctic environment, which can have an impact on employment opportunities for northern residents, game profits, hunting, fishing, climate change, and the prices on renewable and non-renewable resources. The scope of Nunavut's and Greenland's jurisdiction in matters related to the security of the territories is thus important. 132. Are there any grounds for legitimating the voices of Nunavut and Greenland in security and defense issues related to their lands? A historical perspective on the role of Inuit homelands in the defense strategies of superpowers and their national states shows that there is. The strategic importance of Greenland and Nunavut has fluctuated since the end of the Second World War, owing to the changes in the doctrines of the superpowers, technological developments, military capabilities, and competing East-West alliances. With the occupation of Denmark by the Germans in 1940, Greenland's strategic location took on international importance and acquired particular military significance to the United States. 160 Greenland's security was threatened by Germany's invasion of the Danish kingdom. Consequently, in May 1940 the Greenlandic authorities requested American protection and a U.S. consulate was opened in Gothenburg. By July 1940 the U.S. Coast Guard ship Campbell had moved to Iveagtut where some of its crew guarded the cryolite mines, a source of aluminium for the United States. After the Germans had extended their war zone to the east coast of Greenland in March 1941, President Roosevelt allocated $5 million for the construction of air bases in Greenland. 161 On April 9, 1941, the Danish government signed an agreement with the American government, allowing the latter almost unlimited rights to establish bases and military installations in Greenland. 162 This led to the establishment of 13 American Army and 4 naval bases on the island. 163 After the Second World War, the Cold War strengthened American military interests in Greenland. In 1946 the United States made an official offer to Denmark to purchase the island for US $100 million with the purpose of establishing military bases that could be used in the event of attack. 164 It is not clear whether the offer was turned down by the Danish government or simply ignored. With Danish membership in NATO in 1949, the U.S. request for long-term rights to existing military facilities in Greenland and the possibility of building new ones was satisfied. 165 This, in turn led to the signing of a new U.S. Danish defense agreement in 1951. 166 As part of the implementation of the North Atlantic Treaty, the agreement set up a joint Danish, U.S. defense of Greenland under the national flags of both countries. It provided the American armed forces, including ships and aircraft, with free access to strategic facilities on the island. 167 Greenland's long-term concerns with and negotiations towards revising the agreement of 1951 and the upgrading of the only remaining military installation in the northwest of Greenland form the crux of Greenlandic, Danish-American security policy interests today. 168. 133. Since its construction in 1951-2, the Thule Air Base has been the centerpiece of the American presence in Greenland. 169 During the Cold War, Thule's significance was increased by the installation and modernization of the early warning radar system with its large coverage capacity in the event of a nuclear attack. 170 The base has been crucial in the American missile defense program. 171 In 2000 an American delegation visited Greenland and consulted with Greenlandic authorities regarding the upgrade of the Thule radar as part of the U.S. anti-missile defense shield scheme. As Henriette Rasmussen notes, the U.S. visit, derided by One News Weekly as the American Charm Offensive, was one of only several high-level diplomatic visits to Greenland that highlighted the strategic importance of the Thule radar should the U.S. proceed with the national missile defense. 172 The importance of the Thule base to the United States is also evident in comments President George W. Bush made in his letter to the Premier of Greenland in 2001, "We will undoubtedly face a number of challenges in the years ahead. Like you, I am eager to work together on issues of mutual concern, like the base at Thule." 173 Thule's significance can further be seen in numerous overtures made by the Bush administration to the Danish government, seeking permission to upgrade the base as part of the U.S. missile defense plans. 174 In 2002 the U.S. government asked Denmark to open negotiations on the future use of the base. Greenlandic representatives met with the U.S. Secretary of State and the Danish Minister of Foreign Affairs in Washington. 175 Greenlanders suggested that they would negotiate on any further upgrade of the Thule radar facility only if the renewal of the outdated agreement of 1951 could be negotiated in full partnership with the Home Rule government. 176 In 2004 an agreement on the upgrade of the base was reached. On August 6, 2004 an agreement to modernize the 1951 Defense Agreement, a declaration on environmental cooperation in Greenland, and a declaration on economic and technical cooperation were signed in Greenland by representatives of the American, Danish, and Greenlandic authorities. 177 The Joint Committee met in Nuuk on 5–6 October 2004 to establish further cooperation and concrete results in the framework of the signed agreements. A new partnership between the United States, Greenland, and Denmark was further enhanced in the subsequent meetings of the Joint Committee in Washington and Copenhagen. 178 These instances show that Greenland is taking an active step towards greater independence in security and foreign affairs. 134. The Thule issue is extremely sensitive to Greenlanders for a number of reasons. 179 In May 1953, 27 Inuit families were relocated, or strategically banished, from the community of Uummannaq mainly to the community of Qaanaaq in order to provide additional space for the Thule Air Base. 180 This relocation was done without the consent of the local population, and the rights of Inuit were violated through appropriation of their hunting lands and the negligence of the Danish state in failing to compensate them for their economic losses. Lars Nordskov Nielsen, the former Danish ombudsman, concluded that the Danish-American Agreement of 1951 was presented to the Folketing with inadequate information. The establishment of the base in 1951 took place without reasonably informing the local population or hearing their views on the matter. After the base was built, the authorities did not evaluate its economic consequences for the local population, nor did they offer them compensation. 181 In 1996 the Inuit formed an association, Hinjatak 53, which launched a lawsuit against the Danish government. As Aktaluk Linge noted, they simply asked for their land back and to be justly compensated for the decades of lost hunting, whaling and gathering. They asked for justice for having been taken from a region that was not only rich in living resources, but one to which they were intimately linked. They had a deep understanding of the Uummannaq environment, developed over thousands of years, which included knowledge of its ocean currents, animal migration patterns, whale movements, and other environmental features required for survival. 182 On August 20, 1999 the High Court of Eastern Denmark rendered its decision. The relocation was decided upon and carried out in such a manner and under such conditions which meant a serious interference with the peoples who were moved from the settlement. The High Court finds that in the stated circumstances, the interference must be considered an unlawful violation of the peoples of Uummannaq. The loss to the Thule tribe caused by lost and diminished hunting rights in connection with the establishment of the base and the relocation of the peoples can thus fairly be fixed at 500,000 Danish kroner. 183. While the court upheld the Inuits' claim for financial compensation for the losses suffered by the Thule people, it did not allow the hunters to return to their old settlements or regain their lost territories. 184 Yet. 135. According to a Linge, the Inuit must be allowed to return to Uummannaq. Otherwise, they will perish as a people. 185 The population of Uummannaq appealed to the Supreme Court in October 1999. Furthermore, with regards to this relocation, a representation was made in November of that year by the National Confederation of Trade Unions of Greenland, Sulinermak Inyasultissersi Utkartut Katufiat, to the International Labour Organization concerning Denmark's non-observance of the Indigenous and Tribal Peoples Convention, 1989. 186 The Supreme Court of Denmark's ruling on November 28, 2003 did not acknowledge the Inuits' right to return. 187 The court found that the population in the Thule district shares the same conditions as the rest of the Greenlandic people and does not differ from it in any other relevant respects. 188 The Inuits' land claim was not recognized, as the land traditionally occupied by the Inuit people has been identified and consists of the entire territory of Greenland. 189 Furthermore, the court ruled that the Thule base had been established legally. 190 Finally, the Thule tribe's claim for compensation remained unchanged at DKK 500,000. 191 In May 2004 the members of Hinjatak 53 took their case to the European Court of Human Rights, seeking the right to return to their hunting and fishing grounds. 192 It should be noted that in February 2003 an agreement had been signed between the US, Danish, and Greenlandic governments allowing for the Inuits' right of return to the Uummannaq Peninsula. 193 However, This step was protested by several Inuit organizations because the Inuit did not participate in the negotiations for the agreement and only a small portion of the hunting land was designated for their return. 194 The Thule issue is crucial for Greenlanders because of the environmental impact of military installations on Inuit hunting. Radioactive pollution has already resulted from an incident on January 21, 1968, when an American B-52 Stratofortress carrying 4 hydrogen bombs crashed on the ice in Billa Sound near the Thule base. 195 Greenlandic and Danish workers did the cleanup after the crash without any protective equipment. They even made tea using snow contaminated from the crash. 196 Danish and American authorities agreed that between 500 g and 1.8 kilograms of plutonium, enough for a whole bomb, was missing. 197 Although official Danish policy did not allow nuclear weapons on the territory of Denmark, the Thule Air Base was used by U.S. aircraft for stationing and transporting nuclear weapons, with the informal consent of the Danish government. 198. 136. The state of Danish, American relations and the Danish manipulation of the Thule card to please U.S. military interests prompted Greenland's authorities to seek participation in security issues without the intervention of Denmark. 199 Greenlanders were concerned that in the event of war, their territory would have been destroyed in a nuclear attack. The Thule issue and U.S. strategic interests in Greenland show how vulnerable Greenland's position is and how weak the home rule system can be in challenging the superpowers' policies. Despite Greenland's strategic military importance, the adoption of an international convention on the demilitarization of Greenland could be a solution. 200 However, this would be hard to achieve because of Danish membership in NATO and American interests in upgrading Thule. The Americans put pressure on Denmark and Greenland to finalize an agreement to upgrade Thule. Greenland wanted compensation for the upgrade. The United States categorically rejected this demand, and the agreement was revised without any financial compensation. 201 Some Greenlandic authorities have admitted that they had no choice but to support the modernization of the 1951 defense agreement by allowing the radar upgrade at Thule. As Michaela Engel, then Greenland's Deputy Minister of Foreign Affairs, points out, if Greenland had opposed the Thule upgrade, then the US might have closed down the base entirely and headed off to Canada, and we would lose any interest for the Americans. 202 Like Greenland, the Canadian Arctic became a center of military activity after the Second World War. 203 In 1947 Prime Minister Mackenzie King announced Canada's cooperation with the United States on northern defense and Arctic research. 204 This meant that, for the remainder of the 1940s and throughout the 1950s, Canada's Arctic islands would witness a flurry of military and civilian activity, joint exercises, the establishment of meteorological stations, and ultimately the creation of the Distant Early Warning Line, and the North American Air Defense Command. 205 Not unlike the situation in Greenland, Canada's Arctic involvement in defense was a product of U.S. strategic concerns and the military's discovery of the North. As Kenneth Eyre concludes, the United States used the Canadian North to carry the war to the enemy. The United States, its troops, its money, its construction firms and its employees dominated the North. All of what the United States did, or caused to be done, occurred beyond the sight of ordinary Canadians. Much of what they did occurred beyond the sight of even the Canadian government. 137 meant, despite not insignificant attempts to regulate and monitor these activities. 206 These activities were similar to what Denmark had faced with the presence of the U.S. military bases in Greenland. There were also similar military initiatives, such as the construction of the Distant Early Warning Line, which stretched into northern Alaska, Canada's high Arctic, and eastern Greenland. 207 The Due Agreement, signed between the United States and Canada in 1955, in many ways paralleled the Danish, U.S. Agreement of 1951. However, the Due Agreement contained some regulations regarding the Inuit. It addressed the issues of Inuit contact with outsiders, removal of Inuit settlements, protection of hunting grounds and burial places, employment possibilities, and the disposal of waste, supplies, and materials used by the military facilities. 208 Thus, if there were a need for extra military installations, the United States would be entitled to remove Inuit settlements or burial grounds with the consent of the Department of Northern Affairs and National Resources. 209 There could even be a Canadian Thule. 210 Furthermore, some parallels with the Thule tribe's relocation in Greenland can be drawn with the Canadian Inuit relocation of 1953, when the Inuit from northern Quebec were relocated to the high eastern Arctic to assert Canadian sovereignty, which was being challenged by American military activity. 211 U.S. military presence, airfields, maps, roads, and construction played a crucial role in the opening up and development of the Canadian North for the projects of non-Northerners and had a significant impact on the economic development of Greenland. 212 However, Greenlanders continue to have a negative image of possible militarization of their lands, although many have resigned themselves to eventual cooperation with the United States. 213 Furthermore, environmental issues caused by military actions in the Arctic, contamination caused by inadequate local disposal of waste, decaying equipment with heavy metals, spilled petroleum, leaking transformer oil containing PCBs, and air pollution, put the question of cleaning up the dew line on the political and legal agenda. 214 Fortunately in Nunavut, there have not been any crashes of airplanes carrying hydrogen bombs, but the remediation of the 15 dew sites located in the territory is crucial for its residents. 215 Currently, unlike Greenland, Nunavut does not consider involvement in security issues as its priority. However, this may be a challenge for the government of Nunavut in the future. Another foreign policy issue with vital implications for the residents of 138. Both Greenland and Nunavut is the continuing dispute between Canada and Denmark over Hans Island, located halfway between Greenland and Ellesmere Island. Because of the sovereignty dispute over the island, a 1973 agreement drew the continental shelf line excluding the island. 216 The Danes declared sovereignty over the island, and the Danish flag has flown there at least in 1984, 1988, 2002, and 2004, attempting to demonstrate that Canada could not prove its sovereignty by means of effective occupation. The Canadian government disagrees with this claim and started to conduct military patrols to demonstrate its ability to enforce sovereignty. 217 Although the dispute is only about the island itself, concerns have been raised over Canada's capability to maintain sovereignty in its Arctic. There is also speculation that the Danes are being so persistent with the ownership issue because there are valuable natural resources at stake. The Danes claim that Greenlandic Inuit were using the island for centuries and that it was first discovered in 1853 by an expedition with the famous Greenlander Hans Hendrik of Fiskeneset. 218 In September 2005 Denmark and Canada agreed to develop a protocol for managing Hans Island, revealing that both countries will continue to pursue their claim and have agreed to disagree about the island's ownership. 219 Although the dispute continues, in February 2006 the Department of Indian and Northern Affairs Canada granted Mr. John Robbins a 5-year prospector's permit with an exclusive right to explore the island. 220 However, in September 2006 the Canadian government seemed to take a different approach, when the Ministry of Foreign Affairs refused a permit to conduct research activities on the island to a scientist with a license from the Nunavut government and advised the scientist to cooperate with Danish partners. 221 Some Inuit in Nunavut state that Canada can claim Hans Island on the basis of historic use by Canadian Inuit of lands on the Queen Elizabeth Islands, which include Hans Island. At the same time, Greenlanders consider Tartupaluk, their name for Hans Island, as their territory, as it was historically used by hunters from Connacht, and dispute over its sovereignty means that Greenlandic hunting grounds are at stake. 222 The dispute may be settled through the United Nations. 223 Ottawa's various statements regarding missile defense and the agreement to link the U.S. missile defense system with the North American Aerospace Defense Command has caused concerns among the Nunavummi Ut, the Nunavut Tuangavik Incorporated, and other Canadians. 224 At the time of writing, it would seem that Nunavut may not play host to U.S. missile shoot-down sites, and Canada's Arctic bases are not going to be alternatives to Thule. 225 Nonetheless, the 139 Northern premiers have asked for a say in any missile defense developments and involvement in any security or defense negotiations leading to Canada's involvement in the U.S. ballistic missile defense system. 226 However, the Premier of Nunavut, Paul Okalik, has stressed that Canada's participation in the missile defense debate is a national issue. Nunavut only wants a positive role in any projects such as the BMD that take place in or affect Nunavut. 227 Such a role would support a true partnership. 228 To this point at least, Nunavut is not asking for jurisdiction in security matters regarding missile defense, as it considers this best left to the federal government. However, the Inuit have a role to play in northern projects that require an understanding of the Arctic when it comes to such fields as engineering, climatology and environmental assessment. 229 As the Premier further noted, the Nunavut Land Claims Agreement and the Government of Nunavut serve as some guarantee that future development projects will take into account both positive and negative impacts on the Inuit. Over the last few years, the Canadian Armed Forces have conducted several operations and exercises in the high Arctic and Northwest Passage to assert Canada's sovereignty. 230 In addition to logistical problems and limited capabilities of Canadian military exercises to ward off future threats to the country's sovereignty in the region, these activities in the territory of Nunavut raised questions of the Inuit Rangers' participation and role in such undertakings. 231 According to some sources, the Inuit play an invaluable role in ranger patrols, but their participation is still insufficient. 232 The role played by the Rangers in helping the Canadian military and in maintaining Canada's sovereignty in the Arctic cannot be underestimated. Nunavut has a ranger patrol in each community. The Canadian Forces Northern Area rely on rangers. Their reports on suspicious activities throughout the Arctic supplement periodic aerial and satellite surveys. 233 In Greenland, similar to the Canadian case, the assertion of sovereignty is taking place with the assistance of Greenland's Commando Force, which also undertakes responsibility for the Sirius Patrol, Station Nord, the Air Group Vest, and the defense patrols. 234 Over the years, several young Greenlanders have voluntarily joined the GLK and the Sirius Patrol. The Commission on Self-Governance suggested expanding this practice by making Greenlandic men and women a part of the Danish defense on the island to assist in the Coast Guard, the Navy, fishery inspection ships, and the dog sleds of the Sirius Patrol. 235 As an alternative to military operations in the north, it is possible to 140. Develop what Franklin Griffiths calls the practice of civility in the Arctic. 236 Some Nunavut authorities have also emphasized that a better way for Canada to exercise its claim over the Arctic is to work with northern citizens in making their homeland a better place to live. 237 The Home Rule Act, the NLCA, and the Nunavut Act do not include defense policy issues as a subject for gradual transferal to the Greenland or Nunavut authorities. However, the liability and responsibility of these Arctic governments for sustainable development, economic prosperity, safe environment, preservation of Inuit culture, and de facto involvement in security matters, particularly by Home Rule authorities, encourage citizens of Greenland and Nunavut to insist on a share of jurisdiction in this field without threat to the national defense/security policies of Canada or Denmark. New security challenges facing the Inuit of Greenland and Nunavut. With the development of the Nunavut system of public governance, and the evolution of Home Rule in Greenland, the Inuit face new challenges related to security matters in their homelands. Where do these challenges come from? The end of the Cold War brought the Inuit greater opportunities for participation in the security policies of their national states. At the same time, it reduced the potential geopolitical importance of the circumpolar North. However, current U.S. missile defense plans and Russia's activities in the Arctic show that it is of the utmost importance for northern citizens to be informed of any future military activities in their territories and to be ready for whatever security challenges lie ahead. The scope of Greenland's and Nunavut's security interests will evolve with any new strategic military significance of the Arctic lands connected with the War on Terror. This is already the reason for a U.S. upgrade of the Thule radar system. Security interests may also be advanced because of the changing political configuration in the local governments. For example, the December 2002 elections in Greenland brought to power radically minded politicians who were pushing for Greenland's say on defense matters related to the island. Finally, Greenland's or Nunavut's involvement in security matters may increase because of global challenges to the sovereignty and viability of home rule and the Nunavut system in the areas of their jurisdiction. These challenges are real and result from possible Inuit interest in offshore waters, global warming and climate change, the increased feasibility of Trans-141 port in the Northwest Passage, and the environmental impact on traditional Inuit livelihood, dietary habits, hunting and fishing, and so on. 238 Does the possible involvement of representatives of Greenland and Nunavut in national security decision-making regarding Inuit homelands represent a serious challenge to Canadian and Danish sovereignty in the Arctic? Arguably, it does not. However, challenges connected with the assertion of Canada's and Denmark's Arctic sovereignty are relevant to Greenlanders and the Nunavummiut. Some authorities have noted that climate change in the Arctic is a serious threat to Canadian Arctic sovereignty and security. 239 Though Griffiths has argued that Canada's Arctic sovereignty is not on thinning ice, others question this position. 240 The possible melting of ice in the Northwest Passage and the consequent opening of Arctic waters to sea transportation will eventually pose a number of challenges to the Nunavut and Greenland governments. As Griffiths suggests, the policies regarding the Northwest Passage and Arctic navigation have to be reconsidered from the perspective of northern residents and their needs, including engagement of the people and government of Nunavut in the name of Arctic stewardship. 241 The opening of the Northwest Passage as a Panama Canal North, global warming, and the resultant changes will affect Inuit traditional hunting and cultural survival, and, in addition to security concerns, result in substantial economic and environmental problems for the Nunavut and Greenlandic authorities. 242 These may include illegal fishing, trapping, hunting, and navigation of the waters by foreign vessels, increased traffic of cruise ships, oil tankers, and possibly U.S. warships, air and water pollution, change in traditional diet, habits, and hunting patterns, security challenges to Inuit homelands resulting from increased military construction and activities, accommodating new economic development. Increased trade and commercial navigation in the waters between Nunavut and Greenland, an influx of newcomers to the regions, infrastructure issues, increased extraction of current or potential non-renewable/renewable resources, including exploration and mineral resource development by non-native and foreign investors, 243 Employment opportunities, and enacting legislation in conformity with these challenges. In fact, some of those challenges were clearly recognized by a number of people involved in the creation of Nunavut and gave them additional incentive to reach the Nunavut deal. 244. 142. When the Nunavut and Greenlandic governments begin to face these issues, they will need to develop a better partnership with national authorities and to have a say in security matters. The existing home rule system has had a dynamic impact on Greenland's involvement in security matters. Thus, in 2006 the Danish and Greenlandic governments agreed to develop a coherent strategy to deal with and secure their interests in the Arctic, including discussions of concerns connected with the Northwest Passage. Nunavut's authorities have also become involved in national discussions on security matters. At the same time, Inuit representatives are calling upon the federal government for development based on a long-term plan to assert sovereignty in the Arctic with strong Inuit engagement. Nunavut is seeking an equal partnership and responsibility within Canada concerning the status of Canada's Arctic waters. As a result of the devolution process, the territory is willing to assume jurisdiction over Canadian internal waters within its boundaries. According to Nunavut's premier, this process could help Canada's Arctic sovereignty claim and benefit the territory's development. 245. The Nunavut Land Claims Agreement reserves some Inuit rights in decision-making concerning the use, management, and conservation of land, water, and resources. However, it fails to provide sufficient mechanisms to deal with the above-noted challenges. Needless to say, the Inuit of Nunavut and Greenlanders need to be more involved in issues determining Canada's and Denmark's Arctic policies and security developments when Nunavut's and Greenland's interests are concerned. In Griffiths's opinion, it is important to build a stronger capacity for collective choice in the Canadian Arctic. This can be done by creating a consultative committee on the future of the Arctic archipelago. This body could establish enduring coalitions on the basis of a new partnership between the government of Nunavut and the federal government to support priorities and sustained occupancy of the high Arctic. The Inuit of Nunavut would gain greater representation in the Arctic workforce. Their familiarity with the area and sensitivity to the local conditions would ensure the development of the most effective policy. 246. According to Griffiths, the Inuit should take the lead in protecting Canada's Arctic sovereignty and no longer be confined to a historical role in the federal government's endeavour to make a sovereignty claim in law. Further, it is hypocritical to rely on Inuit when making a claim for exclusive jurisdiction but to exclude them from the exercise of that jurisdiction. 247. It is important to recognize that Inuit participation in security policies will not be a challenge to the sovereign. 143. Unity of Canada or Denmark as further partnership between the Nunavut and federal governments, and the Greenland and Danish governments, develops. Danish, Greenlandic cooperation on the Thule issue and other initiatives taken by the Danish/Greenlandic authorities regarding security matters show that, compared to Nunavut, Greenland is in a better position in this respect as a result of its direct engagement with the United States. The Inuit of Greenland and Nunavut should become the de jure spokespeople for their homelands. The Greenland and Nunavut governments should have some legal jurisdiction over security policies related to their homelands. The concept of Arctic governance is a dynamic and evolving issue whose flexible development will not be fulfilled until it provides local authorities with a proper mechanism for participating in decisions on national defense agendas concerning the circumpolar North. Greenland's and Nunavut's jurisdiction in foreign relations, including security, is becoming more transferable in practice. To ensure more responsibility and liability on the part of the Arctic governments, there should be some flexibility in the scope of their competence when it concerns indigenous peoples' interests and the specifics of northern geography. Some may argue that it is not essential that Greenland and Nunavut should carry a legal capacity in the above-mentioned matters of non-transferable jurisdiction, as there are other, more informal, options for conflict resolution and involvement in matters of security, defense, and foreign affairs. It is true that many such issues can be resolved by means of joint committees, consultations, advisory boards, or conferences. Canadian Indigenous peoples have made significant advances through informal bodies, including the renegotiation of the national constitution, which would be unthinkable in the Danish case. 248. However, Greenland's experience with working groups, seminars, and the Parliamentary Committee on Foreign and Security Policy shows that informal methods are not sufficient. Alongside informal methods, which might work well in practice in Canada, the Greenland Commission on Self-Governance has underscored the importance of changes to existing legislation that would allow Greenlanders to influence the security policy of Denmark. The international activity of Greenland and Nunavut has created a new dimension in circumpolar, transborder, and transnational cooperation, and has shifted state-dominated initiatives in external affairs and security towards the involvement of subnational governments. This Phe 144. Nomenon is partially connected with the dynamics and development of Home Rule and Nunavut public governance systems towards greater autonomy and self-determination. The changing nature of the relationships between subnational entities like Greenland and Nunavut vis-a-vis their mother states, and their increasing role in the processes of Arctic cooperation and global challenges, demonstrate the importance of their voice and raise the possibility of expanding their competence in areas of non-transferable jurisdiction. Conclusion. The concept of autonomy is complex. It is surrounded by ambiguity in law and political science scholarship. Although it is housed within the concept of self-determination, one can best understand its content and scope in the context of a particular situation. An empirical analysis of Greenland's and Nunavut's governance systems shows that autonomy is not a static phenomenon. It is a dynamic concept constantly developing and evolving towards more recognition at the de jure level. On the one hand, within the framework of territorial public governance and home rule structures, the Inuit of Nunavut and Greenland are able to secure their interests without de jure indigenous self-governance. Existing forms of public government are effective in meeting indigenous peoples' needs without the enactment of special forms of indigenous autonomy. As in Greenland, the Inuit majority in Nunavut transforms formal territorial autonomy into de facto indigenous governance. This shows that territorial autonomy alone can protect the rights of indigenous peoples and mitigates the need for a special type of Inuit self-governance. On the other hand, these subnational jurisdictions are constitutional hybrids with some competence comparable to the subjects of federations. The fact that Nunavut is embedded in a federal system, whereas Greenland is a part of the unitary structure of the Kingdom of Denmark that is shifting towards some federative elements, does not make a significant difference for the implementation of autonomy. Despite the profound differences between Danish and Canadian legal and political settings, both Greenland and Nunavut evolved alongside political territorial autonomy in the form of public governance, but in practice they aim to protect the Inuit needs and aspirations for greater self-governance and regaining control of their lands and lives. 146. In the framework of internal self-determination, the concept of autonomy is consistent with Greenlanders and Nunavummiut effective political participation in the institutions of democratic governance, is inclusive of cultural, linguistic, and ethnic differences, and is oriented towards achieving economic sustainability and taking greater responsibility, and assuming liability, for managing their own affairs. At the same time, the human development factor is of the utmost importance for understanding governance systems in Greenland and Nunavut. Autonomy starts with the will and ability of residents of these regions to be a part of existing and emerging institutions in their homelands and to make them more amenable to citizens' concerns and needs. Accordingly, I have focused on the bottom-up approach, revealing how empirical or de facto comprehension of the right to autonomy is evolving towards greater recognition on a de jure level and is advancing our legal understanding of autonomy. This development is already happening in regard to areas of non-transferable jurisdiction that can be partially transferred to subnational entities in the process of devolution of powers from the center. Regardless of the political importance of the Greenland and Nunavut cases, their models of governance may not be applicable to all Arctic areas where indigenous peoples are the majority. Internal self-government may not be a panacea or the best solution for realizing Arctic and other indigenous peoples' right to self-determination. Forms of autonomy in the North vary and should be understood in the context of each particular situation. The Arctic Promise means that there is room for a unique vision of governance in the North, inclusive of indigenous knowledge and values, Southern experience, and flexible legal imagination on the scope of autonomy. The lack of a precise legal definition and unanimous understanding of the concept of autonomy makes it more attractive to those who are involved in the process of governance building and more flexible in response to their aspirations to self-governance. Yet, the experiences of the Inuit of Greenland and Nunavut in practice show that there are many challenges in terms of culture clashes, conceptual differences, and bridging the gap between the Inuit and non-Inuit perceptions on autonomy, especially within the legal framework of existing constitutional arrangements. For example, despite being a modern treaty, the Nunavut Land Claims Agreement reveals problems with authenticity and comprehension in Inuttitude, difficulty of its implementation by various stakeholders as a result of the lack of a unanimous conclusion. 147. Interpretation by different government of Nunavut departments, and vague formulas. Furthermore, the NLCA has failed to meet the expectations of the Inuit in regard to guarantees for women's rights or consideration of socio-economic rights. Based on a 1970s vision of indigenous rights and territorial development, it raises concerns regarding Inuit ownership rights and is not adequate in meeting contemporary challenges caused by globalization and the necessity of sustainable economic development. The actual development of Home Rule transcended the scope of the Greenland Home Rule Act. Indeed, Greenland's system functions in such a way as to advance the significant changes that have occurred in the region's relationships with Denmark, the Arctic, and the global community. The growing desire for an extended autonomy is justified by changes in national and international realities, the demand for global visibility, greater independence in taking care of its own affairs, and, most importantly, by a self-sufficient economy that could substantially reduce financial dependency on transfers from Copenhagen. In the Canadian context of interpretation of the right of Indigenous peoples to autonomy, it can be argued that because the Inuit were self-governing prior to colonization, their right to autonomy, being inherent, continues to exist notwithstanding any governance structures created by Canada afterwards. If the Inuit of Nunavut had so chosen, they could have created a system of indigenous autonomy with all the necessary components based on their traditional beliefs and values. Prior to colonization, the informal character of Inuit social organization was based on the extended family structure. The Inuit of Greenland and Nunavut were transformed by dominant states from a people without a formal government to a people with one. Despite this, the Inuit in both regions were able to move rapidly from their traditional forms of self-regulation to institutions and practices that are not indigenous. They have undergone a quick transformation and adaptation to the alien governmental systems of their former colonizers and attempted to introduce some elements of their traditional societal practices and customs into the modern administration of governance. This is of particular significance in Nunavut, where the incorporating of Inuit Kajimajatukanjit into governance machinery and the lives of Nunavummiut is a focal point of the government of Nunavut's policy and priority set out in the government's plan Pinazuak Tavut, our commitment to building Nunavut's future. Despite considerable efforts to make IQ the living policy in Nunavut, the introduction of 148 IQ principles in government is a work in progress, marked by ambiguity and by financial, epistemological, and other challenges. At the same time, Inuit values and traditional livelihood are changing over time and interconnect with the perceptions of the dominant and other societies. Therefore, adapting Inuit customs to legislation or institutions of governance will always be a challenge. In both regions we witness the unique relationship between national and Greenland and Nunavut authorities. However, despite remarkable achievements towards greater political and legal autonomy of these subnational entities, Greenland and Nunavut continue to display voluntary colonialism because of paternalistic practices and policies of Danish and Canadian towards the Inuit, some features of colonial legacy in Greenland's and Nunavut's legal arrangements, and Inuit dependency on the dominant societies. The Inuit need time to regain control of their lands and their lives. Despite some limitations, existing legal arrangements provide a starting point for the expression of the Inuit right to internal self-determination, and show that constitutional entrenchment of autonomy, though important, is not required for its effectiveness. Modern systems of governance are evolving towards greater Inuit involvement in the management of their affairs. The success of autonomy will depend on its progress in practice. From a legal standpoint, the Greenland Home Rule Act, the NLCA, and the Nunavut Act do not recognize Inuit self-governance per se. Yet, because of the dynamic development of Nunavut, there might be a shift towards more political autonomy of the territory, just as Greenland moves towards an extended self-governance. This autonomy does not stem only from the fact that Inuit are a majority of the population in both regions. The effectiveness of Inuit self-governance and its institutions stems largely from thoughtful and active Inuit participation in politics. Internal developments and political institutions of autonomy in Greenland and Nunavut are viewed not just through the prism of the normative dimensions of the Greenland Home Rule Act, the NLCA, and the Nunavut Act, but also through the policies of Greenlandic parties and the Nunavut Inuit organizations that are the driving force behind the normative and functional validity of autonomy. The effectiveness of Nunavut's public governance and Greenland's home rule substantially depends on the breadth of powers delegated to the governing authorities. The legal framework of Home Rule and the government of Nunavut's jurisdiction are pulled in two directions, by Inuit aspirations and their expectations for effective governance, and by Conclusion 149. The realities and pragmatic expectations for future economic sustainability in the severely isolated North. Currently, neither Greenland nor Nunavut can function without substantial financial assistance from the central authorities. They do not have an economic basis for self-sufficiency. That causes the problem of reconciling the idea of autonomy, which means self-reliance, with the necessity of assuring significant funding from the national governments. It further challenges the viability of self-governance in the Arctic, and makes the concept of autonomy rather artificial. In this respect, the capacity of subnational entities like Greenland and Nunavut to take over some additional responsibilities is questionable. The legal authority of Nunavut and Greenland is limited by Canadian and Danish legal paradigms that are not always able to meet the specific interests of the Inuit population. In practice, the Nunavummiut and Greenlanders can shape their own policies but can make changes towards expanding their jurisdictions to only a minor extent. Their ability to shape their own policies is driven by the development of political consciousness and public initiative among residents of Greenland and Nunavut and by economic and socio-cultural factors. Despite jurisdictional limitations of Greenlandic Home Rule and the government of Nunavut, the evolution of these governance systems suggests increased local involvement and a greater responsibility for matters not envisaged by their jurisdictional frames. Therefore, the study of Greenland's and Nunavut's competence reveals the tendency of regional authorities to obtain more responsibilities in areas not covered by their current legal arrangements, as the set of delegated powers does not address all the challenges faced by the Inuit. The Inuit of Greenland and Nunavut have used the methods and language of their former colonizers to overcome their subjugation. They have demonstrated how they value their own cultures by their aspirations for self-determination and autonomy. Arctic indigenous peoples have an image of governance and its institutions that differs from that of their former colonizers. There is a need for more flexibility and a rethinking of the boundaries of Danish European and Anglo-Canadian legal imaginations that would adapt to Inuit realities and better serve their aspirations self-governance. At the same time, in the Canadian context, federal principles and practice facilitate the Inuits coping with the white man's outlook and ease transitions. 3. There are important differences between Greenlanders and the Inuit of Nunavut in their relationship with their respective parent states. The 150. Process of nation building in Greenland has resulted in rapid changes in home rule and its political settings. The current governance structure does not fully meet the needs of Greenlanders in responding to the challenges of modernization, globalization, and a gradual transformation of home rule towards an extended version of self-governance. Home rule has evolved since its introduction in 1979, and Greenlanders are now taking a new look at their own future. It remains to be seen what kind of partnership will develop within a new agreement on self-governance. The Commission on Self-Governance examined several models that are relevant for defining a new relationship between Greenland and Denmark. But the future of Greenland depends on choices that can be made by Greenlanders who have publicly acknowledged their long-term goal of independence, or at least a new partnership agreement with Denmark on Greenland's self-governance, including possible autonomous jurisdiction in non-transferable fields such as foreign affairs, the justice system, and defense/security policy. Nunavut is on a different political trajectory than Greenland. Even though it was established with active Inuit involvement and accommodated Inuit interests to a significant extent, it is unclear yet whether Nunavut is going to develop towards any form of self-governance for all residents of Nunavut or towards Inuit autonomy, or if it will eventually become a province of Canada. For Greenlanders, the Greenland Home Rule Act is a political compromise with the Danes. Similarly, the Inuit of Nunavut had to compromise with the federal government and the Canadian public in political and practical terms. The NLCA was separated from the quest for self-government, and the concept of public territorial governance was accepted by the Inuit as more palatable to the Canadian system. The creation of a new territory and the transfer of substantial responsibility to the public government postponed ideas for Inuit self-government. The Inuit of Nunavut show a strong affiliation to their parent country and pride in being Canadian. They look at the Nunavut arrangement, which is supported by the NLCA, as a victory for the Inuit and an opportunity to realize major developments. The right to a separate Inuit self-government agreement is reserved for the future in case of changed demographic or political situations unfavorable to the Inuit. The citizens of Nunavut consider their future constitutional development as occurring within Canada, aided by the increasing influence of Inuit traditional values and knowledge in the institutions of public government. Conclusion 151. The constitutional recognition in Canada of Aboriginal and treaty rights distinguishes the Inuit of Nunavut's claims and the road to self-determination. Thus, in Nunavut, despite the existence of the system of public government for all Nunavummiut, special consideration is given to the values and rights of the Inuit beneficiaries of the NLCA, who represent a majority of the territory's population. Greenlanders have never considered Aboriginal rights as a focal point in their struggle for autonomy. Furthermore, in Greenland demands for rights put in ethnic terms have been interpreted into rights for the territorially defined population of the island. At the same time, in both jurisdictions, the Inuit are facing the challenges of adjusting to the non-Inuit values of other societies in the administrative institutions of government. The Inuits' recognition of their participatory rights in the structures of Western democracy leaves very little room for any indigenous autonomy. However, unlike Greenland, Nunavut has more possibilities for participating in the institutions of the Canadian federal system. That involvement would expand the territory's political autonomy in practice. Moreover, the existence in Nunavut of the Nunavut Tuangavik Incorporated, a powerful land claims organization with 100% Inuit membership, creates a sort of second level of corporate governance along with Nunavut's public government. This phenomenon does not exist in Greenland. The fields of non-transferable jurisdiction will gradually obtain more importance in Nunavut with Ottawa's devolution of powers and with the region's increasing participation in intergovernmental and international relations. Due to unique northern geography and substantial involvement of Greenlanders and Nunavummiut in their government's affairs, the legal understanding of the concept of autonomy is gradually changing, with consideration for the capability of northern residents to take over responsibility in some areas of traditionally non-transferable jurisdiction. No matter what constitutional path Greenland and Nunavut may follow in the future, there is no need for a special model of indigenous autonomy in the north. Yet the legal scope of autonomy in the Arctic has to be reconsidered. Although there are always informal methods of conflict resolution and consultation, the role of law is still valuable when it comes to defining the boundaries of Greenland's and Nunavut's jurisdiction in international, defense/security, and judicial matters. I have attempted to show in this book that even the confusing legal concept of autonomy can be rendered more determinate by means of comparative research and the application of original information from 152. Those who actually try to build it in practice. This journey has revealed that the current legal arrangements of Greenland and Nunavut carry some potential for being influenced by indigenous values and perspectives on governance. Given Inuit majorities and increasing indigenous involvement in the administration of the institutions of Nunavut's public governance and Greenland's home rule, these Arctic jurisdictions constitute unique legal arrangements. Being by their legal nature models of territorial political autonomy, Greenland and Nunavut are evolving towards greater autonomy within Denmark and Canada. The case of Greenland is of particular significance for Nunavut. It tells us how it is possible, by means of diplomacy, increasingly to take over some elements of foreign policy and become a genuine actor in international affairs to promote local interests. It is remarkable how, despite the isolation, harsh Arctic environment, and economic dependency on external sources, Greenland has substantial promise for a great and self-sustainable future. Since 1979 its home rule system has developed into a highly democratic form of governance with a growing need for extended self-governance based on mutual respect and equal partnership with Denmark. Importantly, Greenlanders keep their options open as regards the exercise of their right to self-determination. Nunavut may not be following the path of Greenland within the next few decades. Nunavut's future depends on economic self-sufficiency, environmental and societal sustainability, a better partnership with the federal government, and to some extent on further developing Arctic and global collaboration. As in Greenland, the participation of every citizen in making Nunavut a success story is crucial. The first 8 years of the existence of Nunavut have shown that its system of public governance is constantly evolving. There were some important initiatives and developments in the dialogue with Ottawa, which show that the future of Nunavut rests in stronger partnership and mutual cooperation with the federal government and other parts of Canada. For thus, the de facto evolution and development of Greenland's and Nunavut's governance reveal that there is room for flexibility in the legal image of governance in the North to keep the Arctic promise alive.